Yes.
May it please your lordships, my lords, requesting for 2:30 today. The urgency is this, my lords, that I have been in possession of the property since 1980, my dwelling unit. I am a third party, my lords, not the judgment debtor.
When is the petition filed?
My lords, today morning, order was passed yesterday, my lords. With the help of police, they have asked to dispossess me. There is a possession warrant. So, my lords, there is a
They'll
threat.
do it today itself.
My lords, because the ensuing weekend is coming, my lords. That's the only worry. Requesting for today, 2:30, my lords.
How can the court pass an order today?
My lords,
Ask it to do it tomorrow itself.
my lords, order was passed yesterday, my lords.
That's what
With
yesterday.
immediate effect, my lords, because they have already moved the police, my lords, with police help. So this is the, my lords, I moved an application on order 21, rule 97. Notice is issued on that without considering that application, my lords. They allow the, grateful.
Yes.
If your lordship pleases, there's just mention a fresh matter unlisted, my lordship. There is an order from the executing court for a break open the locks of running makeup studio, my lordship.
It will come. If it is not coming, tell the court officer.
We have complied with the.
Please, it will come. Yes, just find out.
My lords, one
Yes.
matter for admission of CRP, my lord. It
Which
was,
year?
my lords, it's an ejectment suit that has been passed. I filed an application for the return of the
When
plea.
was, when was?
Last week it was listed before my lords, but by the, I was held up in some other court. It has been adjourned in the month of August, my lord. Matter is listed on Monday, my lord. I request my lords to have it on Monday.
That is also the problem of the court, that you.
I'm
not
sorry, my
applying.
lord. I'm sorry.
Every day this
My
kind
lord,
of mentions.
I'm extremely
I'm,
apologetic.
And from today, I'm making it very clear. I will, matter once adjourned, as there was no representation, I will never prepone those matters.
So extremely,
Why the court has no work? How many matters are there in the list?
extremely, I apologize, my lords. Monday, my lord. There are,
Take it up in the second list. If it reaches, we'll see.
My lords, I'm for the respondent, my lords. Petitioner has come before this honorable court, my lords, without my lords telling that there is arbitration clause and obtained a stay, my lords. I have invested, my lords, more than 35 crores, my lords.
When was the stay granted?
My lords, in the month of March, my lords, but I have received notice, my lords, the previous week. Matter had come up, my lords, before this honorable court. This honorable court, my lords, has posted it in August, my lords. But approximately, my lords, my construction is stopped, my lords. I can't
Were
sell
you
the
there?
property.
Were you there when the?
I was
matter
there in the court hall, my lords.
Then
It
in your
was-
presence, it must have been done.
Yes, my lords. It was in the second
Then-
list, my lords. My lords granted August
A court officer is there. That's what I was telling everyone.
2:30, my lords, today, my lords.
No. I can't take up the matters at 2:30. What are adjourned to August? Yes, call the list.
This page wise adjournment, list number 1, page 1, cell number 2 to 5, page 2, cell number 6 to 18, page number 3, cell number 19 to 31.
Serial number 19, my lord. Pray for a week's time.
Hmm?
Serial number 19.
Disconnect wherever disturbance is coming. Yes.
Page number 4,
Serial number 31, my lord.
to 35.
I appear for the petitioner, madam. Your lordship may have it in the next week, madam.
Yes, this also in the month of September.
Serial number 35, my lord. Kindly press 1 week time for complaints. 35.
Office of petition shall be complied with within 2 days, or else the writ petition shall stand dismissed without further reference to the court.
Till
Yes.
page number 5, cell number 36 to 40, page number 7, 41 to 45, page 7, 46 to 51, page number 8, 52 to 55, page number 9, 56 to 58, page number 10, cell number 59 to 62, page number 11, 63 to 67.
Serial number 65, my lord. My lords, the respondents are going to seize the property, my lord. There is a utter urgency, my lord. We engage the senior counsel, my lord. Kindly at 2:30 it may be taken.
When it reaches, will reach. Yes.
Page number 13, page number 12, cell number 68 to 71, list number 2, page 1, cell number 1, page 2, cell number 2, 3, page 3, cell number 4 to 8.
Serial number 7. I appear for respondents number 1 and 2. We have also spoken to the petitioner counsel who said he has no objections to the matter being adjourned.
Matter in the month of September.
Lord, I appear for the petitioner, Lord. There is some urgency. In the trial court, Lord, the trial is proceeding. It's an application for rejection on the ground, my lord, that the suit is barred
Once
by
it is out of the
limitation.
list, I can't help it.
I request for a date, my lord.
There's this matter on August 3rd.
Obliged.
Yes.
Page number 4,
Serial number 15.
to 14. Page number 5, serial number 15 to 18.
Serial number 15, my lordship. 2 weeks time may be granted, my lordship.
Why, who moved the memo?
My lordship,
Who moved the memo?
the respondent, my
Then
lordship.
why are you asking for time?
My lordship, there is an urgency, my lord. The respondent, the petitioner is admitted in the hospital in the Chennai, my lordship. He's undergoing treatment, my lordship. For that, I need a discussion, I need an instruction from him, my lordship. That's why 2 weeks time may be granted, my lordship.
There is a stay.
Yes, my lordship, there is a stay in the sense. No stay, my lordship.
This is matter in the month of August, September. At the request of non-counsel, the respondent. Petitioner, yes.
Page number 6, serial number 19 to 26. Page number 7, 27 to 31. Page number 8, 32 to 35.
My lords, serial number 35, my lords, I appear for the
35 to
respondent.
39.
For the
The
petitioner, my
petitioner is
lord.
also present, my lords. There is some inconvenience today as a senior counselor to travel due to some emergency, my lords. Any date may be given, my lords.
My lord, any date in first week of July, my lord.
That is what I'm indicating. Once it is out of list, I cannot help it.
My lord,
Whenever it comes, it comes. Because there are so many people waiting for their matters to reach. So one matter that comes in the list will not come again.
I'm sorry.
We'll see in the month of July. We'll see. Don't give the
date may fix, my lord, because we also led by the senior counsel, my lord, and last hearing, we had started, my lord.
This is matter in the month of July. Yes.
Page
For the
1,
list.
for orders matter, serial number 1.
And delete from this 230 caption.
Serial number 1, Kavita D.
Lord, appearing for the respondent. Matter has been settled, my lord.
Memo is fine. Memo is filed stating that the matter is settled between the parties accordingly. Memo is taken on record and dismissed as withdrawn.
Serial number 2, preliminary hearing, Venkatesh, HN.
I have sought for a speedy disposal because
Which year is the suit?
2016 suit, my lord.
Which court?
OS 48 of 2016 on the file of senior civil judge and JMSC Anekal. And the matter, the evidence is yet to commence by the plaintiff. And the hearing dates are given 3 months, 4 months once, my lord. This is the problem of the defendant.
The present petition is filed. Seeking a mandamus directing the Court of Principal Senior Civil Judge and JMFJ Anekal to dispose of OS number 48 of 2016 by fixing an outer limit for proper disposal in accordance with law. Then counsel for the petition submitted the suit of 2016. And what is the stage?
Stage is evidence yet to, plaintiff is yet to commence his evidence.
Plaintiff evidence is yet to commence and the court is giving long dates and there may be direction to dispose of the matter in a time-bound manner, considering the fact that this is a 2016 suit and even till now the evidence is not commenced. The trial court is directed to dispose of the matter expeditiously without granting unnecessary adjournments to the parties.
Time timeline make
Time of evidence, what
at
is
least
outer
at
limit?
least 1.5 year or 2 years may be fixed.
Court will.
Because the one of the plaintiff,
When there is an order of expeditious, court will show some, because we can't fix the time.
because if the time is not fixed, the court will.
We don't even know what is the pendency in that court. If the matters which are prior to 2016 are pending, it is not appropriate on the
But
part
in
of
this,
this court
in
to-
this specific suit, one of the developer as well as one of the plaintiff is colluded and it's a suit for partition and declaration, my lord.
I already said without giving unnecessary adjournments, yes.
But at least outer timeline of 2 years may kindly be
Within
fixed.
2 years.
Very well.
Serial number 3, C. Ananta Kumar.
Yes, appear for petitioner. I am the impleading applicant before the trial court. My application came to be rejected.
What is the suit for?
Suit for partition, my lords, between my husband's sister and my husband.
Hmm.
In that suit, my self-acquired property was also incorporated without arraying me as a party. Now, based on that,
Property stands in your name.
it stands in my name. It is my self-acquired property.
Hmm.
Now, based on that, a decree has been passed And on that, the FDP proceedings was there. The husband, the impleading applicant's husband had suffered from high blood pressure and he has lost his memory as of now. So he is not contesting the suit. Now, when the court commissioner has approached the property,
While he was contesting the suit, what happened? Like the relation between the petitioner and the husband is good or not?
it is good. She is taking care of her.
Then why you have not impleaded yourself that time?
No, it was not aware. He was not at all aware, my lords. Immediately after filing the suit, the husband was hospitalized. So thereafter, he is not contesting the suit. He did not contest the suit, my lords. Subsequently, suit came to be decreed.
He didn't file the written statement.
No, my lords. No, he didn't file it.
Come
So
to
it,
the order. Come to the.
it is in page number 69, my lords. I filed an application for impleadment, my lords, in the year 2022. On the basis of that, certain objections were filed by the petitioners.
Let's see the order.
In page number 69, my lords. Here, what has happened is, my lords, in between that, the counsel whom I had engaged has, they have made a pleadings that I have given an NOC. He has given an NOC and a fresh advocate has appeared.
Is it the counsel for the obstructor?
Yes, my lords. Learned counsel for the obstructor in IA number 1 of 22 has filed a memo with legal notice, postal receipt as well as track consignment issued by the postal department. As per the said notice, duly has been served on obstructor on 27/3/25. Called out in open court, obstructor Preeti Vahale is absent. Learned counsel for obstructor fairly submitted that after filing the application in spite of his effort, the obstructor is not ready to prosecute her application. It clearly shows that obstructor is not interested to proceed with the application filed by her. Moreover, as submitted, the obstructor is none other than the wife of fourth respondent who was fourth defendant in OS number 26010 of the 13. Thus, at the outset, it is clear that she is claiming through JDR. I am not claiming through JDR, my lords. I have an independent right. Court says she is claiming through JDR and there is no independent right as asserted. My lords, may I kindly peruse the sale date which I have produced at Annexure E.
Let's complete reading this.
Yes, my lords. When the obstructor is not interested to prosecute the application, though it is filed way back in the year 8/3/2022, it appears that real intention is just to protect the proceedings and to harass the other party without being there any bona fide intention. Since already sufficient chances are given and the obstructor not ready to proceed.
Precisely, this is the reason why your application is dismissed.
No, my lords, I didn't engage a new counsel. There is another issue here, my
You have
lords.
filed an application in 2022. Why have you not pursued it till 2025?
The counsel whom I had engaged says that he has given an NOC and a fresh Vakalat has been filed in my name. That has not been done by me, my lords.
Where did you say? Whatever you are submitting.
No, this absolutely it is not well within the knowledge of the learner obstructor, my lords. That is the issue.
Please read from this, whatever you are submitting. That no objection was given. Vakalat is filed. Where is it?
No, my lord, that I have stated in my writ petition, because till then I was not aware of it, my lords. It was only when the court commissioner approached, only then I came to know that these things have happened. After obtaining the order sheet only, I came to know, my lords.
You have to tell from the, what is it? You read it, the order is so clear. You are submitting something which is not in the order.
No, my lords, it may kindly be perused. 64, in page number 64, my lords.
Counsel for obstructor has filed a memo with legal notice, postal receipt as well as track consignment issued by the postal department.
64, my lords, in page number 64.
As per that, the said notice has been duly served on the obstructor on 27/3/2025. This matter has come up before the court.
On 29th.
29/3, yes.
29/3. My lords, may kindly peruse in page number 64, my lords. Order sheet.
Said, after filing this application in support of his effort, the obstructor is not ready to come and prosecute her application.
My lords, in between that, there are several dates which are posted for orders only, my lords.
Why should the court wait for your IA to be decided? FDP, in the FDP proceedings, when there are no bona fides on your part. And you just file the application and keep quiet. And when is this order passed? This order is passed on 29th.
3/25, my lords.
When have you come to this court?
That is only after the court commissioner has approached and came for the valuation only, we came to know about such an order being passed against us.
No, when you have received the notices from the advocate, what did you do from?
I didn't receive any notice, my lords. The issue is that the earlier counsel has not issued any notice to me. I didn't engage this counsel, my lords.
For the record?
My lords?
Shall I call for the trial?
Yes, my lords,
Yes.
definitely, my lords.
The registry is directed to call for the record with regard to particularly with regard to the proceedings dated 29/3/2025.
Including the Vakalats that were filed, my lords. The entire
And
case
also the
records.
Vakalas that are
Yes, my
filed.
lords. In the meantime, the FDP,
But no, I will not say anything. I'm not convinced with this. Yes. let's
any
just
date may
matter-
be fixed, my lords.
Matter on 8th of July.
Much obliged.
Cell number 4, Sridhar NG, for petitioner.
I am for the petition in this case. I have invoked the supervisory jurisdiction of this honorable court, seeking for the quashment of the entire proceedings in miscellaneous case that has been instituted before the trial court for want of jurisdiction under two statutes, my lord. One under the Civil Procedure Code, Order 23, Rule 3A, and another one under Section 21 of the Legal Services Authority Act, both being plea of law, my lord.
Why the court cannot consider this?
The court cannot consider because, my lord, when under 23 Rule 3 of CPC, the suit per se is barred, expressly barred, that cannot be circumvented to entertain a miscellaneous proceedings under the same provision. That is one, man. And
Grounds you're raising before the court. Can't you raise this before the trial court?
I had,
The
my
very
lord,
court.
I had.
There is the order.
I have not challenged any particular order. I have challenged the entire proceedings, my lord.
Correct. You
And
can
now
tell-
the-
No, you can tell the court that you have no jurisdiction to hear all this. And you can invite an order from the court. Why should you come here?
My lord, when being argued on this plea of law, my lord, on IA number 1 and 2 that was filed by the petitioner, the honorable court has noted down this, and I have also reflected this in my statement of objections to the main petition.
If you have filed an IA, we'll ask the court to decide it. Why should we do this?
My lord, it's a supervisory jurisdiction. Therefore, my lord, I invoked.
The jurisdiction, every order and every proceeding, High Court will not interfere. Where is that IA that you filed by you?
I have not filed any IA, my lord. I have not filed any IA. The IA was filed by the petitioner, for which I filed statement of objections.
Objections, and if if you say that the court has no jurisdiction to do it, with all these grounds, you are at liberty to go before the court. Please come. The
My
President.
lord, may I persuade your lordships for this reason? It has become a trend before the registry in the trial courts, my lord, that miscellaneous petitions assailing the compromise decrees and the decrees before Lok Adalat are being entertained under 23 Rule 3 of CPC, my lord, which need to be quite suppressed by exercising supervisory jurisdiction. That has been the trend now, my lord.
The already.
Matter will have been put to quietus.
Already courts are burdened, High Court is burdened with so many matters. So let's not usurp the jurisdiction of the trial court and discuss.
Under 23 Rule 3, when per se the suit is barred.
Presented petition is filed. Seeking the following prayer.
My lord, just one more point, my lord, apart from CPC. Legal Services Authority, Section 21, my lord, it is settled that the parties cannot approach the same court, even alleging fraud. My lord, it is settled that a writ petition has to be filed and the honorable court. Even that is.
That's why you tell the court will understand. I think what this court can understand, trial court can also understand.
But they did not.
The petition is filed, seeing the following prayers. Then counsel the petition submits that. Against an award passed by the Legal Services Authority, the miscellaneous petition is filed, which is not maintainable. And in the light of the settled law, a writ petition has to be filed. Without considering all these aspects, the court has entertained the miscellaneous petition. Court has numbered the petition and is entertaining the same. Hence, he has come before the court, invoking the jurisdiction of this court under Article 226 of the Constitution of India. According to the petitioner, the miscellaneous petition is not maintainable. In that regard, he should have filed an IA and should have sought for an order on the said IA. And if the petition is aggrieved, he can as well come to this court. Every application that is entertained by the court, this court cannot invoke the jurisdiction under 227, and we cannot set right every order without even before the orders are passed or even before any relief is sought before the trial court. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to raise raise all these grounds before the trial court, and the trial court shall consider the same in accordance with law.
Obliged.
Cell number 5.
So no notice is issued to the parties because no orders are passed. Address to the interest of the.
Appearing for the petitioner, Your Lordship.
5, Dhananjay.
Your Lordship, we have approached this court seeking for the speedy disposal of the FTP proceedings, Your Lordship. Your Lordship, the suit is
Proceedings
of,
of which year?
the suit is of 2011, Your Lordship, which has been renumbered as OS number 123 of.
What is the present stage?
Your Lordship, it is hearing on application IA filed by the defendants, Your Lordship, wherein they have been continuously trying to
Petition is
file.
filed. Seeking a mandamus, directing the trial court that the senior civil judge and JMFC Mudbidri to expeditiously dispose FDP number 6 of 2025. But FTP proceedings are initiated in 25.
Please, Your Lordship. Your Lordship, the defendants are filing impleading applications,
That
Your
is
Lordship.
true, but the court has to consider FDP proceedings just like that will not conclude. I was under the impression the suit you are asking.
I know, Your Lordship, FTP proceedings, Your
But
Lordship.
recently it's instituted.
Your Lordship, they have been trying to delay the proceedings by filing numerous
When was it filed?
applications.
Please tell the court. Look at, let's see FDP when the application is filed. We can't direct the court. The court has also has several other matters apart from your case.
Your Lordship, on.
I thought it is 2011 matter that is pending.
No, Your Lordship. 2025, the FTP proceedings was initiated.
The FDP proceedings were initiated on, they were initiated on, in the month of March.
15/3.
In the month of March.
March, yes, Your Lordship. Your Lordship,
We can't pass the direction. The present so-and-so FDP itself is of the year 2024 and this court cannot direct.
Your Lordship may keep the petition pending, Your Lordship. Your Lordship, they have been trying to delay the proceedings by filing numerous applications.
What should be kept pending?
Your Lordship, may I submit, Your Lordship? Your Lordship, the defendant number 1, who was party in the OS suit, he was aware that there are the purchasers for the scheduled property, Your Lordship. However, they have not brought the same before the
Court do not find any reasons to issue a mandamus to the court as this is a FDP of 2025 accordingly dismissed. Next.
Cell number 6. Second BS.
Lords, the complaints, my lord, is that 3 IAs, my lords, have been challenged in a single writ petition. Though, my lords, court fee has been paid, my lords, for all the 3 IAs.
What are those IAs?
My lords, IA, my lords, one is of to condone the delay, set aside abatement, my lords, and one more is, my lords, to bring LRs, my lords, 3 applications. My lords, the facts are this. My lords, in the 1996, my lords, original suit is filed for partition. 99, my lords, suit gets dismissed. I file appeal, my lords. Please, my lords. Lords, annexure A, my lords, is the order under challenge.
It is submitted that it's a common order passed on I number 4 to 6. Hence I filed the single writ petition accordingly. Office of counsel submission with regard to the office objections.
Lords, the facts are this. Lords, 1996, a suit for partition is filed.
Where is the order? Come to
Lords,
the
at
order.
annexure A, my lords, 2 minutes, my lords, if my lords can give. 1996, suit is filed. Suit gets dismissed in the year 1999. Thereafter, my lords, regular appeal is filed in the year 2000. It gets decreed, my lords, subject to some conditions in the year 2001. Lords, these conditions are that, my lords, there is one suit scheduled property which is stated in the written statement. That also has to be included in the plaint and requisite court fee has to be paid. And thereafter, my lords, the plaintiff is allowed to go ahead with the final decree proceedings of 1/8 share of the plaintiff. Lords, 2001, my lords, that decree is passed. 2007, my lords, the plaintiff dies. Lords, the condition that is my lords, imposed by the regular appellate court is not fulfilled. Lords, thereafter, my lords, the LRs did not know, my lords, that these proceedings were going on or it has culminated. Lords, in the year 2024, an application comes to be filed, my lords, before the regular appellate court. Lords, 2024. Please, my lords, 2024. Lord, seeking one, my lords, IA number 4, seeking setting aside of abatement.
Too early to come to the court.
Please, my lords, that, my lords, I understand there is some mistake, my lords, on the part of the LRs. Lords, one abatement application, one delay application, and one, my lords, LR application. 3 applications plus 2 another IAs are filed. Lords, by common order, my lords, the court comes to the conclusion that the delay is not satisfied and hence it is
So
rejected.
you filed all this in RA.
in the RA, because my lords, the RA court direction is, my lords, to include the suit schedule property in the plaint, and my lords, to pay the requisite court fee, if any. My lords, in suit for partition, the court fee is fixed at rupees 200 rupees. Lords, but the only condition that was not fulfilled was the,
When the father died,
my lords, 2007, the father died.
you cannot claim that
Lords,
after 6 years after the ARIA order, he died.
please, that is,
What your father has not raised, you cannot raise.
Lords, but Lords, I'm not seeking challenging the order of anything, my lords.
What do you want then?
Lords, Lords, the condition that is imposed by the regular appellate court, I'm fulfilling those conditions. Except that, my lords, I'm not re-agitating any of
What
the
it
claims.
amounts to?
Please, my
So
lords.
what has been closed because of your non-compliance about 24 years back? Now you want it to open. So there is no end to this.
Lords, I'm not reopening, my lords, any case.
What will happen by this?
Lords, whatever, my lords, the decree that was passed, my lords, that will be, my lords,
That itself, that execution time itself has gone.
lords, execute, the final decree proceeding itself is not started yet. FDP proceeding itself is not started based on the regular appeal, my lords, order that is passed. My lords, no FDP has been filed nor initiated by the court. That is the issue, my lord. No, my lords, fruits of the decree has been got, my lords, by any of the parties. That is the issue.
Only preliminary decree is passed.
Only preliminary decree is passed since
Are
2000.
you right on the, do you have the correct instructions on?
My lords, I have the,
facts?
my lords, 2001, my lords, the FDP is filed after this, pursuant to this, my lords.
So you said 2001.
2001, 2026 FDP is now filed, my lords, by the parties, by us. Until
You,
then,
what happened to the 2001 FDP?
my lords, it is as, my lords, it's just a paper decree. Nothing has been done past.
Where did you say so?
My lords, may see the annexure A, my lords, order
Notice to the
passed.
respondent.
Please notice.
Cell number 7.
Lords, can I take, my lords, also hand summons, my lords?
Let it come, no urgency. 24 hours years you have waited. You can wait another 20 months.
Please, my lords.
Cell number 7. Neeraj Rajesh Shivam.
Appearing for the petitioner, same set of facts as the matter yesterday, where the appellate court has granted an injunction in favor of the respondent. The plaint schedule boundaries and the partition schedule.
What happened to yesterday's matter?
It's adjourned. Same date it may
When is
be.
it coming?
27/7.
List this matter on 27/7 along with give that number.
Number right. Grateful.
Cell number 8. Devraju HV.
That I appear for the petitioner.
What is the amount?
The amount that now awarded 32,55,000.
What is admitted?
That the admitted amount that even that 50% market value taken.
No, how much it
30% is required to be taken. But even that value has been taken as a garden.
That's what I'm saying.
That it comes around 14 lakhs.
14 lakhs.
Yes.
Yes, please come. Then counsel appearing for the petitioner submits that the court has awarded an amount of rupees 32 lakhs without considering the fact that
Not that 30% of the diminution value instead of 50% awarded.
court has granted 50% of the diminishing
50%.
value instead of 30% and
value taken is that garden land instead of that it is in a dry land.
it's a dry land. The value of a garden land has been taken and granted the compensation. Considering the submission of the then counsel the petitioner, they should stay of all further proceedings on the condition that they shall deposit 14 lakhs within a period of 4 months. And on such deposit, the respondents are at liberty to withdraw. Notice to the respondents.
Cell number 9.
For petitioners in this matter, my lords, prays for short accommodation. my lords.
Not
A
accommodation.
week time will be given.
This is matter in the month of September.
Cell number 10. Nilesh Krishna.
In this petition, my lord, we are just seeking direction to the trial court to dispose of IA number 3 in that.
Why all only Mandamus?
No, my lord, in this matter,
Which year is the suit?
my lord, suit is of the year 2023, my lord. We are only seeking disposal of the IA in a time because on the last 2 occasions, despite both parties having completed their arguments, the court is posting it for clarification.
For every matter, for every IA disposal, if everyone starts coming to the High Court, what will happen?
My lord, since
And
last,
what will they do? They have their own priority to pass the orders.
if I may take your lordships to the orders, my lord, because both parties have completed their arguments
No, that is
only on
true,
IA, my lord.
But we can't minute to minute supervise when they are passing orders, how they are
Certainly,
passing
my lord.
orders.
The court is telling clarification. It is posting for clarification, but does not tell what the
Let's see
clarification.
the order sheet.
Yes, my lord. My lord, page number 70, my lord.
Yes.
Page number 70, that IA is filed, my lord, by the plaintiffs. IA number 3. Now, my lord, on the next date, written arguments is also filed.
On 12/2/2026, heard arguments on IA number 3.
Yes, my lord.
Praise time for hearing on IA 3 with cost of ₹500.
This, my lord, is corrected on the next date because we had already filed a written arguments and
Submitted that she has already filed written arguments.
over,
Found correct and cost is hereby cancelled.
found correct and hereby cancelled. Heard argument is heard for P.
Is it appropriate on the part of this court to pass an order on this?
My lord, let it in a reasonable time. Let it pass, my lord, because it's posting for clarifications. We are not telling immediately, but at least.
That's not right. We shouldn't interfere with their.
My lords, after that, my lord, next 2 days, they are only saying posted for clarification, despite hearing the arguments from both sides.
That kind of interference is not warranted in how they conduct their the writ petition is filed in the following prayer. This court do not find find any reasons to direct the court to. This court do not find any reasons to issue any direction to the trial court. Accordingly dismissed.
My lord, at least let liberty be reserved, my lord. If tomorrow again, if for next 2 months, the same thing happens, my lord.
The court has already heard the matter and it will pass orders, and this court will cannot issue directions in this manner in every case. Yes.
11.
My lord, at least liberty may be reserved, my lord.
Liberty for what?
My lord, if the court is not still passing the orders, my lord, it's been 8 months now. Some liberty, my lord, if the court is not continuing the matter, my lord, because all the IA and the proceedings are pending because of this IA.
What is it? So that with this liberty, next time you will file a writ petition and an order should be passed. How can the court grant liberty in this? Yes.
Number 11.
For petitioners in this matter, for short accommodation.
This also in the month of September.
Much of.
Yes, 12.
Number 12. HT Jagannath.
I'm challenging the orders passed on IA number 6 for granting of police protection. The responding herein has filed a suit for injunction against me. In the injunction suit, I have taken a contention that suitable property belongs to my mother, and I have taken a specific contention. And thereafter, the ex parte order of injunction was granted. And in the meantime, the responding herein has filed an application for grant of police protection. That was pending. The trial court has directed to consider the said application along with me. Then thereafter, since I have taken a contention, suitable property belongs to my mother. My mother has filed a suit for declaration, comprehensive suit before the trial court.
No. When an injunction is filed, when was the injunction granted?
Injunction was granted in the month of June in the previous year.
You have not.
Yes, once again. Thereafter, my mother has filed a comprehensive suit. My mother has filed a comprehensive suit against the defendant herein. The concerned court has granted an order of injunction in my favor also. Now, by suppressing that fact, he has made an application for the police protection once again. Now, taking on the orders of this application, he is taking to forcible possession. Since injunction is also operating against.
Have you not contested the suit, contested this IA?
Yes, till he is not filing written statement.
No. Have you contested?
Yes, definitely. I have contested.
What was your contention? What is the order of the court?
Yes, my contention.
To the order.
Yes.
Yes.
On perusal of the record, it is seen that this court has granted temporary injunction in favor of plaintiff holding that the plaintiff has made out a prima facie case and he is in possession and enjoyment of suitable property as on the date of suit. The fact that who is in
On the
possession.
other hand, in spite of giving sufficient opportunity, the defendant has not filed objections to IA number 6.
Yes. A similar application was filed by the respondent in IA number 5. In IA number 5, that application was still pending. For that, I filed an objection.
So you don't file objections to this?
This application, I have not filed.
And then why have you not? Why should we consider all this now?
Because,
This application.
because as on the date of filing the application, the injunction order was operating against the defendant also.
So you need not bring it to the notice of the court.
Yes. What, Mel?
You shouldn't bring it to the notice of the court. You have no role to play. You will just keep quiet because you have an injunction.
No.
And you will let the court to pass orders. And come to this court questioning that order.
No, because in my written statement, I have taken a contention that if
The court will not look into everything. So whatever an IA is filed, an opportunity is there to file objection. Without filing it, you come to the court that it is wrong.
Yes, Mel. For IA number 5, I have made a detailed objections. For IA number 5, for that application, the court.
For example, if IA number 6, if this writ petition is coming, you are coming up on IA number 1. Will court look into other IAs that are filed by you?
On similar application, IA number 5 and 6 are within the same, my lord.
I think that argument is not correct. You have to first accept the fact that because of your non-appearance before the court, this order is passed. You have not assisted the court. You have not brought to the notice of the court. That's why first I asked, have you brought this to the notice of the court and contested the IA? You said, yes, I have contested.
No, for IA number 6, in regards.
This is IA number 6.
IA number
How are we
6.
concerned with other IAs? This order is in IA number 6, where there is no assistance, nothing has been brought to the notice of the court. That's why the court has passed this order.
Yes, by oversight, I didn't file objections. Since I have filed an objections to IA number 5.
Oh, then you be happy with the orders that are going to be passed in IA number 5. Accept this IA number 6, because you are thinking that you have already passed. This is on 1st June 2026.
Yes.
Unnecessarily wasting the trial court's time. Second round, wasting this court's time.
No, because in my.
I will grant an interim order on costs for for wasting both the court's time. If it's okay, I'll pass an order. Otherwise, no.
No. Opportunity may be granted to file objection.
Call to stay this order. I will stay on costs. What is the cost? You please tell. Otherwise, I'll not interfere with this order.
Nominal cost, my lord.
Not nominal. No, this is not the lower court, 200, 300.
No, I'm not saying that.
The land counsel for the petitioner submits that the plaintiff in this suit has filed an IA seeking police protection for implementation of the order of temporary injunction granted with the court on 26/11/2023. Land counsel appearing for the petitioner defendant submits that the mother, you are also party to the other suit.
I am not. My mother is the party. My mother has filed a comprehensive suit against the.
Submitted that it is the case of the petitioner that the property belongs to the mother, and the mother has filed a comprehensive suit for declaration and injunction, and in that an injunction is granted against the plaintiff in this suit. It is submitted that in spite of the same, this order has been passed, giving police protection to implement the interim order of injunction. Next para. This court has perused the order. In the order, it is clearly mentioned that in spite of giving sufficient opportunity, the defendant has not filed objections to IA number 6. When there are no objections are filed to IA number 6, court has court has rightly passed this order. However, considering the fact that in the other suit there is an injunction, there shall be stay of all further proceedings on pursuant to the order dated 1st June 2026 on the condition that the petitioner shall pay an amount of ₹5,000 to the respondent. Notice to the respondent, petition is permitted to take out hand summons.
Yes.
And file a memo to the effect by 8th of July, or else a stay granted by this court stands vacated.
Number 13.
For the petitioners, my lords, they are the landowners who have lost the land. The execution proceedings, the amount is deposited by the acquiring authority. We requested for release of the amount. That amount is ordered to be released for only 50% of what I am entitled to, subject to furnishing a security, my lords. Therefore, my lords, I have challenged that portion of the order which restricts my withdrawal to 50%.
Okay, so who appears?
Please,
for
lords.
this? Who-
Government for first respondent and defense estate officer.
For who appears for all this? Any panel counsels or
Lords,
AGA will appear.
AJ will appear for first respondent, my
For the
lords.
respondent,
For second respondent, central
AG will
government.
appear.
My lords, they have engaged separate counsel, my lords.
Find out,
Please, my lords.
and they so that will pass over.
Grateful.
Cell number 14, R.S. Sumesh.
I appear for the petitioner, my lords. My lords, the application for amendment came to be allowed by the Honorable Trial Court. The suit is filed by the respondent for the relief of a bare injunction, my lords, against the petitioner. 2023, my lords. In fact, what has happened, my lords, under the Annexure A plaint, I think page number 11, my lords, they claim the property by way of an FDP proceedings, that is FDP 1 of 2007, my lords.
Come to the affidavit that is filed in support of the IA.
Please, my lords. That is Annexure G1, my lords.
Yes.
Please, my lords. They say that I know the facts of the case. It is submitted that I am the absolute owner in peaceful possession and enjoyment of the suit scheduled property. It is submitted that I am acquired the same through the way of the court decree passed in OS number 191 of 2000, and the said decree is enforced in FDP number 1 of 2007, my lords. And as per the court decree, Kata and Parni has been mutated in my name, and I'm in peaceful possession and enjoyment of the suit scheduled property as absolute owner, and I have paid the taxes to the authority. But it is submitted that at the time of compromise in FDP 1 of 2007, the southern side boundary was wrongly mentioned as remaining land of survey number 22/2. But as per the sale deed dated 1/6/1968, southern side boundary is land of Kempaya and Gundappa, that is the father of the defendant. It is submitted that the defendant is my neighboring landowner and he is an utter stranger to the suit scheduled property and having no manner of right, title and interest, much less possession over the suit scheduled property. And the defendant is trying to interfere with my peaceful possession enjoyment of the same. It is submitted that I intimated the same to the jurisdictional police, but the police have not initiated any action against the defendant. Hence, without alternative, I filed this suit.
Amend the plaint. By
In fact,
amending the boundaries.
I understand,
After the sale date.
In fact, may make a humble submission. My lords may kindly peruse Annexure A, the schedule itself, my lords. That is at ink page number
No. He is asserting his title to the property.
based on the FDP proceedings. my lords.
Based on the sale, FDP proceedings
Yes.
or based on the sale deed?
Please, my lords.
So let's look at the sale deed. Sale deed is.
I will showcase to this honorable court that as well, my lords.
Where is-
But before that, that is at Annexure G itself, my lords, ink page number 67.
67.
Yes, my lords. Unfortunately, it's in Kannada, my lords, and I didn't have time to get it translated before this honorable court. But I would assist this honorable court in the said aspect, my lords.
What is at page 69?
69, my lords, is a different set of scheduled properties. 67, my lords, that is the second clause.
No, in page 67, which is
Yes, my lord. The
schedule
second
of-
one, the first portion, which is written as 2, the number 2, my lords.
Number 2.
It says Tumkur Taluk, Guluru Hobbali, Kambatnahalli, Gramada survey number.
Come to the plaint. Both will
Please,
be
my lords.
together.
That's precisely, my lords. At ink page number 12, my lords. Ink page number 12, at the schedule, my lords. The below portion of it.
Yes.
They mention, my lords, it is land bearing number, survey number 22/12.
22/12, it is 22/2.
2, precisely, my lords. That's one aspect of it.
That anyhow, that can be done.
Assuming, my lords. But my lords may kindly peruse further. It says, totally measuring 33 guntas, including 0.9.08 guntas Karab land.
Yes, 26.08.
Yes, my lords. What is important is the boundaries, my lord. The boundaries is
The
east
extent are
property.
also- The extent are also different.
Yes, my lords. Everything is different. That's precisely my point before this honorable court.
Totally measuring 0.33 guntas.
Yes, my
It
lord.
says 26.08 guntas.
Please, my lords.
Then after that, what is that?
Then they say, my lords, Gunte Paiki 0.23.08, my
What does
lords.
it mean?
That is again Karab land, my lords.
Mm.
In fact, if I may request my lords to kindly peruse the boundaries. It says east in the plain schedule, property belongs to Sumitra.
When the entire extent itself
Is wrong,
changed.
my lords.
Entire extent itself is changing from the sale deed to the schedule.
Precisely,
No,
my lords.
what is the?
And in fact, they
No, no,
filed,
what is the amendment they are seeking? Let's
please,
see
my
that.
lords, if I may request my lords to kindly peruse ink page number 71, annexure G1, my lords. Even in this, my lords, they ask for two things. One, to add para number 2A.
No, no,
Ink page
first,
number
no,
71,
first
my lords.
Let's complete this.
Please, my lords.
Then we'll go to the next aspect. 71.
Yes, my lords.
Hmm.
They say to add para number 2A, which is, it is submitted that at the time of compromise in FDP number 1 of 2007, the southern side boundary was wrongly mentioned as the remaining land of survey number 22/2. But as per the sale deed dated 1/6/1968, southern side boundary is land of Kempaya and Gundappa.
Where is that? First is, what is the first one?
The first one, my lords, to add para number 2.
Page number 67, it says.
Please, my lords. Page number 67, this is the same thing, my lords.
No,
They
what it
say,
says? Southern boundary.
southern boundary says the remaining portion of survey number 22/2.
That is the southern, first one
That's
is
the southern. No, my lords. The first one is east,
Uh,
second is west,
hmm,
third is north, and the fourth is south, my lords.
hmm.
So in the
What
south,
it
they
says?
say
It says?
remaining portion of the survey number 22/2, my lords.
Hmm.
And
What?
here they say that instead of remaining portion, it should have been mentioned as property belongs to Kempaya and Gundappa. Unfortunately, my lords, these two are two different survey numbers. If I may request my lords to kindly peruse the plain schedule. Again, under the plain schedule, only the east boundary is tallying, my lords. The west, north, and the south are not at all tallying with the FDP proceedings, the schedule mentioned in the FDP proceedings.
First is the sale deed. Sale deed is the basis for the FTP
Please,
proceedings
my lords,
also.
please.
So if you look at the sale deed, what he says here and the sale, this is a document.
This is the document. This is the document. And in fact, if I may
Then
request my lords to kindly peruse
Come to the order, what it
ink
is.
page number 63, my lords.
No, no, come to the order. What
I'll come to that, my lords. Just one moment, if I may request my lords to kindly peruse ink page number 63. This is approved by the Honorable Court, Senior Civil Judge at CGM Tumkur, my lords.
Please
The
come to
schedules,
order.
please. This is at Annexure J, my lords. In fact, the Honorable Trial Court only comes to the conclusion, my lords, that this is prior to amendment, apologies, my lord, prior to evidence, commencement of trial.
Have you filed your objections
Yes,
stating
my
all
lord.
these things?
Yes, my lords. In fact, my objections are at Annexure H, my lords,
Page number?
ink page number 73.
Yes.
At para number 5, my lords.
Hmm.
The defendant further submits that the schedule of the final decree proceedings and that of the proposed amendment clearly shows that the plaintiff is trying to make out a new case, which is impermissible under law. Under the guise of amendment, the direction of the property so claimed by the plaintiff cannot be changed. If permitted, then the defendant's defense will be meaningless and diluted. The affidavit in support of the application does
You have
not
You
disclose.
have not referred to the inconsistency between the sale deed, between the FTP proceedings and now the.
My lords, that was not specifically contended, but it was contended as it would raise a new case itself, my lords.
Please come. Then counsel for the petitioner's office at the court has allowed the application is filed under order 6 rule 17, whereby the boundaries in the suit scheduled property were permitted to be amended. It is a case of the plaintiff that as per the boundaries in the sale deed were wrongly mentioned in the FTP proceedings. Then counsel for the petitioner has drawn the attention of this court to the sale deed and the boundaries that are mentioned in the boundaries that are mentioned in the petition seeking amendment of the plaint. On the face of it, it appears that there is inconsistency between the two. In that view of the matter, there shall be stay of all further proceedings pursuant to the order dated so and so.
Much obliged.
It is permitted to take out hand summons and file a memo to that effect by 10th of July or else a stay granted with this course transfer.
Please, much obliged.
Cell number 15. Why can Narayan Sharma?
For petitioner, my lord. See, suit for, initially the suit for permanent injunction, lord, that was amended and sought for relief of possession. Now, during the pendency of the suit, the defendant has put up a fencing over my property. Now that fencing was removed. Now I am in possession of that property. Hence I sought for deletion of the prayer of possession. That has been rejected by the trial court, my lord, saying that already.
How you have become in, how you have come to position?
Earlier, he just only put the fencing, my lord. That fencing now removed. In view of that, I am in possession of that property. There was one more suit, my lord.
No. When was the suit?
Suit was filed in 2012.
2012. When was the relief of possession sought?
That was in 2000. That date is not here, my lord.
Which year?
Maybe 22 or 23, my lord. In the meantime, there is one more suit has been filed, my lord. There was one more suit pending at that time between these two this plaintiff and defendant, and also their vendor. And in that suit came to be dismissed. And in that, the finding has been given that this defendant is this plaintiff is in possession of that property, suit schedule property.
Come to your.
So it's a vacant site, my lord.
Come to your right.
Affidavit, my lord, please. Kindly come to page number 28, my lord. 28. Para 2, my lord. I submit that one Sundarama and others who are the legal representative of late Doddaya, who is my vendor, my lord, filed a suit for partition against late Doddaya and also against me and defendant in this case in OS number 466/9 on the file of the Mysore. When the trial in the said case started, the defendant in this case had removed the fencing which he put up to the plain schedule property and other adjoining sites. In fact, the said suit in OS number referred above was dismissed on merit on 74/21. In the said judgment, the Honorable Court has clearly observed that I and other purchasers of the sites from Doddaya are in possession of our respective
Pausing here
sites.
for a minute.
Please, my lord.
This is on 17/4/2021.
21.
There was a observation in the court that in that order that you are in possession.
Please, my lord.
You filed the amendment in the year 2023.
No, I am not having that. I will furnish that date, my lord. When I file that application, I will furnish that date, my lord. I will get that application. I do not have that now.
This is matter next week. Yes.
Till number 16, CM Nagbhushana.
Date may be given, my lord.
Listed on 8th of July.
10th of July. Much obliged.
Till number 16,
Yes.
Plaintiff filed a suit for declaration and for possession, claiming that he is the owner of a site number 153. And I am the site owner of 153A. According to the plaintiff, the site number 153 has been acquired for formation road. On the other hand, we contend that it is his site which has been confirmed. And the PW1 was evidence was over. DW1 evidence, when it is set down for cross-examination, plaintiff files an application appointment of a commissioner to collect evidence, and he makes a submission. He will continue with the DW1 cross-examination only after the report is received, Your Lordship. Therefore, it is a premature according to me, Your Lordship. When the evidence is not completed.
Let's see the order. Page number.
Yes, Your Lordship. Page 74, Your Lordship gets it.
Counsel for defendant number 1 is ready with evidence. Is
Yes,
that the order?
Yes, Your Lordship. May I read the whole order, Your Lordship? IA 26 is filed under Order 26/9 of CPC to appoint the city surveyor or Department of Survey Settlement and a land records KR Circle, Ambedkar BD, Bangalore, as a court commissioner for purpose of investigation of boundaries of the suit schedule property. In support of the application, the applicant states that he is the absolute owner of the suit schedule property, having acquired the same under.
What is this allowed? What is this allowed?
Appointment of a court commissioner, as I said, to investigate the boundaries of the suit.
This is the order, no separate order.
No separate, this is the order.
Please come. The defendant has filed an IA seeking appointment of an advocate commissioner, which was opposed by the plaintiff. Then counsel.
Defendant, Your Lordship.
What is that?
Defendant has opposed the application.
The defendant has read the order.
This is the application filed by the plaintiff which has
That's
been
what-
allowed.
No,
It is
no, look at it. Counsel for D1 filed IA.
Page number 76, your lordship, Godship will order.
I'm looking at 75.
No, it is 76, your.
Look at 75. What is this? Counsel for D1 filed IA.
Order sheet continuation, your lordship. 35. 35.
That's why I was asking you. There is no separate order.
No, separate order is this, commences from page 76, your lordship.
Okay.
Most important, layout plan is not produced by.
1 minute, 1 minute.
Nearly.
What is the present stage?
My lord?
What is the stage? of
Cross
the-
exam DW1, but the learned judge, my lord, records a incorrect statement in para 8 at page 82. Already the trial has been concluded. It is not so. As I submitted, DW1 cross examination is to be done. At that time, this application is filed and the plaintiff makes a submission. He will complete the cross examination only after the report is received, your lords. May pass on the order sheet, your lordship.
Then counsel for the petitioner submits that. Then counsel appearing for the petitioner defendant submits that. The trial, now the matter is coming up for the evidence of defendant.
Yes.
Evidence of defendant. And at that point, at that stage, the application is filed seeking for appointment of an advocate commissioner without even furnishing all the layout plan and other details. The court, by observing that the trial has concluded, has allowed the IA, it is submitted that the trial is not concluded and the observation of the court itself is factually incorrect considering the stay hand summons by 9th oral stay granted by this court stands vacated. Yes, next.
17 for admission matter, serial number 17, Parmeshwarappa.
Petitioner is the absolute owner of the suit schedule property, man. Respondent is the tenant. Petitioner filed a suit for eviction, my lord.
No, I'm told it is still there.
The reason,
This matter.
the reason is
No, it is like this. The court has no jurisdiction. Wherever you have the jurisdiction.
section
you go there.
50 of the order,
Section 50?
section 50. It is clear that
50 of which? Arbitration.
page number 15, my lord, jurisdiction of the civil court.
Yes. What is it clear?
Save otherwise expressly provided in this act, for the civil court shall entertain only suit for proceedings insofar as it relates to the fixation of standard rent. Only tribunal is only fixation of standard rent. I filed a suit for eviction, my lord. Ejectment. Fixation only come to the
Seeking eviction of the tenant. And what is the rent?
rent is 1,000 rupees, my lord. I filed a suit before the small causes.
It has said come notice.
Cell number 18. Cell number 18. Balakrishna K.
I represent the petitioner in this case. I am the defendant before the trial court, Your Lordship. I filed the rejection of plaint. There is a MOU, Your Lordship, kindly come to the
What is the
in-page.
suit? What is the suit for?
Suit for money recovery.
Oh.
There is a MOU. On that basis, certain lands are executed the agreement of sale in favor of the respondent plaintiff. Lordship, kindly come to the in-page 27 MOU enter into the between the parties.
Oh, we will go to your affidavit. Where is the affidavit? Affidavit in support of the IA.
81 it will start, Your Lordship. Clearly stated in my affidavit, para number 11 also. 11, there is a MOU. MOU not brought before the court deliberately by the plaintiff.
And who will bring, why the court will look into that MOU?
I have produced, letter I have produced, I have argued the matter. Lordship, kindly come to the order, only portion of the order. In page 25.
Before you go to the order, can the court look into the MOU that is produced?
I have
by you?
produced, I have produced.
You're not answering my question.
Please.
Can it look into, that's what I asked, while considering an application under order 7 to 11.
I have taken.
On law, please argue. Can the court consider the MOU that is produced by you for rejection of the plaintiff? Is the only question. Can the court do it?
Court also admitted a MOU. Lordship, kindly only 1 second. In page 25, only portion of order I will read. Conclusion, 13th para.
Even if it is admitted, whatever it is, it cannot consider it.
Arbitration clause is there, even though I will deal, Your Lordship, I may be permitted, only one. The counsel for the defendant has filed synopsis wherein he has referred memorandum of understanding regarding the arbitration clause. Even if it is assumed there is an arbitration clause, plaint cannot be rejected on the ground that the existing arbitration clause at the most of suit may be referred to arbitrator and the plaint cannot be rejected. The other coordinate court already written the plaint and direct the plaintiff to go 6038 connected case. The 3 cases filed by these plaintiff, different court. 6038 plaint was returned and direct the plaintiff to defendant to go before the arbitrator. In that relying upon a judgment, and also the same party has filed before your this honorable court for the reference for arbitration clause, Your Lordship. I am furnishing the
Please
order.
understand, we don't have to look into all that. That stage has not come now. You have to file your written statement, then the court will consider.
I have filed the written statement. It is a 2020 case, Your Lordship. I have filed the written statement.
Yes.
The issues are framed. One and other reason they are filing application. They filed the before attachment judgment. The land is situated in Devanelli. There is no jurisdiction. Then they withdraw that one. Then they file the amendment plaint. Lordship, there is a 2 Honorable Supreme Court judgment. Once the principal agreement is there, it cannot be looked at any other agreement. I am permit, sir.
Take that.
Adela, madam, sorry, there I have not. The first judgment, May 2018, Your Lordship, in page para 22, Your Lordship.
How this law will help you in an application under order 7 to 11?
I have produced,
Court cannot look into, that's the first issue, you have to cross that hurdle. After that, all these judgments, Court cannot look into.
Already
That is
same
settled
my
law.
principal investor, both are before the
Settled law,
arbitrator.
you also know.
I am permitted read only one 22 para. Parties the agreement namely Rishabh and Jewel India equipment material supply agreement, engineering installation, commissioning contract, parties sale and purchase agreement between Rishabh and Poseid are one and the same. That the parties main agreement namely equipment lease agreement dated all four agreements interconnected. There is where several parties involved a single commercial project, solar plant executed to several agreements, contracts. In such a case, all parties conveyed arbitration clause, main agreement equipment. Now only one submission, Your Lordship. The MOU enter into the between the parties on in page there is a principal agreement in page 27 on 30/10/2014. In that MOU, there is a land. Now the plaintiff respondent filed the various 3 suits before the trial court. The survey numbers mentioned here 63/1, 63/2 and 206/182. The same agreement only is filed for the money recovery. Therefore, the principal agreement MOU, he suppressed the material fact. Therefore, my submission. Lordship, kindly come. I issued the notice. I have taken contention. Initially, I have cancelled. Lordship, kindly come to the in page 52 legal notice.
How all those are material to decide this application?
Already there is a.
Still you have not answered my question, Mr.
Please.
Counsel. I have asked you, there are 100 documents in your position along with the written statement. Will the court look into all that while considering an application under Order 7, Rule 11?
The MOU executed by the.
I'm sorry, if you're not understanding, I can't help it. Please come. I've already heard you.
Maybe notice may be issued.
I will not order notice. This is an order. The present CRP is filed. Agreed with the orders passed in I number 6, invoice number 6017.
The cause of action also I have taken
Dated,
contention. Your
I
Lordship.
will record, dated 21st January 2026, whereby the court has dismissed an application that is filed under Order 7 Rule 11. Aggrieved thereby, the defendant is before this court. The respondent herein has filed a suit for recovery of money. In that, the present application is filed seeking rejection of the plaint. It is a case of the plaintiff that the averments made in the plaint is an imagination of the plaintiff and the same is false. The documents pertaining to the scheduled property were handed over to the plaintiff and he don't have any funds to purchase the properties. The petitioners have issued a notice bringing all aspects of the case to the plaintiff and cancel the agreement executed by them in favor of the plaintiff. The memorandum of understanding was relevant and the plaintiff, while producing all documents, has deliberately not produced the MOU, which shows the malified intention of the plaintiff. It is stated that they terminated the agreement of sale on 19/7/2017 and the agreement of sale was executed on 18/12/2014. Limitation period to file the suit was on or before 17/12/2017 and this suit was filed on 30/11/2020. Therefore, the suit itself is barred by limitation. It is also stated that the plaintiff has issued a reply notice and admitted that there is an MOU and the plaintiff will initiate the suit for money recovery within 15 days. Failing that, if the petitioners herein fail to pay the amount, it is stated that the cause of action that it is already that is covered. The trial court, next part, the trial court by order impugned has observed that the trial court by order impugned while dismissing the IA has observed that the the counsel for the defendant has filed synopsis wherein he has referred to memorandum of understanding and regarding arbitration clause. Even if it is assumed that there is an arbitration clause, plaint cannot be rejected on that ground that there exists an arbitration clause. At the most, suit may be referred to arbitration, and the plaint cannot be rejected on the ground that there exists a MOU containing arbitration clause as contended by the defendants. Therefore, there are no grounds and dismiss the IA. Land counsel appearing for the petitioner submits that the suit itself is not maintainable as there is a arbitration clause in the MOU and all these aspects were suppressed by the plaintiff and the defendant has brought this to the notice of the court. The court, in spite of taking cognizance of the same, has dismissed the application. He has relied on the judgment of the apex court in case of Amit Lalchan Shah versus Rishabh Enterprises, reported in 2018 6 KL 621, and also the judgment of the apex court in CH-19 Controls India Private Limited versus Severn Trent Water Publication Inc. Arising out of civil appeal number 7134 of 2012. Relying on these judgments submits that when there is an arbitration clause, the civil court has no jurisdiction. The court has no jurisdiction to entertain the suit. Next, having heard the counsel for the petitioner, there is the material on record. The suit is for recovery of money. The petitioner, the plaintiff has stated about the cause of action and how the suit is filed and how he is entitled for recovery of money. The defendant filed his written statement and stated about the MOU and where it contains the clause for arbitration.
17 of the MOU.
Where it contains a clause of arbitration. When the petition is filed seeking rejection of the plaint, as it is settled law that the court will consider at the plaint and the documents that are filed along with the plaint. Apart from that, the court will not consider any other document. It is the case of the defendant himself that the plaintiff has misrepresented before the court and concealed this important aspect. If that is the case, that would be considered by the court while considering the other aspects. But as far as the rejection of plaint is concerned, the court cannot look into the written statement. All the judgments that are relied on by the petitioner do not come to the rescue of the petitioner at the stage of Order 7, Rule 11, where there is no mention about the MOU in the plaint or in any of the documents that are filed along with the plaint. In that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed.
Cell number 19 adjourned. Cell number 20.
Before the trial court. The respondent had filed a suit for the relief of declaration on the ground that she has acquired the property through a registered sale deed dated 25/10/2008.
25/10?
2008. I have produced the plaint in page 15. Your Lordship.
Let's go to your affidavit. What are the grounds?
The fact is that, my lords,
Where is the affidavit?
affidavit in page 30,
Let's read it.
para 2. I submit that we belongs to scheduled tribes and scheduled caste. They are the owners of the so and so, and I acquired the land which was granted to my grandfather. Next, if your Lordship takes up page 32, para 6, the reason for rejection of the plaint.
Yes.
It is submitted that we filed a petition under section 5 of the PTCL Act, before the Assistant Commissioner, Madikeri subdivision, Madikeri, requesting the authority to declare the GPA dated 24/5/2008, sale deed dated 25/10/2008. This was the sale deed under which the plaintiffs are claiming their right, said to have been executed by us in favor of Pullegowda and the plaintiff, are null and void, and seeking for restoration of the scheduled property. Assistant Commissioner has registered a case in PTCL number 6/2425 and RA number 80/2425. After contest, Assistant Commissioner has passed an order declaring that the GPA dated 24/5/2008 and sale deed dated 25/10/2008 are null and void. Further passed an order to restore the land in favor of the defendants. I have produced the order passed by the Assistant Commissioner in page.
Please come to the order.
Please, my lords. Even the trial code, if your lordship takes up page 44. Para 19. The Honorable Trial Code holds that the land in question, the suit property, is an granted land. May I read, my lords? Para 19, page 44.
Please come to para 18.
Para 18. The defendants have sought rejection of plaint, contending that it does not disclose a cause of action and that suit is barred by law. More particularly under section 4, 5 and 11 of the Scheduled Caste and Scheduled Tribes Act. The plaintiff, on the other hand, has denied allegation of fraud and statutory bar and has asserted that plaint clearly disclosed the cause of action. At the outset, it is not in dispute between the parties that the scheduled property measuring 2 acres was originally granted in favor of one Shri Harijana Sanna Javara. The Honorable Court holds that the property is a granted land in favor of the scheduled caste person, namely that's the grandfather of the defendants, Harijana Sanna Javara. It is my contention that once there is an, however, the nature of the grant and whether such falls within the ambit of section 4 and 5 are matters which cannot be decided without evidence. My respectful submission is, once there is an order, the Assistant Commissioner, the authority.
Did the plaint say so that there is an order?
Pardon?
Did the plaint discloses that there is an order?
Well, they have, in their objection, they admit. In their objection, they admit.
What about objections?
My lords.
Plaint, written state, plaint documents.
Plaint, intention.
Please understand, it
Please,
is a
please.
settled law.
Please, my lords. Once there, the civil court has no jurisdiction. Once there is an order under the PTCL, please, my lords.
That's where you have to pause. That order, where is that order?
I have produced in page.
You don't have to produce. Did the plaint, is it produced by the plaintiff or is it along with the documents?
No, my lords, intentionally they have concealed. It's a fraud on the court.
You have answer in your own submissions. Please come.
My lords,
Let the court decide. The agreed with orders.
for a moment, I will.
You know that that's a law. You can't change it. Whatever the
My lords,
submission
even if,
is.
my lords, may I make one submission, my lords? Even if the suit is proceeded, then the entire fruit of the order, this special enactment under PTCL Act, they are the party, the plaintiffs are party to the order. They have not challenged. It has attained finality.
Each and every ground and all the grounds you raise cannot be considered at this stage.
Well,
That you have to understand.
Once there is a special enactment,
Yes.
it is brought to the knowledge of the honorable court. It is the duty of the court.
It has no duty to consider any of whatever you say. It has only the duty to look at the plaint and the written statement.
My lords, even if the suit is proceeded, my lords, suit is proceeded, even the,
That is a hardship which
It's-
the court cannot.
it's a futile exercise. That's the,
Come,
well,
agreed with orders.
may I seek one adjournment, my lords, I will convince. Along with authority, I will convince.
There is no authority.
Yes,
that
yes,
you
I
can
will produce, my lords, I will produce. One day, my lords.
He will produce,
My lords.
please, sir. What authority will produce?
My lords, once it is brought to the knowledge of the court that the subject matter is
I will give you 10 judgments right now.
One opportunity, my lords.
Don't
Monday,
waste the court's time.
Monday,
Listen,
Monday, my
lift
lords.
this matter on Monday
Please.
as the first matter in the list.
Please.
You argue contrary to law and you seek time.
No,
You're
it's-
an advocate, you
it's even-
understand.
even if-
No, one should it's on a settled law, you have to
Yes,
argue.
once there is an order under special act. Even the.
Yes, that is like something, yes.
21.
Appear for the petitioner, my lord. My lord, I'm challenging the order 7 rule 11, which has been dismissed.
This is the suit for.
They have filed the plaintiff a suit for cancellation of the GPA and the sale deed. GPA has been done in the year 1995 and the sale deed has been done in 2004. That is 17 years after the sale deed, after 26 years of the GPA, the sons are challenging this, asking for the cancellation of GPA and sale deed, my lord.
Let us see the affidavit.
My lord?
Affidavit.
My lord, affidavit I have put in my grounds. Page number, verifying affidavit I have put 18.
You are not.
Yes, 54 to 58.
Hmm?
My lord, 55 it starts, madam, affidavit.
Your Vakalat is at 53.
55 affidavit starts from 55, my lord.
You have filed it separately.
Yeah, separate A is there along with affidavit.
Ah. Yes.
My lord, if you see directly, I will go to the point on page number, paragraph number 5, my lord. The trial court has miserably failed to appreciate the fact that the cause of action as made out by the plaintiff is an illusory one and the contrary to the pleading set out in the plaint. On a plain reading of the entire plaint, it is evident that the cause of action for the plaintiff had arisen way back in the year 1995 and 2004 itself.
This is the ground.
Yes, my lord.
Please come to the order.
The impugned order is page number 19, it starts, madam.
Yes.
Annexure A.
Yes.
The ground taken by the trial court judge is that he has not mentioned that why the delay is there. And he is telling that the plaint governments also that the one, in my case, defendant number 1 is the husband.
We will read where are the findings.
My lord.
The plaintiff
Yes.
has filed the present suit, para 9.
My lord.
Para 9. The plaintiff has filed the present suit.
Yes, my lord. The plaintiff has filed the present suit for the relief of cancellation of the GPA dated 28/8/1995 and directed the defendants to execute the cancellation of the sale deed dated 25/8/2004 and the other relief against the defendants. My lord, here the defendant number 1 was the husband. He died and the suit against him is abated.
Let us look at the page.
My lord, the plaint is in page number 28, my lord, annexure B. The case has been filed by the sons, my lord. Just to harass the senior citizen, she is 60 and above widow. Just to grab that property, they have filed this case. Defendant number 1 was Shiv Shankar. Defendant number 2 is the wife of Shiv Shankar. Defendant number 1 died. GPA was given to Shiv Shankar by the fathers of the plaintiff. And based on that GPA, sale deed was created.
Once the executant is no more, the GPA, where is the question of cancelling the GPA?
But the thing is, GPA was given when their father was present. When his father was present, only the sale deed was done. He was alive for 11 years. No, his father also never challenged the sale deed or the GPA.
When was the sale deed? 2004.
Yes, my lord.
The sale deed.
Sale deed is 25/8/2004. And the GPA is 28/8/1995. It has the sale deed has been done when his father was alive. His father never challenged the GPA or the sale deed. When his father has died, when he is not able to get this property, he has filed this case. They are none other than the relatives only. He wants to grab that property 30-40 site because the BDA has been stopped in the 100 meters. And he has came for negotiation also. He's asking for 25 lakhs, but it goes for 1 crore.
And counsel to the petitioner submits that the father of the plaintiffs have executed a GPA, have executed a GPA in the year 1995.
My lord, 1995 GPA.
And basing on the said GPA, the sale deed was executed in 2004, and the father of the plaintiffs died in the year 2011. Now, in the year 2021, the present suit is filed seeking cancellation of the GPA and sale deed. It is submitted that the suit is on the face of it, the suit is barred by limitation, and the cause of action that is stated in the plaint is a illusory one, and these aspects were not considered by the court, and court in a mechanical manner has dismissed an IA saying that these are all questions of fact and law. Considering the submission of the counsel for the petitioner, they shall be still called for the proceedings pursuant to the order dated so and so. The same hand summons by 13th of July, the memo shall be filed, or else the stay granted by this court stands vacated.
Sale number 22.
Much obliged, my lord.
Janardanji.
Defendant's revision and an application has been filed to reject the plaint on the ground that the sale transaction of the petitioners have purchased the property in 1962. By reading the plaint, it is clear that obviously, even though he has produced the encumbrance certificate.
Who has, what is the suit for?
Suit is for bare injunction.
Oh.
But the plaintiff's father, grandmother has purchased the property in the year 1960, sold it to the plaintiff's father in the year 1962. That lordship could be able to see that the averments in plaint.
Who purchased the property?
1962.
From the plaintiff's father.
Plaintiff, my father purchased thereafter the death of
What
my
is
father.
the suit for? What they say?
No, he says, I am in possession of the property. I am interfering with his possession. He says, I am restraining, I am not allowing him to enter the property. That is the plaint averments.
No, in the plaint, did he mention about that 1962
Yes.
sale?
Yes.
Where is the plaint?
Kindly come to page 20th is the plaint copy. Kindly come to para 3. Ma'am. The plaintiff submit that their grandmother so and so died on so and so, 3 so and so, their father so and so 99 living behind the plaintiff's estate of so and so, and grandmother plaintiff.
When was the purchase by you?
By 1962, my lord.
Date of the sale?
Yes, I have purchased it on 6/7/1962.
So they have produced something till
1959 sale deed I have produced, and fortunately has produced.
Copy of the encumbrance certificate.
Yes,
till
that he has produced.
2024.
Kindly see, it is reflected in my sale transaction is reflected. The learned judge are not looking at it. Kindly see here, that sale transaction to my name is reflected.
Take that. In the documents which are filed by them.
He has filed by him. He has only referred in the plaint also. Kindly see, first entry, 62, in the name of my father, Chandraman. He says that in the plaint, I am obstructed, he is not allowed to enter the property. He has sued for
Please
injunction.
come to the order.
Yes. Lord, kindly come to plaint para 3. He has
No, no,
referred
please
that.
come to the order.
Yes, yes. But kindly see, he says para 9. Para 8, my contention, then para 9 is his contention. Then the learned judge, para 10. In the affidavit, annexed affidavit IA3, defendant has stated, plaintiff has filed the suit for him for seeking for relief of permanent injunction from the suitural property. Originally, property belonged to Channabhagamma, having purchased the same from so-and-so Narayan Swami and registered sale deed dated 1/6/11/6 or 1960, and during her lifetime 6/7/62 itself, herself and plaintiff's father Ramalinga jointly sold the suitural property to his father and registered sale deed.
Then counsel appearing to the petition submits that an application is filed under order 7/11 saying to reject the plaint. It is the case that the suit is filed for bare injunction against the true owner of the property, as the property is purchased by a registered sale deed by the father of the defendant on 6/7/1962. The plaint, along with the plaintiff in the plaint, has categorically stated about the encumbrance certificate, and in the encumbrance certificate, the property that is sold to the father of the but the defendant herein, the petitioner herein who is the defendant is reflected in the same, that the court has failed to consider the same. Considering the submission, they shall be stay of all further proceedings. Pursuant to the order dated so and so. Hand summons and a memo shall be filed by 14th of July. If the memo is filed, if the memo is not filed, stay granted by the court, stands vacated. Yes.
23, you can agree.
For petitioner, my lord. Suit for partition, my lord. I have filed application for rejection of claim.
And then let AC also be switched on. Move slow. Open on and let it be AC. Yes.
Suit for partition, my lord. I have filed application for rejection of plaint as it is there is no cause of action and it is barred by law. My lord, my affidavit at page number 58, my lord.
58.
8. Para number 3 of my affidavit. On plain reading of the plaint averments, the plaint related document clearly does not disclose a clear right to suit submitted. The plaintiff has cleverly drafted the plaint by suppressing the facts after dismissal of father of the mother and brothers of plaintiff a partition
Who are
suit.
you?
I am the purchaser.
When did you purchase the property?
2010, my lord.
Yes, suit is filed in the year 24.
24, my lord.
Who executed the sale deed in your favor?
My lord, defendant number 9 to 11 have executed.
Yes.
My lord, kindly come to page number 47 of the plaint, my lord, plaint pleadings. Para number 6, my lord. Para number 6. It is clearly stated that plaintiffs, the suit schedule properties are the ancestral and joint family properties of plaintiff and defendant number 1 to 11, and there was no partition took place among the plaintiff and defendant number 11. And my lord, in the plaint, my lord, they have sought, they have they have sought for, they have, in the prayer, my lord, they have sought my sale deed as not binding on them. My lord, my sale deed, my lord, is at page number 76, my lord. In 76, my lord, the recitals of my sale deed. They have produced my sale deed along with the plaint. In recitals of the sale deed, how my vendor has acquired the title is by virtue of registered partition dated 31/7/2003, which is entered before 2012-2004, as per section 6.
So what is it? Partition?
Partition is entered between the family members.
Date?
31/7/2003. My lord, in my
They accept that.
they accept, my lord.
Please go. Then counsel for the petition submits that an application is filed on order 6/17 seeking the rejection of the order 7 to 11, seeking rejection of the plaint. The petitioner, who is defendant number 9.
I am for defendant number 12, my lord.
Defendant number 12 has purchased a property between defendant number 9 to 11. The sale deed is produced by the
Plaintiff.
wherein
Respondent
the sale deed, the recitals on the sale deed show that the property, the source of title to defendant number 9 to 11 is the partition that is effected in the on
31/7/2003. 31/7/2003.
31/7/2003. And all these documents are produced by the plaintiff, and the court has failed to consider the same and rejected the IA that is filed by the petitioner considering the submissions.
My lord, I am filing memo for dispensation of notice for R2 to R16, my lord.
Memo
R1 is the
seeking
plaintiff.
Dispensation of notice to R2 to R16.
R2 to 16.
Dispense with the risk of appellant. One notice by the hand summons on respondent number 1. Memo shall be filed by 10th of July or else the stay granted by this court stands vacated.
24, Sumaki.
Obliged.
Sumaki for petition.
I'm the advocate for the petitioner. I'm defendant number 12 before the trial court. The plaintiffs are respondents 1 and 2. They are the legal heads. That is, the plaintiffs are the legal heads of defendant number 2. That is, the children are challenging, though the father is alive, they filed a suit for declaration, partition, separate possession and permanent injunction. There was a partition right in the year 1989. At that time, the father of the plaintiffs, that is defendant number 2, had a share in the property. And there was another share to another defendant 9. And this defendant 9 has sold the property to defendant number 12. Defendant number 12 got a portion of the property, and they had given part payment, and then a judgment was rendered in 2009 saying that a sale deed must be executed. Sale deed was executed subsequent to 2009. Hence, from 2009, the defendant number 12 is in possession of the property. Now, these plaintiffs, who are the legal heirs of defendant number 2, have filed a suit for partition possession, though their father, okay, he had a share in the property. All the properties were mutated, all the revenue records were mutated in 1989 itself.
Come to that.
2 points. One is they had no cause of action. The second.
Come to that.
Yes.
Next, para number 16.
Para number 16. The question whether there was a prior partition, whether the decree in OS 738 of this is the decree is binding on the plaintiffs, and whether the suit is barred by limitation are mixed questions of law and fact, which cannot be decided at the threshold under Order 7, Rule 11 of CPC.
I think you can come to para 24.
Yes. Para 22, I'll start.
24.
Okay, 24. On careful perusal of the plaint averments, the plaintiffs have specifically pleaded that the suit scheduled properties are ancestral and joint family properties, that there was no partition by metes and bounds, that the plaintiffs and defendants 1 to 9 are members of Hindu joint family, and that the alleged documents, decree, sale deeds, and will relied upon by defendants 10 to 13 are not binding on them. The plaintiffs have categorically denied the alleged prior partition and have asserted continuous joint possession and enjoyment of the suit scheduled properties. They have also pleaded the cause of action, date, place, and jurisdiction. The reliance placed by defendant number 12 on Koshi Abraham versus B. My humble submission. Yes.
Do the plaintiff accept or state in their plaint that there was a prior partition?
They do not accept there's a prior, but they say that when they served a notice to the defendants, they have said that there's a document registered in their name. Your Lordship, if even after knowing about this registered document, because they were residing along with their father, they could have challenged that sale deed, they could have challenged the 2009 judgment. They have not done till today. If they were so much affected, because I am in possession of the property till today. But in paragraph in the plaint, what they have mentioned is when we give a notice.
So,
yes,
with regard to the prior partition, there is no averment in the plaint. They do not accept it. According to you, they have misrepresented it.
They have misrepresented.
But can the misrepresentation be decided in Order 7 to 11?
My humble submission is what they could have done is they could have, because they are very well aware of the.
All these things will
yes,
arise.
I agree.
File the written statement.
I agree.
And when it comes to the notice of the court, at this stage.
My humble submission at this stage, cause of limitation will not come. The reason, that is why I have given this Joshi, so I will just produce the judgment. In this case, what they say is, when there is a prior partition in 1989, Your Lordship, and when.
Who says that there is a prior partition?
They don't agree, but their father, because another humble submission is, can these legal heirs challenge us, may have a suit for partition when the father is alive? Now the father, when he's alive, he's defendant number 2. He should have also been the plaintiff. When he's not a party, how can they challenge? When the father is alive, how can the children claim a suit for partition? Hence, on that ground, the order, that is why I have filed that they have no cause of action and hence a suit.
No, which ground you are now?
Both
I
am.
That ground is not available to you, number 1, because that is not stated in the plaint. That is not plaintiff's case. Your case cannot be considered. Then, from the plaintiff's case, why the plaint has to be rejected. That ground you submit, that we will consider. What is that ground?
That my second ground is when the father of the plaintiffs was alive. When the father of the plaintiffs was alive, can the legal heirs challenge the partnership? They can.
How that particular aspect, where it is dealt with by the court?
That particular aspect is also, I have mentioned it.
No, in the order where it is answered.
Yes. Your Lordship, point number 1. Learned counsel for defendant number 12, paragraph 22, reasons. Learned counsel for defendant number 12 in support of the application has placed reliance on the judgment of the Honorable High Court of Karnataka in Kochi Abraham versus BK Jayalakshmi.
Come to your affidavit. Where did you say about this during the lifetime of the father?
Yes, I have mentioned
Because the
it
court has not dealt with it in this order.
in the first,
Only maybe there is no finding on that. Come to your affidavit.
affidavit. Your Lordship, I have written in the fourth para, page 73.
Yes. Yes.
I submit that the respondents have filed a suit against appellants and others for declaration, partition, separate possession, and permanent injunction in
No,
respect
where
of
are you
ans-
reading? I don't see at 73. 73 is a stay petition.
Okay, sorry. Your Lordship.
I'm asking about the affidavit in support of the IA.
Okay, affidavit in support of the IE, yes.
That's at page 49.
Your Lordship, paragraph 50 below.
52 bottom para. Please
Yes.
come.
It is submitted that the original owner of
Counsel
the.
of the petitioner submits that when an application is filed under order 7 to 11, contending that during the trial time of the father, there is no cause of action for them to seek partition. That aspect was not considered by the court, and no finding is recorded in that regard. Considering the submission, stay and summons memo shall be filed by 10th of July, or else the stay granted by this court stands vacated. Yes.
Number 25, Vishnu.
Petitioners, Your Honor. Petitioners are the respondents 2 to 6. Plaintiffs suit for specific performance. Admittedly, this is a property which comes under the purview of PTCL. Even the court acknowledges in the order. The IA was filed under 7 Rule 11, under 7 Rule 11A and D. So D acknowledges. With E, the court says, since there is an alternative prior, it cannot be rejected.
What is the suit for?
It was a suit for specific performance.
Hmm.
It was, the property comes under the purview of PTCL.
That's the case of the plaintiff. That is
Yes,
the-
yes, it is part of the plaint. Even the impugned order records that. It's
Come to that order.
page number 26, para number 26 of the. It is true that in the plaint, there is a clear mentioning of land coming under PTCL.
Please come. Land counsel, the petition submits that the suit is filed for specific performance, and the property in question is which will come under the PTCL Act. In spite of recording such a finding, the court has refused to entertain the application on the ground that there is consequential relief of, there is another relief of refund of amount. It is submitted that when the suit itself is not maintainable, the court ought to have rejected the plaint, considering the sufficient stay. The same memo by 10th, or else the stay granted with this court stands vacated. Yes.
Published.
26, Lakshmi Kant case. Petitioner.
For the petition, madam. Order 7 Rule 11, my lord, has filed before the trial court for rejection of the plaint, my lord. On the ground that, my lord, the suit for the declaration possession was filed by the plaintiffs on in voice number 55/2003, my lord. In that suit, my lord, the prior one is considered that they are entitled for a declaration that the trustee is the owner of the property. Insofar possession is dismissed, my lord. Without challenge the judgment, my lord, they have presented the second suit, my lord.
What was the finding with regard to possession?
Insofar as the finding that, my lord, the trustee is concerned, my lord.
It declared that so and so is the owner of the property.
Please.
Who is the owner of the property?
The trust is on Ramalingeshwara Swami trust is said to be
The
property.
So their right to property is declared.
Please.
What is the other pair? Seeking recovery of possession.
Possession of the property.
Then what was the finding?
The finding that, my lord, the possession is concerned, my lord, they ought to approach before the district court filing a 92 CPC on by reasoning that ground, my lord, possession is dismissed, my lord. Against which, my lord, they didn't challenge before the higher court, my lord. Now, my lord, they are claiming the possession of the property by filing another suit, my lord.
So claiming?
Claiming possession of the property by filing the present suit.
They mention about all this in the plaint.
Yes, my lord. But
Let's look at the plaint.
page, my lord, 14, my lord. Second para, my lord. After the death of D. Venkatanna, the first dependent, who is the daughter of D. Venkatanna, claimed to be gift the property in her favor and claimed exclusive right over the shooter property. The public of Jangarmali so-and-so village were obliged to file a suit representative capacity on behalf of the public so-and-so in OS number 55/2003 on the file of civil judge so-and-so, claiming that the property to be temple property from so-and-so. The suit was decreed on 22/10/2000, declaring that the property belongs to Sri Ramalingeshwara Swami temple. But, my lord, they are clever drafting the plaint, they suppressed.
Where is the plaint? Where is the judgment?
Judgment is.
Is it filed not? Is it filed along with the plaint?
They have not at all filed. They have
There
suppressed.
is occasion for the court to see the judgment and decree.
My lord, in that, my lord, subsequent that, my lord, the judgment in OS number was not challenged and it became a final. Now, my lord, the prayer.
They were not saying all that. They only said the suit is decreed. What is the suit for is also not mentioned.
That property, declaring that the property belongs to Ramalingeshwara Matta.
They never speak about the recovery of possession. And,
now, my lord, they are claiming that the recovery of possession, my lord.
What you are saying is in the written statement, nothing has been stated in the plaint. And know what are the documents that are filed along with the plaint? They have filed a judgment and decree.
They didn't. Because, my lord, the recovery of possession is concerned, they need to some cause.
So that you can on the maintainability of the suit, that will be decided in the suit. Under order 7 rule 11, no, we can't look into it. That is not filed by them. Document is not with it. And in the plaint, they do not say about what you have said now. That submission with regard to 2 reliefs, one is decreed and the other is refused.
Please, they might have filed the judgment of the earlier suit, my lord, before that.
It's not produced along with the plaint. Then how will the court see that?
Along with documents, my lord, they
Have not. They have produced?
A list of documents, along with list of documents. Their claim is only based on that judgment, my lord.
No, that is what I am asking.
Please.
This particular judgment and decree
is produced
is
before.
part of the plaint.
Please, Your Honor.
Along with the documents.
Along with document. Their claim is only based on that judgment.
That is how many documents are produced along with the plaint?
List of document, I need to apply certificate.
Get it. This is matter. On when can you get it?
1 week.
This is matter on 2nd of July.
Next matter is also same.
27.
Please.
Yes. No representation. Is this matter in the month of September? Is 29.
27 is also Lakshmikant case.
20? And same 27. 28 I said.
28.
To appear in 28. Yes.
28.
I am appearing for the petitioner.
28.
28. But 28, I pray to appear for the respondents. But I pray for a short accommodation to file statement of objections to the application seeking stay. Because many documents not in which he relied upon has not produced, including the miscellaneous petition filed by the respondent and other connected documents.
All that are filed along with the
They are
plaint.
not filed. I'll place.
No. All these documents which you are referring,
Yes,
they are filed along with the plaint.
No, I have filed the plaint. I am the plaintiff before the court below.
They are not produced.
They are
sir.
not produced. I'll produce it along.
File all the documents, whatever you have filed along with the plaint. This is matter.
and 25.
This is matter on 6th of July. Yes,
My
next.
My lord,
Till number
6th of July.
6th June.
July.
July.
Yes.
29.
The request of learned counsel for the respondent. Yes.
Now, petitioner is aggrieved by judgment and decree passed by current trial court in SC number 121 of 25. Suit
is
is
the
for
order?
recovery of money, my lords.
What is the amount?
Amount is 1,20,000.
50% deposit.
Please, my lords.
The petition is agreed with the judgment and
Six.
decree passed in SC number 121 of 2025. It is submitted that the court has failed to appreciate both factual and legal portion and decreed the suit. Suit, and it is submitted that they have a strong case and they're likely to succeed in this appeal, in this revision petition. Considering the same, they shall be stay or fall for the proceeding pursuant to the judgment and decree and so, on the condition that he shall deposit 50% of the amount. That is, it would be how much? 60. And they shall be stay or fall for the proceeding on the condition that the petitioner shall deposit 60,000 within a period of 4 weeks.
6 weeks, my lord.
6 weeks or else a stay granted by this court stands vacated. Notice to the respondents. Yes, next.
Till number 30. Linguraj K.R.
No, because nothing is pending.
Petitioner, my lord. No, it's defendant number 4 and 15, 14 and 15 are before this court, my lord. My lord, suit for partition, my lord, suit of the year 2016. My lord, suit came to be dismissed for default when the matter has been put forth for plaintiff evidence PW1. My lord, on 4 occasions time has been granted for a kind perusal, my lord. What a conduct of the plaintiff, my lord, a relevant portion of the order sheet.
So what is the IA?
My lord, mispetition has been filed, my lord, for restoration of the suit, my lord. My lord, before that, kindly see the order sheet, my lord.
And see, that
Kindly
came to
see.
be allowed.
Now that is allowed. My lord, there are 605 days delay. Delay is not satisfactorily explanation.
The order, come to the order.
My lord, before that, my lord, kindly came to the mispetition, my lord. What is the reason given in the mispetition?
No, that would have been discussed in the order. Now we are at the admission stage, so that kind of a detailed analysis is not required. Come to the order, we'll understand from the order.
My lord, page, my lord, relevant page starts from, my lord, page 22.
Para 12.
Para 12, my lord. On perusal of the order sheet, exhibit P1, said suit was set down for cross-examination of PW1 on 17/11/2021. On the day PW1 and counsel not appeared and no one represented the case, and finally suit was dismissed for default for non-appearance. The PW1 thereafter, the petitioner have filed present petition on 15/7/2023. The petitioner contended that they are doing coolie work for their livelihood and going to different places and districts for coolie works. They were not attended the courts on the date of hearing, and their advocate is also not appear and engage in the other court. So the suit was dismissed for default on 17/11/2021. The respondent number 1 and 3 not contested the case. Respondent number 14 and 15 alone filed the objection to the main petition as well as IA. In their objection, they denied the entire petition amendments and affidavit, and in cross-examination, PW1, she deposed that herself and other petitioners are not educated persons. They are doing coolie work in landed properties and other properties, also doing coolie work in different places. They went to coolie work. No one appeared in the suit, and it was dismissed for default. PW1 deposed that on 17/11/21 she went to coolie work, so and so.
Can you take notice, we'll see?
My lord, my respectful submission, my lord. In mispetition, my lord, they take a contention. They are not present in the village on that day. My lord, in evidence, when the same question has been put, my lord, they say, yes, we are in the same village We are in the same, in the village. And also, how is the relationship with your brothers? Even then say, yeah, we are cordially.
Consider it
My lord,
once the other
my
side
lord,
comes.
now suit has been restored. My lord, in suit, my lord, they are pursuing for, therefore I seek interim order, my lord, further proceedings.
Notice to the respondent, petition is permitted to take out hand summons and file a memo to that effect by 3rd of July. If the memo is filed, list the matter on 6th.
My lord, interim order, otherwise suit is going to be,
10
my lord,
days.
suit is going to be prosecuted that one.
Yes, what will happen? Nothing will happen.
My lord, insofar as my lord, other, my lord, petitioner respondent number, I seek dispensation of notice to, my lord, respondent number 7 to 19.
Memo is filed. Give the memo.
I will
Seeking dispensation of notice to 7 to 11 dispense with. Petitioner shall serve the hand summons on the council appearing for respondent 1 to 6.
6. My lord, for limited, they are pursuing for, my
No,
lord,
nothing will happen even if they
Please.
pursue. Yes, next.
date,
I have given the date. If you file the memo by 3rd, it will list on 6th.
please, my lord, please.
32 for orders, Anupama board on the
Lord's copy has been served. I have filed affidavit also.
Memo dated for having served the hand summons on advocate for. You have a stay in this.
No, my lords, that's the reason my lords have directed us to take hand summons.
It's already recorded by the court that you have served the hand summons.
Yes, sir.
32.
Ah.
I am filing Vakalat on behalf of respondent 1 and 2.
File it before the registry.
Minute.
So and so submits that he has instructions to file Vakalat on behalf of respondent
1 and 2.
1 and 2. List this matter on 30th
Cell number 33.
in the first list.
Cell number 33.
But I may be permitted to take notice to the council for respondent number 1 and 2 are the plaintiffs before the trial court, my lord. So for other respondents are concerned, I filed dispensation application, my lord.
Memo is filed seeking dispensation of notice to R3 to R6, dispensed with at the risk of appellant. Then who remains?
Respondent 1 and 2 are the plaintiffs before trial. I will take
Respondent
to
1 and 2
council.
petition is permitted to take out hand summons and file a memo to that effect. If the memo is, once a memo is filed, list the matter on 4th of August. Yes, 34.
Cell number
34 I appear for the petitions. It's a impugned order is a common order, my lords. I have only challenged the order on IA number 4.
What is non-compliance of office objection?
That was a office note which was written by me, my lords.
Where is that?
Annexure A is a common order, but I'm only challenging one of the order.
No, there are so many.
Because that and all are complied, my lords.
It doesn't appear so.
All the office objections were complied. Only one submission was written on.
Office note, there are about 9.
Please, minutes.
Thereafter, it went before the
Register.
registrar.
Please, minutes.
Council appearing on the appearance. So, however, 3 weeks time is granted for compliance of the office objection. Then after that, there is no note.
Whereas that office objection which was.
Then the following objections had to be complied. Single WB filed against more than 1 IA to be clarified, court fee to be paid.
That is the malus. That is already been paid. 100 rupees court fees is paid. The orders is passed on 2 IAs, but I'm only challenging 1 IA. IA number 4. That was the objection which was pending.
Office has raised an objection that the writ petition is filed against more than 1 IA. Then council submits that he is restricting the
Prayer only
to I number
4 minutes.
I number 4. And he has already paid the court fees and all the office objections are complied with. Office council submission is taken note. Yes.
Minutes.
And accepted by the court. Yes.
This is a suit for eviction minutes. I was a tenant. So I lost the suit in the trial court and I had.
Order notice?
Minutes?
Notice?
Minutes. This, I'll just submit minutes. Then.
When is the writ petition filed?
Writ petition is filed on 5th September 2025 minutes. This
That
matter
means
can
there
be
is- that
disposed.
means-
That's the reason.
That means there is no threat to, there is no
That's the reason.
Requirement of interim order.
That's the reason I said this matter can be disposed of. I'll just make submission.
No, without their presence, how can it be?
I'll just submit the fact, then my lords may decide.
No, we have to, if I have to dispose.
May not be.
Why? What is
I'll just submit.
No, what is the relief you're
Order 21, Rule 26 application was filed saying that stay the execution until the RFA is heard. RFA is now dismissed. I have to go to the Supreme Court. That's all is my submission. That's the reason I said I.
Where is the order?
Well, its order is at page number 20, my lords. Operating portion is at page number 22. It starts from 20.
The petitioner is agreed with the order passed in I number 3 and 4 in execution number 1169 of 2025. In this,
I'm only challenging on the 4. Page number.
Not agreed with the present petition is filed, agreed with the orders passed in I number 3, I number 4 in execution number 1169 of 2025. The JDR number 2 has the petition up here in who is the JDR number 2 has filed IA number 4 under order 21 rule 26 to stay the further proceedings to the disposal of RFA number 11402 of 2025. And that came to be dismissed by order impugned.
Order dated 9/6/2026, my lords.
By order dated 9/6/2026.
26.
But it appears to be 5/8/2025.
Now it's dismissed, my lords. It's filed in 25.
No, order 5/8/2025 is the order. No, you're talking about the RFA.
Please, my lords.
The court has dismissed the same. Against that, the present division is filed and counsel for the petitioner submits that the RFA itself is dismissed. RFA itself is dismissed.
Please, my lords.
Dismissed by judgment and decree dated
9/6/2026.
9/6/2026.
Now.
9/6/2026. Hence, this writ petition has become infructuous. As the RFA itself, no, it has become infructuous.
May not be my submission, my lords. Let it be the order of the court.
It's submitted. Considering the fact that the IA itself is filed to stay the RFA, when the RFA itself is dismissed, the writ petition has become infructuous. Hence, the writ petition is dismissed as infructuous.
Grateful, my lords.
Yes. Tell that
advocate
Serial number 35, my lord, lordship. I am extremely sorry, my lord. Early morning, my lord, lordship has granted 2 days to comply the office objection, my lord. My lord, may permit me to withdraw the petition, my lord, file the 2 petition because I have challenged the 2 IAS, my lord, in 1 writ petition. I have paid the court fee in 200, my lord.
Where is the memo?
My lord, I'll place on record, my lord. I'll do needful today, my lord.
Pass over, ask your to give the memo.
Please, ma'am. Please, ma'am. Highly obliged, my lord.
Pass over?
Please, my lord. Please, my lord.
Yes.
Cell number
Please.
36, B. Manjunath.
Lords, petitioner is challenging the orders passed on 2 years, which is common orders. The objections were also common. 2 recalling applications were filed by the petitioner, which has been rejected. It is the common order which is passed on the same day. Lords.
That's the objection.
That's only the objection.
The petition, it is submitted that the petition is filed against the common order passed and officers raised an objection. Considering the fact that it's a common order, office objection is overruled.
Lords, this is the MC petition which is filed by the respondent, Lords, for under section 9 of Hindu Marriage Act. The respondent the petitioner in this case has taken specific defense that the respondent is having illicit relationship with one Ranjit. So he has filed an application under order 16/6 for witness in the evidence, at the stage of evidence. He has filed an application under 16/6 to witness the Bharti Airtel company to give the details of the particular number, the Ranjit's number and also the respondent's number. So that application came to be allowed and the witness summons was issued to Bharti Airtel company, my lords. After that.
Why these matters have, this is before which court? Family court. Why this WP has come? It should be GMFC. It should be numbered as GMFC against an interlocutory order of the family court.
Yes, ma'am.
This writ petition is filed against order passed by the family court, against an interlocutory order passed by the family court. And the writ petition should, the registry should have numbered this as GMFC, but not GMCPC. Yes,
Cell number 37.
petitioner, you have filed it as GMCPC. The petitioner shall carry out the necessary corrections. Yes,
Cell number 37. P. Madhusudan. Adina.
yes.
I have filed Vakalat for respondent one, my lord.
Only one.
Only one.
So and so submits that he has instructions to file Vakalat. And you have already filed.
I filed yesterday.
So and so has filed
Only for R1.
Vakalat in Vakalat on behalf of R1. Print the name of so and so. Then what about the others?
Others, the petitioner has met with an accident, leg fracture, is bedridden. He requires at least 4 weeks to come to Bangalore to 60 kilometers. 4 weeks to come to
Petition
Bangalore.
with the plaintiff.
One submission,
Petition is-
affixture paper notification is required. So affidavit he has to sign. So 4 weeks.
Petition is unwell,
Not unwell, suffered with an accident. met
suffered
an
with an accident. List is matter after 4 weeks. Yes, 38.
38. P. N. Harish.
But there are two IAs, my lord. What has happened is I filed an application under Order 26 Rule 9 that came to be rejected. Then I filed an application to review the said order. So both are interlinked. According to me, subject to your lordship.
What is that?
I filed an application seeking appointment of court commissioner. That came to be rejected. Then I filed an application to review the said order. That is also been.
They are two different orders.
But they are all interlinked, my lord, because I cannot challenge it independently because each one of them has to be.
The petition
merged
office
with.
objection with regard to office objections or sustained petition shall comply with it. Yes, next.
Cell number 39.
Lord, what week time may kindly be read so that I will.
A week's list is matter. The office of objection shall be complied with by 25th of June.
Please.
List is matter on
First-
30th.
first July, first.
1st of June, yes.
First of, after 1st of July.
1st of June shall be complied with by 1st of June. List the
1st of
matter on
July,
6th of
July.
Okay, 6th of July. It shall be complied with by 1st of July. List on 6th of July.
Please.
Yes, 39.
39. Purushottama H.
My lord,
My
I am
lord,
for
I
petition.
undertake to appear on behalf of respondent number 2, my lords.
Yes.
I appear for respondent number 3, my lords. I undertake to file Vakalat, my lords.
Land
Fun-
council
in the
so
name.
and so submits that. You have filed Vakalat?
We'll be filing, my lords.
Mr. Samarth M. Raju submits that as instructions to file Vakalat on behalf of
Respondent number 2.
respondent number 2. And what about you?
For respondent number 3, my lords, Santosh Nagrali, my lords.
So and so as instructions to file Vakalat on behalf of respondent number 3. Registry is directed to reflect their name in the cost item, in the cost list. This is matter. When do you want?
My lords, only
Maybe
one.
Monday, my lord. Monday only.
Only one submission, my lords. In this, the petitioner, what the OF which they're seeking, my lords, it have been disposed, my lords.
No, my lord, it is not been disposed.
Monday.
Yes,
Monday I'll
please,
hear
my
it.
lord.
Monday. Serve the papers on both. of
Please,
them.
my lord.
Cell number 40.
Then counsel for the petition, serve the copies of the
Name
petition. Yes, 40.
Cell number 40. R.R. Hiremat.
No representation. Does this matter after in the month of August?
Cell number 41.
For petition, my lord.
Also maintainability.
This also is 42.
Cell number 42.
Same, my lord.
Vinod Kumar S.
For petition, both are same, 41.
Yes, same.
Cell number 43.
No, he's saying something. Yes, Mr. Vinod Kumar.
My lord, serial number 40, my lord.
42.
40 and 41. Both are same.
41 and 42, yes.
Ready, my lord.
Yes.
Maintainability. My lord,
What is the order impugned?
My lord, FDP is dismissed, my lord. For inexecutable decree, the reason is quoted, inexecutable decree, it is dismissed, my lord. The previously, the father of the petitioner is filed a suit for partition, my lord. That case was decreed. After that, father of the petitioner filed a FDP proceedings before the court below. But court below is findings are the property is residential property. Item number 1 and item number 2 are the
residential property, it is between the 1,200 square feet. The
No, no,
preliminary
FDP is it is dismissed.
dismissed, yes, my lord.
Against that, how can you file a CRP?
227 is, the court below is over judicially error, my lord. They can't
So it is
dismiss
an appeal, it is not an appealable order.
without jurisdiction, they can dismiss the matter, my
The
lord.
office objection with regard to the maintainability is upheld and the petition is disposed of giving liberty to the petition to file the appropriate remedy. Yes,
42.
both.
40 and 42. 41.
Yes. 40 is also the same.
No, my lord. 41 and 42.
Yes. 43.
43, serial number 43, Naveen Jayan.
That's a week's time, my lord.
Notice to the respondents. List this matter after service of notice. Yes, 44.
44.
Please, Lord, it had
Because,
come up the other day.
Lords,
The petition,
seeking
my
a
lord,
short, my lords, seeking a short accommodation, my lords. We have engaged the
Have an
senior
interim
counsel.
order?
Lords, the interim order is I want stay of further proceedings because I've been directed to pay an undisclosed amount.
My lords, seeking short accommodation, my lords.
This
We
is the
engaged
third
senior
time they're
counsel.
asking for time.
My lords, as a last opportunity, my lords,
What is,
address our arguments.
Lords, they filed an execution petition in
No,
2015.
you're saying that interim order of this court or the trial court order you're talking about?
Lords,
Undisclosed amount.
the order of the trial court,
So anyhow, that is state.
that is not yet stayed, my lords. I'm praying for stay. If they want time, let them take time, but let that. Lords, the order begins at page 51.
44.
Yes.
The order begins, my lords, at page 51. This is an order in an execution petition. And the operative portion, my lords, is at page 89. Operative portion, my lords, at page 89. Within 3 months, I have been directed to pay an amount that is not ascertained in the order of the executing court, much less ascertained in the decree.
Lords, I'm
I'll give
seeking
you
for
a short date. Let
short-
this order be stayed.
Please.
The then counsel for the petitioner submits that the court has passed an order.
My lords, a passover, my lords. I would
Pay
request.
the license fee royalty amount from 2011 to
My lords, I'll
2000
request a passover, my lords. Please kindly pass over the matter, my lords.
till the period it has remained unpaid to the decree holder with interest at the rate of 8% per annum with 5% VAT till its realization. It is
Lords,
the,
my lords, page number 69, my lords. Our stand is there, my lords.
no, but that should reflect in the order.
My lords, they've agreed, my
No,
lords.
what we do is we'll set aside this order and send it to the court. Let the court determine what is it. Court can't
Lords,
pass orders
give me a
like this.
short
Can this
passover.
order be executed?
My lords, give me a short passover, my lords. I'll take instructions and come back. Passover, my lords.
Yes.
Serial number 45, Ganapati Bhatt.
Please.
Senior counsel comments the argument. Senior will come and join.
Please,
Yes.
Senior counsel will come and.
please.
Yes.
May it please, madam. The petitioner is challenging my lord, the order passed in MFA. MA number 23 of 2026, whereby my lord, injunction order on IA number 12 was dismissed by the trial court.
Trial court has granted injunction in your favor.
Trial court, no, my lord, I am defend number 1 and 2. Plaintiff filed application, my lord, initially IA number 1 and 2 for injunction not to alienate all those things, my lord. So all were dismissed. Finally, one of the IAs was taken before the.
Court has reversed it.
No, my lord, one more aspect. 1 and 2 were dismissed by the trial court. Almost same relief, not
What
to
are 1
alienate.
and 2?
1 and 2 for also, my lord, not to alienate and not to put up construction. That was dismissed. May I beg to directly take to 151, my lords? Just I will tell once, before your lordship. 1 and 2 were dismissed. Honorable High Court said, don't encumber the property, don't alienate. In MFA, this all court said so. That order was in force. That's all, my lords. And now, one more IA is filed, IA number 12.
No, encumber means?
Not to alienate the land. Alienate
So,
the land.
one IA is granted.
no, my lords, I will have to read the order correctly because our honorable coordinate, which is your lordship may kindly discuss. My words may not reflect. Directed not to alienate, encumber or create third party rights. Create the
So
third.
this, you said one is, IA number one is?
IA number 1, my lord, was, my lords. One nimisha. Please, my lords. The IA number 1 was filed, my lords, seeking an order of temporary injunction restraining defendants from alienating this short property. Alienating.
So in MFA, that order is granted.
In MFA, that alienation not
Then
alienation.
next is IA number 2,
Yes.
not to put up.
And IA number 2 is filed, my no, IA number 2 is filed not to change the nature of the property. That MFA is pending. That order is also challenged.
No, not this order. Let us see that order. MFA order.
Order of the Honorable Trial Court, my lord.
No.
Of this Honorable Court, my lord. Yes.
Page number.
Two different IAs, my lord. I beg to humbly submit there are two different IAs filed, IA 1 and 2. Two different MFAs are filed. Now kindly see MFA, first MFA, 165.
Now, in view of the urgency pleaded, both parties are directed not to alienate, encumber, or
Yes.
create third-party rights. So
Yes.
what is left is now the
Construction.
construction.
Construction
That's the
only.
change
That
the
as far as
nature of
construction is concerned, they filed one more IA, my lords. IA 2. IA 2 was dismissed. As against that, the MFA is filed next page 166. That MFA, there is no order not to put up construction, my lord. 166. It's directed to be tagged along with the another case. Now, my lord, they filed IA number 12. Not to put up the construction. IA number 12. IA 1, 2 is over. IA number 12 they filed again.
No, not to change is IA number 2.
How?
And not to alienate is IA number 1.
IA number 1 is
Not to alienate.
alienate. IA number 2 is not to change the nature. Change the nature means including it includes the construction.
Construction also.
Yes,
won't-
IA number 2. Both are now subject matter of two MFAs.
In one MFA, order is not
Yes.
granted.
Thereafter, IA 12 is filed. IA 12 by a reasoned order, trial court dismissed it. Reason for dismissal, my lords, is that 183 is the order on IA number 12. Trial court frames, I am reading it because, my lord, appellate court's jurisdiction in case of IAs, my lords, is very limited unless the order is very perverse. Appellate court cannot interfere, my lord, in respect of such interlocutory orders, my lords. Page 184. The trial court frames the proper issues and finds it negative.
No, this order is dated.
This order is dated 21st February 2026.
MFA order is dated.
MFA order, my lords, is 27 1/3/2023.
27,
3/2023.
2023.
2023, my lord. That's MFA 1018 of 2023. And the other MFA is tagged along with that.
So IA number 12 is filed after 3 years from the date of the earlier order.
Please, my lords. Earlier order. And the reasoning is that certain property was agreed to be sold, my lords. The suit was one for specific performance.
I think we can read from para number 12.
Para number 12, my lords. That being their case, admittedly, defendant number 1 and 2 have not denied the execution of the agreement of sale in favor of the plaintiffs and the social property on 9/10/2002. They have also not disputed the receipt of the amount of rupees 4 lakhs from the plaintiffs. They have disputed the receipt of other amount as claimed by the plaintiffs, contended that since the plaintiffs did not come forward to get registered sale deed in the year 2013, they have issued notice to them by terminating the agreement. It's our case, my lords. The social properties have been developed and alienated to purchasers. Your lords may kindly see it has already been developed. Several portions have already been sold out also. Disputed construction is completed by raising loan. The one construction being done now by us. Therefore, it's clear that execution of the agreement so and so, receipt so and so in favor of plaintiff and receipt of 4 lakhs as advance amount is not in dispute. Further dismissal of IA 1 and 2 filed by plaintiffs in respect to social property, filing of MFA so and so grant of an order by the Honorable High Court restraining from alienating, etc. are not in dispute. Photographs produced by the plaintiff show that the construction of the building in the portion of the scheduled property has almost reached up to G plus 4 floors. As per sketch plan, there would not be further more construction on said building except final finishing as submitted by the learned counsel for the defendants 1 and 2. They further stated that the said construction started in the month of March 2025. Plaintiffs have not approached the Honorable Court at an earlier stage and filed a present IA when construction is almost completed up to G plus 4 floors. It appears that there is some force in the said content. Plaintiffs are not appeared at the initial stage, hence it's open the contents so and so are not acceptable, etc. Then, my lord, para 17, not entitled to temporary injunction. Para 18 also, your lordship may kindly see. By answering the finally under the above circumstances, defendant number 1 has contended that they had issued a notice the plaintiff and terminated the agreement in the year 2013. Whether it is legally terminated or not is a matter of trial. One aspect, your lordship, now it's.
I understood what is, I've seen.
Please, 2020 is the suit, your lordship.
Then come to the.
Conclusion.
MA, I've seen MA.
50% to be deposited, my lord. They said I deposited. Trial court says, my lords, that amount you deposit 50%. We immediately deposit at 50% subject to the further orders. The MA order says there is already trial courts order. Please, my lords.
Page number 76, para 35.
Please. 35. However, perusal of the materials available record trial court had made observation that if 50% amount would be deposited would be kept. If at all the plaintiff failure to terminate. This observation clearly goes to show the trial court has not properly appreciated the facts of the case. This case, it is undisputed that there was an agreement between the parties, even payment of the part amount is also under dispute. The shows the transaction was not in dispute. However, the defendants contended they sent a termination notice, it served. However, it is a matter of trial, where it sent or served. If at all it was served, then the plaintiff kept quiet is a matter to be considered during trial. But the trial court observed that already the defendant had put up commercial complaints, sold us some of the portion to the customer, shows that the trial court has not looked into the order passed by the High Court, wherein the parties were restrained from alienating the property. That's all done earlier, my lords. All these alienations were done earlier to the High Court's order, not earlier, not later. Further, when the contents have been dished that they have paid, so and so is nothing but major portion of the payment. This 23 lakhs is deposited.
Yes.
So they say where they deposited.
Yes.
Those,
No, like
stuck in four.
now you have there is an order, your rights are protected, where there is an order in the MFA not to alienate, not to encumber. No, you have filed this application when they have come almost completed 4 floors. Suit is of the year
My lords,
2020.
that they will create third party rights, my lords.
That is, there is an order in MFA, how will
I
they
can't.
create third party rights?
My senior will come, my lords, please, my
The
lords.
rainy season, kindly see the photographs, my lords. D2 onwards, photographs. How I will suffer. Complete construction is there. All the photos.
Will allow the MA.
I will not alienate anything. I will not create any.
Lords, my lords, 2:30, my lords, he's held up in court on 4, my lords. 2:30 only, he'll, first year only will be here, my lords. First matter, please, my lords. My apologies, my lords.
Both the senior counsel shall pay the cost for wasting the time of the court on 4
My lords,
occasions.
he's just held up
On
in
one reason or the other.
court on 4, my lords. He said that let senior counsel argue, he'll come and join, my lords. Sorry, my lords.
Over how much it will take? Is it a first appeal that it will take 1 hour? Does this matter at 2:30? If 2:30 it won't turn up, I'll allow the appeal. I'll allow the petition. Yes.
Dates I have clearly mentioned in the synopsis, please, my lords. For my lords can consider.
Yes, I understood. Yes.
I'm great.
2:30, I'll be.
46, admission 46, Gopal Singh.
Counsel for petition in this case.
Respondent is kindly prepare for 2 weeks time. I have not been served with the copies of the.
My lords, I have filed an IE for a stay. Actually, this is an ejectment suit. My lords, in this, the trial court have not considered the latest will, which was done by my father. Actually, here, my lords, the basic principle that is in the ejectments on the ownership tenant relationship. Neither I am the owner nor I am in the possession of the property, which was not considered by the trial court, my lords. And my lords,
When is the judgment and decree?
please not.
When is the judgment and decree? Date of judgment.
Please not.
It's on 5th February
5th February
2026.
Please not.
You are directed to give the position within 2 months.
Please, my lordship, but
Expired.
I'm not in the position, my lordship. I'm never was in the position.
Then why are you bothered if you're not in position?
That's true, my lordship, but actually my brother is there. And that's Parasmal, in whose name the property is. My brother, actually, there is another connected case for this. My brother filed it.
What
before
is
this
that
court.
number? We'll have it after 2 weeks. List along with so and so, give that number.
Please, my lordship.
Yes.
Cell number 47. 47, Vinayaka, yes.
No representation, less than the month of September. 48.
48.
I represent the second respondent, my lord. My lord, I have not served with the notice, my lord. I've been waiting.
Papers are served on them.
Inform it served.
He says it is not served.
Second respondent, my lord. I have not served with the notice.
We will. I'm informed, my lords.
Serve the papers on them.
Please.
The petition, serve the copies of the writ petition on the respondents. Is this matter on 7th of July? Is 49?
Cell number 49.
Ma'am,
Let them not, my lords. It's a case where we have prayed for a dismissal or rejection of the plaint. Let them not precipitate till then, my lords, because they are the case. Because
You appear?
48, ma'am. NOC I've taken from my lawyers. I have to keep new counsel, ma'am.
7th July, 48.
let them not precipitate till then, because the
No. What is
the
respondent number?
Madhvi defendant.
she's a plaintiff.
Huh?
She's the plaintiff. She's the plaintiff.
Respondent number 1.
How?
Respondent number 1 submits that she has taken, the party is present and it is stated that they have taken, she has taken no objection and seeks time to engage the advocate. Is this matter on 6th of July?
Please. Because if
6th of July.
So please let 6th of July. Let her not precipitate, my lords.
What?
Because suit, my lords, we have prayed for dismissal of the rejection of the plaint. That has been rejected because suit is beyond the period of limitation. The trial court holds, my lords, the period of limitation. The prayer is to set a sale deed. It will be, my lord, 3 years. The trial court holds, no, there is also a prayer to declare her as the owner, etc. It's a consequential prayer. The trial court holds, therefore, it's 12 years. That is clearly against the decision of the recent decision on the Supreme Court. On the Supreme Court said, you have to see what is the main prayer. Main prayer is
what
this.
will happen? Nothing will happen.
Please.
Yes. Engage advocate. Yes.
My apologies, my lords. The previous matter, my lords, because 2:30 there is a special bench before Court Hall 4. My apologies, my lords.
Cell number
Lords,
45. Pass over matter 45.
It's only on a short ground, my lords. I understand what my learned senior friend is saying.
No. What, having heard the learned senior counsel, subject to what you say, the view of the court is, so suit is filed in the year 2020. They have constructed, it has come to 4 floors or 5 floors. In MFA, your rights are protected, where there is no stay of alienation, encumber, everything is given.
Lords,
If he complete the construction, what will happen?
Lords, if he undertakes that he will only complete the construction and not create any third party rights, then, and he should not claim equities.
No, your last any
That-
third party
The
rights in
Supreme
the
Court
sense, my lords.
says third party rights can't be created. That there is already an
That much
order.
you have to say, that we have to record.
Please.
Because you shouldn't claim equities.
And he should not create third party rights.
My lords,
Lords,
only one
they
submission,
can't
my
let
lords.
out the properties.
No,
It's a suit for specific performance. They can't.
They are not going to. They are not going to sell it to anybody.
No.
The problem is the bank loan. Yearly lease has to be given, otherwise it will be vacant, my lord. Huge building, 4 floors building, my lords. Lease out the premises, my lord, on a yearly basis. Otherwise, we can't pay back.
There is already an order.
We are not going to sell it.
There is already an order. They can't do that. The reason why the court has
If at all
granted
you want
injunction
all
is
this, you have to seek clarification in the order
That-
passed in
that order
MFA.
they'll have to seek
That
for
liberty your lords may,
Concern.
that liberty your lords may grant, my lords, from
As far
that
as,
aspect.
as far as this is concerned, you can go ahead with the construction and you shouldn't alienate the property.
Please.
And you should make the construction and subject to the orders passed in MFA.
My lord, as far as alienation, your lords may kindly permit me to make prayers.
When I say subject to the orders in MFA, when you go to the MFA, you can
That's
ask
for
the sequence.
alienation is subject to there, my lords. Alienation is subject, my lords.
Cannot be subject. Lords, may kindly see page 77.
No, he is bound by the orders in the MFA.
Yes,
That is
I
what the
undertake,
court
my
has-
lords.
That is the reason
Simple
why I
one
said, my
sentence I
lords,
beg to submit.
now-
I will be bound by the orders of the MFA court.
It is something like this. Lordships may kindly see page number 77, why this order has been passed. Their argument itself, even now their argument is that if I don't lease out this property, there is no way that I am going to clear the bank loan. That is the argument which is made before the court. What prevailed upon the wind of the trial court to pass an order of the kind is, the object of putting up of construction is to create third party rights. If this is the object of putting up construction, I can't permit you to put up construction in violation of an order which you are already suffering.
No, but that doesn't appear
Page,
to be the
page 30,
findings of the appellate court.
Lords, kindly have a look at page number 77, my lords, para 36. That is the reasoning.
Anyhow, my lord, now I am informed, my lords, the construction itself will take at least 6 months, my lords. Now only pray, my lords, only for the construction, my lords. I am not going, cannot alienate. In the meanwhile, I will take necessary steps, my lords. My only prayer is for that aspect.
36,
The impugned order, to that extent, my lord, MFA order will remain. Impugned order, my lords, your lords may kindly set
But if they don't make a statement that they are not going to let out this property, there is no way that
There
the
is already
construction could
an
be put
order.
up for this reason. Because their entire case before the trial court, and even as they advance their arguments before this honorable court, is that it's a commercial complex meant to be let out to third parties.
The teeth of the orders passed in MFA, can they do it?
Lords, the reason is, kindly have a look at this. That's the object with which they are putting up the construction. Para 36, page 77.
No, that's why I'm saying, I'll make it clear in this order.
Your
In the
lordship
light
may
of the
observe in the order that
Order
they
passed.
can't create third party rights in terms of the order passed, and they should not claim equities.
Bank
Because
loan
what
is already
happens-
there. I wish to make,
No,
bank
my
loan is
lords-
already there, they can't say. And
lords,
one more
I-
aspect, my lords, I have not, we have pleaded it.
They
The
can't
order
claim
of the-
equities.
The
Lords,
order of
now
the-
they can't put up
Your
a
lords may kindly
construction in
see-
respect of a specific performance suit. Number one, if they want to complete the construction, they can't create any third party rights or induct any person in possession of the property, and they can't claim equities. With that observation, lords,
My lords,
dispose.
the one more aspect we have pleaded, my lord. In fact, the honorable district judge, my lord, city civil court, my lord, had no jurisdiction, my lord. The matter, the territorial limit, the pecuniary jurisdiction, my lords, lie directly to the honorable high court, my lords. Still, the appeal was entertained.
That is
Appeal should
because
not
there
have
was
been
an order
entertained.
of the coordinate bench.
Yes, yes. That has never
What
been
hap-
kept in abeyance.
No, that is not state. The problem is this, because I am appearing in that matter. The Civil Courts Act came to be amended. The jurisdiction to entertain a miscellaneous appeal, which was otherwise by this honorable court, was relegated to the district court. Now we filed an appeal before the district court. Now, whether it was maintainable or not, when this question was being considered, a coordinate bench of this honorable court upheld that validity of the legislation. Now that is before the division bench, but the division bench has already passed an order of status quo. It has not stayed the judgment of the trial
So
of
the
the
effect is, my
learned
lords,
single judge.
effect is, only the high courts have jurisdiction, my lords. The
No, no,
three
no.
judges do
Effect
not have the
is that the
jurisdiction at
validity
all.
of
I have
the
raised that
statute
ground.
remains.
Ultimately,
On merits,
what
they are
the
getting an
order
order.
is-
You
Yes,
should be happy about it.
is what the order
Please,
is
please,
disposed
please, ma'am.
of. I'll pass the order.
Lords, it's grateful. Lords.
Grateful.
49.
For KV respondents,
Yes.
KV complete copy has not been submitted. May I take a next week, not go on with the matter.
I'm ready in this matter, ma'am. It was
So
served,
the papers on him.
I served on them.
Complete papers has not been served. That is my submission,
This
my
is
lord.
wrong submission.
This is not, I have the papers.
So the
Allah,
papers
11th,
on-
11/6,
Complete papers have not been
2026.
served. That is the
What you have served
request.
on him?
What is that you have not got, you please?
Complete papers, that's why I can say, there is no
What you-
pagination, there is no pagination, entire set of CRP has not been served on me, my lord. Only impugned order, appeal memo has been served on me.
National, 7 to 11.
Index has to be there,
application.
pagination, everything, complete set, whatever filed bill before the court, that should be served on the KV terminal. As far as my knowledge is concerned. Whatever the papers produced before the court, that should be served to the KV.
Served on him. So
Please,
the
my lord.
papers take, the list is marked on Monday in the first list.
Please, my lord.
Then counts for the petitions of all the documents on the council.
May I request on 24th, my lord?
Huh?
24th,
List this matter on Monday in the first list.
please, my lord.
Yes.
Till number 50, for orders 50.
Lord, I appear for the appellant petitioner in this matter. I have paid process on 8th of June and taken out steps again, fresh steps to respond number 4.
R4, why
Yes.
can't you take the notice on the council appearing before the trial court handsome so that it will be complete?
I had taken it for the other respondents. If I may be permitted, I will do
The
that.
petition is permitted to take out handsome on the council appearing for the respondent number 4 and shall file a memo to that effect.
Stay is
by-
granted.
1 minute. But to file a memo to that effect by 3rd of July or else the stay granted by this court stands vacated.
Vacate the stay, my lord. I'm
Why
filing
you-
application for the vacating stay, my lord. I'm the respondent, 1, 2, 3, and 5, my lord.
No, if I want to allow the revision, what will happen? If I want to allow the revision without service of notice to fourth respondent, how can I do it? Yes.
Cell number 51.
My lord, interim order may be kindly be extended.
Interim order only granted is extended. Yes, 51.
51. KN Mahabaleshwara.
Objection with reference to the Vakalat filed by the.
Vakalat objection.
Vakalat, all the defendants are represented by one GPA holder.
Where is the copy of the GPA?
The GPA copy I've produced, but it doesn't contain all the plaintiffs, my lord. I'll produce fresh GPA.
Yes. The petitioner, the respondent shall comply with the office objections. You have an interim order?
Yes, it is in the.
The granted is extended.
I request for a date, my lords.
This is matter in the month of September,
How did?
on 2nd of September. Yes, 52.
Okay, date, madam.
September. Yes.
Cell number 52. Chandrasekhar S. Awaiting service.
I may be permitted to delete R5 and 6, my lord. I'm not seeking any relief as against R5 and R6. The other respondents are served.
No, it says await service of notice in respect of R2.
Lord, the other respondents have.
Are you referring to 52?
It's not 52.
Chandrasekhar S.
Chandrasekhar L.
Chandrasekhar S.
Yes,
How
Lord,
many are the respondents?
R1.
Give the petition.
Yeah, sir.
There are only 2 respondents.
I'm sorry, my lord. I'm afraid. I'm extremely sorry.
No representation. This after service of notice.
Cell number 53.
Look at it if interim order is there. It's 53.
53.
The respondent number 7 in it.
Notice to respondent number 1 returned with, you appear for respondent 1?
Respondent number 7, my lord.
Respondent number 1
No,
returned with.
in this
postal
matter, my lord,
shara.
the impleading application filed by the
1
petitioners
minute.
here.
Postal share has refused, amounts to service of notice. Then the notice in respect of R2 to R4 returned with postal share unclaimed amounts to deemed service of notice. Yes.
This is the IA filed by the petitioners herein to implead the respondent number 7 as an additional dependent. But they have not placed any material to show that how I am related to the property subjected in the suit.
There is an interim order in this?
There is an interim order.
No representation on behalf of the petitioner?
Monday, my lord.
Don't extend the interim order. This
This is the
what-
matter of the year 2006, my lord.
I am not extending the interim order.
Much of it.
List this matter on 5th of August.
Much of it.
Cell number 54.
No, it's
Not
already,
that.
I think, no, Mr. Counsel, it's already 1:30. I'll take up this matter in the afternoon, 53.
50.
Your matter. It's already, I will take up in the afternoon. It's already 1:34. Yes,
Some even submissions, ma'am.
Oh.
In respect of serial number 47.
yes.
It was actually yesterday heard for some time, thereafter it was posted today. I got stuck at the other court and it got 5 minutes delay in.
What happened?
I think it is adjourned.
What is urgency in this?
So the trial court matter is settled for 25th, Swami. That's why.
25th, list it on 24th.
Okay.
47, list it
Alright,
on 24th.
Can it be on 22nd, Swami? Because 24th I am
When-
22nd.
No, you don't come when the matter is called.
Illa,
All
illa,
choices
the
can't
thing
be
is,
yours. Yes.
Yesterday actually it was R25 only, Swami.
25.
Deeply, please. Deeply.
25th is holiday.
25.
25th is not holiday, yes.
Deeply, please.
25th.
Firstly status. Okay. Anna.
I remember ಇವಾಗ September.
Sir,
September.
After lunch.
ಅಲ್ಲ ಇದು 51.
ಮುಗಿದ್ಮೇಲೆ
ಯಾವುದು 53 ಏನಾಗುತ್ತೆ ಟೈಪ್ ಮಾಡಿ ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಕೊಡಿ ಸರ್ ಅಡ್ವೊಕೇಟ್ ಅಪಿಯರ್ ಆಗಿ ಅವರು ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅದು
In the
ಲಂಚ್
comments
ಹೋದಾಗ
hospital ಅಂತ ಹೇಳಿ ಮೇಡಮ್ 54 ರನ್ನಿಂಗ್ ಎಲ್ಲಿಂದ ಅಂತ ಕೇಳಿ
ಏನಪ್ಪ 52ಗೆ ಮುಗ್ದಿದೆ 53 ಇಂದ ಕಾಲ್ ಔಟ್ ಆಗ್ಬೇಕು 53 ಅದು ಆಗಿದೆಯಲ್ಲ ಅದೊಂದು ಪೇಜ್ ಅದು ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ
Serial number 35, my lord, filing a withdrawal memo.
Take that.
Kindly permit me to liberty to file the fresh file 35 and also write the registry to the return the
List one
certificate copy.
35,
Howದು.
Memo, the officers raised objection with regard to maintainability. The petitioner has filed a memo for withdrawal. Being to withdraw the petition with the liberty to file the fresh petition accordingly. Dismissed. The office will return all the documents within 2 weeks from the date of receipt of this the order. The petition shall be filed. Yes.
Serial number 66. Others for other side also.
66, list this matter on 14th of July.
Please.
This
continuation of the list one, serial number 53. 53, B. Anand.
None appears to the petition. This is matter, same order. Yes, next. 54.
Serial number 54.
I am seeking vacating the entry model mirror. But this writ petition.
Anyway, he is not there. I will not extend the interim order. No representation on behalf of the
But
petitioner.
in the spot mirror, there is a serious problem.
The-
Taking advantage of this order, they are
You
not-
tell the court the stay is not extended. No representation on behalf of the petitioner. List this matter in the month of August.
The August mirror. Stay. This mirror.
Yes.
Serial number 55.
Date mirror.
Sundar Rajan.
August 19.
Serial number 19. 55.
Yeah.
14% Sundar
Yeah,
Rajan.
yeah.
Your post response to this matter. So far as the maintenance of the petition may be heard at first. The impugned order, my lords, which is under ceramic petition, my lords, the order has one impleading application. So far as my lords, the petitioner is concerned, he is one of the beneficiary of partition who is already on record at the time of institution of the suit. How come he can file this petition as a question of please?
The problem, Your Honor, is that the impleading application is based on sale deeds that have never been examined. So the separate IA where we try to get the sale deeds, and they are showing that they belong to a different property.
Where are your objections to the IA?
Sorry?
Where are your,
Lords, he has not filed any objection to the impleading.
that's why I'm asking.
And the problem was I did file a memo, but the order sheet has not recorded it.
Where is the memo?
Then it's there.
Page number?
Page number 43. Annexed F. Defendant 2 most humbly prays that IA 425 needs to be disposed before objection to IA 2/25 can be filed. IA 2/25 is the impleading application. So it sought the production of the sale deed so that I can file that. And again, when IA 4 is heard, since both are being heard in parallel, it's understood.
Please read that. I'm not able to understand. What is that you want to tell the court?
I want to tell the court that the IA 4, which is the production of the sale deeds, needs to be disposed so that the sale deeds comes on record. And then after looking at it, I can file the objection. So while I put the memo,
So you have no objection to allow IA number 4.
I know IA number 4 is still being heard.
What is this IA?
IA number 4 is the production of the sale deed because
IA, what is the present impugned order passed in which IA?
both IA 4 and IA 2 are both a part of the same writ petition because they are both related. One is the impleading application. The second one is the production of the sale deed, which is the basis of the impleading application. So the impleading application, there's no point hearing it without getting the sale deeds on record. And that's what the memo is saying.
That is what you wanted to say, which nobody is able to understand from this memo.
No, and nothing is written about the contents of the memo is there in the order sheet.
Even if it is considered, what is that the court can consider?
No, but all I'm saying is that we first dispose IA 4.
When the court is considering IA number 2, you have to file your objections on the merits of that. Why it shouldn't be allowed?
No, so for me to file, the sale deed needs to come on record. So that's what I have said here.
You can't impose conditions like that.
I can ask for the production of the sale deed.
You cannot. When IA2 is heard, we have to argue on the merits of it.
And
Unless when IA4 is heard, I will not file objections to IA number 2.
I mean, because without those.
That is not the procedure. If you are not understanding, you should say, you should take the legal
So
help.
second aspect is that the IA2, although it's based on sale deeds, they are not examined and it's being allowed based on the contention of the proposed defendant. The basis is a sale deed.
Where is IA?
You can look at the order of IA2, which is on page 20, Annexure A.
Your?
Annexure. Let me.
He has not given.
So copy of what? Yeah, it's up to you. I put a copy and it's there in the file. Yeah, otherwise they will not allow it to be heard.
Let him, I'll make my submission.
1 second.
Who are you? You are the plaintiff, defendant, or who?
I appear for plaintiff. I appear for plaintiff in the trial.
Yes.
He's
And
filed.
he is arrayed as?
He's arrayed as Malad, sir, defendant number 2.
He is member of the joint family.
Member of the joint family. He is the beneficiary of Malad's partition. I don't know why he wants impleading application to be dismissed.
One second.
Impleading applicants and Malad's are trying to squat the property by way of fraudulent means. The person who has died in 1974 accused the sale deed in the year 2013.
Wait, Your Honor, 1 sec.
That is why I was constrained to file an impleading application seeking for Malad's arraying defend number 9 to 12.
Your Honor.
For that, Malad's he objects.
No.
He is party in person before the trial court has.
The sale deeds produced are a different property. That they don't belong to the suit property.
That will be decided by the court.
No, it's there in the order itself. The order itself says that the property are different, but they're allowing it because he's saying it. So there's no document for the for them to be considered the same.
Oh, if this is allowed, what is how you are affected by this?
Yeah, because now two properties are being treated as one. These are 4 crores. The 4 crore value properties are being treated as one. Property number 5 and 17 are being treated as suit schedule C. 2 properties being treated as one.
What is this order and what is your submission? Come to the order.
Yeah. So if you want to see where it's being
Permitted to implead the proposed defendant. Plaintiff is permitted to impose the proposed defendant number 9 to 13.
right.
Where is what is
So,
now what you are submitting, that is the 3 properties, 2 properties.
That is in the next order, IA4, and that is Annexure B. You can look at.
The order is on IA number 2 or 4.
I have combined both because they're related to the they both come from impletion. Because they're impleading, we are asking for the sale deeds. So both of them are part of the same writ petition. Because we need those sale deeds to figure out whether they're proper parties.
The office has raised objection. Office has raised as many as 9 objections. The petitioner shall comply with the same within a week, or else the writ petition shall stand dismissed. Yes, sir.
He will mislead the court by filing
No.
memo every time, saying that there is a petition which is pending.
No, there is.
And Malad's trial court is going to adjourn the matter.
No, you can read the order. There are 2 properties being combined to be one.
Yes, 56.
Cell number 56, Chandrasekharan,
Permitted to file memo seeking dispensation of notice to R5 and 6.
R5.
5 and 6, my lord, they are the dependents number 1.
Dispensation of notice to 5 and 6. Dispensed with at the risk of appellant. Copies are served on you.
Next date is on 16/7 before the trial court, my lord, any day before.
7. Place this matter on 14/7. Yes, 57.
Much.
7, cell number 57.
CRC is already represented, that EPF may not be necessary. My learned friend has already filed a Vakalat on behalf of respondent number 1.
The R1 is already
The file
served.
Vakalat.
R1, on behalf of R1, already Vakalat is filed. Yes.
I appear for R2 and R3, my lords. I seek time for instructions, my lords.
You have an interim order.
Yes.
Interim order earlier granted is extended at the request of land council for the respondent. This is matter in the month of September.
Wait.
Serial number 58.
And two other matters in the second list are connected. I'll give the list. Same.
Give the numbers
Serial
to
number,
them.
sir.
List is tag these matters along with so and so.
Serial number 58.
Appealing for the petitioner, my lord, seeking a short accommodation to take its steps, my lords.
Notice to R5, R15, returned with the postal sugar, unclaimed amounts to deemed service of notice. The petitioner, the respondent shall comply with the office objections. Raised, huh?
Serve the copy
Oh, it is submitted that the copy is served on the council for the petitioner. The petitioner shall furnish the PF for issuance of within a period of 2 weeks. Huh?
Respondent number 8 and 9, I undertake to file Vakalat.
Land council submits that. What's your name?
S. Sumati.
Yes, Land council is Sumati submits that she has instructions to file Vakalat on behalf of
R8 and 9.
for respondents 8 and 9. Notice to R7, 12 and 14. The petition shall furnish the PF within 1 week or else the petition shall stand dismissed as far as the said respondents are concerned. Yes.
Interim order may be extended, my lords.
The order earlier granted is extended. Yes, 59.
59.
Sorry, my lord. In the connected matter also interim orders may be extended. I'm sorry.
In the connected matters also interim order. Yes,
Serial number
59.
59.
It's a suit for permanent injunction, sought for an order of temporary.
Huh?
Respondent 2-4, I am appearing.
You are ready?
Lordship, can you see short question involved in this matter? Let my friend submit because trial court, court is.
No, if you are ready, I'll hear the matter. Are
Yes,
you
my
ready?
lord.
Or?
Yes, I am. Sir.
Yes. Yes.
Lord, this is a suit for injunction.
So memo reporting death of R1 filed by advocate for petitioner.
Yeah, we have already filed a memo reporting the death of the first respondent. See, after filing of this petition,
So then they
the
have to
first
be-
respondent
they have
is
to
dead.
put on record.
Uh,
Or for the trial court or before this court.
No, the first respondent children are already on record.
Then you have to file a memo.
I'll file a memo.
To
To that.
represent whom?
2-4.
He is representing the children of first
No,
respondent.
you file a memo, then we'll take that and then we'll consider them as LRs of so and so.
Please, that can be done. Huh? Now itself we will file a memo. The short point is, after purchase of this property from the father, daughter and daughter's children are objecting. See, I have invested more than 59 lakhs in purchasing the property.
This is a suit for.
Suit for bare injunction. Thought for an order of interim order of injunction. The trial court refused to hear the other side. So then, being aggrieved by the high-handed acts, we approached this honorable court.
Then we'll ask the trial court to decide that. We'll ask the trial court to decide.
Yes, within a time-bound manner, this can be disposed of
Yes.
with an observation till such period.
No.
Let the parties maintain status quo.
Was it granted earlier?
At least for a period of,
We will say 1 week to be disposed of. I will not pass any orders in between.
please, please.
The petition is before this court. Agreed with the issuance of summons to the respondents without hearing the IA file for ad interim injunction on behalf of the petitioner. The senior counsel appearing for the petitioner submits that when an application is filed seeking ad interim injunction, the court ought to have considered the same on the merits of it without issuing the summons. It is submitted that the coordinate bench of this court in so and so. That order. so and so has observed as follows. It is submitted that respondent number 1 is no more and already LRs on record. Respondent advocate is representing respondents 2 to 5.
2 to 4 million.
2 to 4.
2 to 4.
2 to 4. But in the cost title, it shows R2 to R5.
Yes.
Look at it. Represented
GMI is no
in
more.
respect of R2 to R5. Considering the fact that in the light of the order passed by the coordinate bench of this court, when an IE is filed seeking interim injunction, if the court looking at the considering the case of the petitioner has to pass an order, and if the petitioner is agreed, he will avail the appropriate remedy, and without doing so, the court has issued the summons. Hence this court deems it appropriate to dispose of this matter as already respondents are appearing by way of a following order. The writ petition is disposed of, directing the trial court to consider IA number 1 within a period of 1 week from the date of receipt of the copy of the order.
Cell number 60.
My lord,
I'm for the
see,
respondent.
they have filed the Vakalat, they have not filed the statement of objections or a written statement.
The court shall, whether the defendants file their objections or not, the IA that's filed for interim injunction be considered by the court. Yes.
Please, much obliged.
60.
I appear for the respondent, Your Lordship.
And for the petitioner, my lord, kindly, my lord, I will permitted to file my statement of objections to the impleading application.
The fact is this, my lord. The lessee is the IOC and the present petitioner is the lessor, owner of the property. The lessor files a suit for eviction against the lessee, that is IOC, and it is decreed in October 2025. 2 months' time was granted to the lessee to vacate the premises. In the meantime, RA was filed before the senior civil judge challenging the judgment decree of the trial court. In the RA, the notice of the summons was not received by the present petitioners. So the case was posted because there was 11 days delay in filing the RA. In the meantime, what has happened, they have filed an execution petition for not vacating the premises by disclosing in the execution petition that RA is pending before the court. Again, notice was issued in the RA because without notice to the other side, a delay in filing the appeal cannot be condoned. There is a direct decision of this honorable court on the point. Notice issued to them, they did not receive the notice. In the meantime, because the decree is within 1 year, the trial court issued execution warrant in the delivery warrant. Though there is no police protection, they have gone to the spot and to the petrol pump and they have seized the petrol pump in the execution petition. The IOC appeared before the execution court and made an application that we have got stocks and it is going to be get wasted. RA is before the trial court, give some interim arrangements to see that the stocks are exhausted subject to the result of the RA. The trial court gave 2 months' time to suspending the delivery warrant. That order is challenged before this honorable court by the other side, and the petrol pump is now under the lock and key of the court. The RA was heard on last 2 days back. It is today posted for the arguments of the other side of the landlord. I appeared for the IOC before the trial, before the first appellate court, and the matter will be posted for judgment if the other side argues the matter in the afternoon today. My only submission is the dealers, that is the impleading applicants per day loss is about 50,000 rupees because these days since December 2020.
How can that be decided in his?
No, no.
May I make this submission?
I will complete. I am the applicant. This the stocks that is now lying in the petrol pump belongs to me. I have paid for it. If I don't pay, the IOC can take recovery action against me. I am the dealer. IOC is the lessee. IOC supplies to me. I have to pay them and then take the stocks. Now, since the present day petrol is mixed with ethanol, it gets contaminated and there will be seepage and wastage of the petrol pump, and that wastage will be about 2 to 3% per day. 25,000 liters of petrol and 30,000 liters of diesel is lying in the petrol tank.
Before you submit all that, where is the impugned order?
The impugned order is only the time has been granted.
For that, how can you file an impleading? What order?
No, my lord,
you expect from
if the stay is not vacated, I am the loser.
He is not a party, my lord.
No, if stay is not granted, stay is not vacated, I am the loser. I have to come to the court. This is a court of equity. My only submission is this, my lord. Now, subject to the result of the RA, this stay may be vacated. Today, the RA is posted for the respondent's argument. If the RA is dismissed, I have to vacate the premises immediately. I have no other option. Or I have to file a RSA before this honorable court. IOC has to file an RSA. And if the RA is allowed, if some time is granted to me, then within that time, both the parties are bound by it and they can file an appeal.
So order should have been passed in the RA. Why should it be passed in
No, what has happened here is, my lord, in the stay has been granted by this honorable court. Your lordship may kindly see page number 19.
No, my lord, before marriage, let him say what is his locus standi to come on record
I have not yet completed.
His impleading application is written on.
I am making out a case to vacate.
He is not a party to the proceedings.
No, I have filed an impleading application under CPC. It
Yes,
is binding on all.
That. Why should we touch the
Your
merit
lordship
now?
may kindly see page 19. IA4 filed by the DHR are hereby partly allowed. The possession of the suit scheduled premises is handed over temporarily to the JDR for a period of 3 months from 3/5/26 to 3/8/26, subject to payment of additional damages of 5,000 per month, in addition to damages already awarded, which has to be paid to the DHR. Further, JDR cannot refill the petrol or diesel tank. The 3 months period is granted only to sell the petrol and diesel which is already stored and remove all fittings and deliver the vacant position. This is a very fair order. Now, this order has been stayed by this honorable court in the above writ petition on 19/5/2026. Now, my lord, my submission is only this: in a win-win situation, let the senior civil judge court, which is dealing with the RA matter, decide the matter on merits of the case. Subject to the result of that RA, this interim order granted by this honorable court may be vacated and this writ petition may be disposed of. Otherwise, it will be a loss to me.
May I make a submission? Look, kindly see, my lords. He is neither a party in the trial court, nor a party in the appellate court, nor even a party in the executing court. My lord, 1994 is the lease deed executed by the father of the petitioners in favor of Indian Oil Corporation. My lord, lease expired. But what Indian Oil Corporation appoints, whom it appoints as a dealer, is not a tripartite agreement with me. I lessed it. And he is only a dealer, a concessional license given to a person to run the show on behalf of Indian Oil Corporation. It is the relationship is between between interstate. We filed a suit for eviction against original lessee. Suit was declared. Appeal was filed. No stay was granted. We said before the trial court, yes, appeal is filed, but there is no stay order against, and trial court granted 2 months time. But we waited for 4 months. Then we filed the execution petition. But execution petition, delivery warrant was issued. My lord is well aware, my lord, I need not, within 1 year, my lord, notice is not necessary. Delivery warrant was issued. My lord, Amin executes the delivery warrant, hands over the position to me because, my lord, it is an eviction decree. And he filed a report. My lord, I'll demonstrate before my lords. There's a report filed by the Amin that warrant has been executed. No, my lord, when the vacant position is handed over, can the executing court go beyond the decree or grant extension of time? And what trial court does is, it says, all right, you have taken the delivery, you deliver the. How can the trial court ask me to redeliver the position when I obtained pursuant to a decree? Is it or not beyond the scope of very executive in court? So therefore, I came up before this court saying that, Lord, this is beyond the power of the executing court, because the Supreme Court also says the decree should be executed as it is. That's what my lords have granted. My lords may kindly see the interim order, what this honorable court said. And my lord, he is not a party. And my lord, interestingly, the JDR is also not before my lords with a vacating application.
Your Lordship, I'm for the respondent. I've also filed my objections and a vacating stay. I've also I handed over a copy to the petitioner here.
Objection is served on us yesterday through post. I acknowledge it. But
And the
not
vacating stay is
application.
mailed. Vacating stay is mailed, and also I will hand over a copy to him.
Please, sir.
Yes.
Let us kindly see the interim order. But therefore, he is a dealer. Now he cannot come in between a lessor and a lessee saying that I have a right, I am owning it. No, you are not owning it. It is Neon Corporation which appointed you as a dealer, and DHR is not before my lords with a vacating application. So therefore, my lord, he is not entitled to come on record. That is my primary objections.
Yes.
Because he is not a party in any of the proceedings.
Where is the IA?
IA for impleading.
Where is that IA for impleading?
IA for impleading, I have filed on 2nd June 2026, my lord.
Look at it.
Well, kindly see, my lord, he is appointed as a dealer in 2022. 94 is the lease, my lord. He was appointed as a dealer in 2012. After 10 years, my lord. Kindly see, my lord, page number 51. May I pursue, my lords, just to see page number 51. One sentence, my lord. Other than that, I don't want to argue anything.
Date of filing, second copy ತಗೊಳ್ಳಿ, office copy. ಅದೇ same.
May I seek my lord's indulgence? Only one page and some sentences, my lord. What is his locus? Kindly see page number 51, my lord. It is, he appointed as dealer on 19/3/2012, page number 51, my lords. It is fill in the blanks, my lords may kindly see. In the statement of objections. That is the statement of objection, my lord. Page number 51, my lords.
Yes.
My lords finds it? Yes. Kindly see the date, my lord, 19/3/2012. It is fill in the blanks. He was appointed as a dealer. 1994 is a lease. 2012, he was appointed as a dealer. Kindly see the first paragraph. Whereas the corporation carries on the business of refining and sale of petroleum products, and more particularly of motor spirit, petrol, and high speed. So kindly see third paragraph. Whereas at the request of the dealer, the corporation has agreed to appoint a dealer as its dealer for retail sale and of supply at the said prices of certain petrol. So therefore, he is a dealer. He is not a lessee. There is no direct contact between me and. So therefore, suit was properly filed against the lessee. No, the suit culminates into degree. He never participates in any of the proceedings. Nor corporation brings these facts to the court. And they go in appeal. The respondent number 1 hearing has filed an appeal. And let's kindly see which application was filed under Order 27. It's all right, Lord. I do concede. Putting of wrong provision of law does not disentail the court from passing the appropriate orders. Even if I assume that application was under Order 21, Rule 97, but can the decree holder file that application? I mean, sorry, judgment director file that application? Having suffered the judgment and decree. Nonetheless, the trial court entertains. Therefore, I am before my lords. No, he is not a necessary party. That is all my humble submission is.
My submission is one Krishna was the dealer since 1994. this Tirtha Kumari became the applicant, that is the firm, became the lessee after dealer after 2012 because of the partnership deed that I have produced before the court. The lease terminates in 2014. They have filed the suit in 2019.
It's all right.
For 8 years, they have waited without filing the case. The lease, they allowed the lease to continue. Now, 2 months' time was given by the executing court. They are not allowing. This is a blackmailing tactics. That's all, my dear.
I number 1026 is filed by the petitioner, who is a dealer of the first respondent. First respondent is IOCL here.
Yes.
Yes,
Of
please.
the first respondent. It is a case of the petitioner that they're engaged in the business of sale and service of petroleum products. The unit is situated in the property belonging to the plaintiff, that is the petitioner in the writ petition,
Father of the petitioner.
father of the petitioner.
2 daughters, my lord. Father has a original lessee.
The Implead applicants are in occupation, the proposed parties are in occupation and possession of the said premises, and the lease was between the plaintiff and the first respondent defendant IOCL. The lease was in the year
1994. my lord.
1994.
4/3/1994. And petroleum operations business is carried on in the said premises. Pursuant to the lease agreement between the petitioner and between the plaintiff and the first defendant, the applicant herein have established and developed the petroleum outlet and have been carrying on business without interruption. It is stated that the first respondent, the plaintiff has instituted OS number 304 of 2019 on the file of the civil judge Belur seeking eviction and other consequential reliefs against the respondents therein. The suit for eviction came to be decreed by judgment and decree dated 31/10/2025. Agreed with the said judgment and decree, the IOCL, the defendant number 1 in the suit,
Oh, sole defendant, my lord.
the sole defendant has filed an appeal, that is RA number 33 of 2025 on the file of the senior civil judge and JMSC Belur. The appeal is filed with a delay of 11 days and the court has ordered notice. In the meantime, the decree holder has filed the execution petition. That is EP number 114 of 2026 on 9/3/2026. In the execution proceedings, a delivery warrant came to be issued and the same was executed. Upon coming to know about the execution of the delivery warrant, what does it mean? The respondents filed application means IOCL filed.
Yes,
IOCL filed.
filed.
IOCL filed the execution.
The respondent filed.
Application seeking recall of the delivery warrant and restoration of possession. It is stated that the executing court by order dated 2/5/2026 was pleased to restore the possession and maintain the possession for a period of 3 months. Agreed with the said order, the decree holder has come before this court and a coordinate bench of this court has granted stay of this order. Now, the present Now the IA is filed under order 1 rule 10 by the dealer of the dealer of the defendant number 1. Stating that.
Sorry, sole defendant, because my lords are dictating defendant number 1. There is only defendant.
That's
I'm sorry,
the
my lord.
dealer of the defendant, or the dealer of the defendant, that he's a necessary party to these proceedings, and because of the stay granted by this court, he is incurring losses. Hence, he may be impleaded in this petition. Further, as the appeal is pending, and till the further orders are passed, the orders passed by the executing court dated 2/5/2026 shall be in force. With this amendments, the implead applicant is before this court. Next para. Then counsel appearing for the petitioner plaintiff submits that has filed his objections and submits that the dealer is not a proper and necessary party to this petition. It is submitted that nature of the suit, appeal, or in the execution proceedings, he was never a party. There is no relationship between the petitioner and the implead applicant, and he has no locus to come before this court, and the implead petition has to be dismissed. Anything else? Implead petition has to be dismissed. Having heard the counsel for the petition, the learned and the counsel for the respondent, there is a material on record. Admittedly, the suit is filed for eviction, and this applicant is a dealer of the defendant. And at any point of time, either in the suit or in the appeal or in the execution, the implead applicant is not a party. His relationship is with the defendant, and the defendant has put him in possession of the property, and he has any nexus, any relationship with the plaintiff and the suit. But the suit, the rights of the plaintiff and the defendants are determined, and the court has passed an order of eviction, and which is challenged. And if any orders have to be passed on the execution petition that is filed at the behest of which is filed by the appeal filed by the IOCL, that is the defendant therein, the court would pass appropriate orders. Admittedly, the said appeal is pending consideration, and so far no interim orders are passed. Whether the order that is passed by the court, executing court, is legal or valid, that would be decided by this court in the main writ petition, while disposing the main writ petition. As far as this IA number so and so is concerned, in the considered opinion of the court, the petitioner is not a necessary party for adjudication of the necessary party in this petition. Accordingly, IA number so and so is dismissed.
My lord, my submission is only this. My submission, IOC is also a party in the matter, and IOC is also insisting for vacating the order.
That we will hear.
I've also filed my application. I request for a short date, Your Lordship. I'll argue on merits and it can.
List is matter on 1st of July.
The original date given was 25th.
The other day than 1st of July. I have some personal.
Original date given was 25th of June, my lord. The same date may be given.
No, 2nd of July or 3rd of July.
25th, it's not possible.
Any other
This is
day.
matter on 29.
Please.
Please.
Now, in the meantime, the first appellate may proceed with the judgment which they are posting.
We are not stopping it. It's only the interim order earlier granted is extra.
My lord, my submission is only this: the first appellate court may proceed with the matter, because let them not go there and say that this writ petition is pending.
That can be decided independently.
So let there be.
That is an appeal. I'm only. That is an appeal, my lord. I am
No,
only
my lord. Today
against
morning,
the order passed in execution petition. That's all.
Today morning, they have made a submission that matter is pending in the High Court. Let the first appellate court should not.
It is made clear that no, while not in that IA, that's in this extension of interim order. it is made clear that as far as the proceedings pending before the first appellate court shall proceed in accordance with law.
Please comply.
61, Jayaprakash Rao M for petitioner, V. Chandrappa.
Lordship, I appear for the petitioner. So Lordship, it is on the maintainability. The MA, the two applications have been collectively ordered in a MA.
What are those two applications?
Two applications. One is for the not interfering the possession. One more for not demolishing of the wall, compound wall.
He submitted that. The both a common order is passed. Then council submits that the officers raise objection with regard to maintainability in view of section 7 of the rules. Considering the fact that as it is submitted that these are it's a common order, the office objection is overruled. Yes.
Lordship, 2 weeks time may be granted for the other office objections are there. So certified copies have to be placed.
Other office objection petitioner shall comply with within a period of 2 weeks. This is a matter in the month of August.
Cell number 62, Keshav M. Datta.
Petitioner, 1 and 2. Now, this is a suit for declaration and injunction. We had filed I'm appearing for the defendants before trial court. We had filed an application of 7 Rule 11 on the ground that the valuation of the property and the court fee has not been made proper. Learned trial court dismisses my application, which is why I'm before my lords.
Why can't on that ground? Why should it be rejected? It will pay.
I'm not asking for it to be rejected on that ground. I'm only saying give them sufficient time, failing which let them make that deficit payment. That is all my submission is.
What did the court say?
The court has not averred to anything of that sort. It just says the valuation made under 35(2), but they themselves have not made valuation under 35(2) of the.
Let there be an issue in that regard and let the court pass an order.
Issues are not yet been framed.
No,
My only submission is they valued the scheduled property at 61 lakhs and change. But actual valuation of the property is
But
4.5
for that,
crores.
If you are disputing it,
Please.
so that there should be an issue, there should be evidence, and court will pass. If he has to pay, he will pay.
Let me seek instructions then.
Yes.
Great.
In fact, my lord, the IA is properly considered, my lord. See, my lord, we are
No,
pending.
there is no interim order.
There is no interim order.
This is matter in the month of September.
Grateful.
63.
Cell number 63,
My lords,
Srinivas
matter relates
D.
to the illegal holdings, my lords, that have been put up on the state highway. A suit has been filed, my lords. In this suit, I have entered appearance, filed my written statement.
What is the suit for?
Suit is for injuncting me from interfering with the holding that they have put up. This is a state highway. The Karnataka State Highway Act does not permit holdings to be put up. And they have put up holdings on the state highways. Now, my lords, they filed the suit. I enter appearance. And before I enter appearance, they have approached this honorable court during vacation bench. They don't appear in the matter. When I appear there and file my written statement, they take an adjournment. Then later they move this honorable court and get an interim order. They don't argue on the application there. They come before my lords and then,
Even before order is passed there, this court has passed an order.
my lords, ex parte injunction has not been granted earlier. I have entered appearance.
Where is that order? What is the date of the order?
The date of the interim order here, my lords, or
Here.
Here, the date of the order is 18. It is 18/6, my lords. Date of the interim order passed by this honorable court.
It is 23/6, I think.
Sorry, my lord, 23/6. And 18/6, I have already filed my written statement. They have taken time.
To the prayer made in the plaint, respondent corporation shall maintain status quo.
Yes, ma'am.
And not to damage the holdings of school scheduled property henceforth. Then I will vacate this stay, or within 1 week the court shall consider your application. Till such time they will not do anything.
Last six dates, they have not appeared. I've argued on
That's what
6.
I'm saying.
Yes, ma'am.
We'll keep it, we'll give a week's time. Till such time any order to be passed. If they are not coming, then after if they are not cooperating, court will.
Because of the pendency of the writ petition, the trial court is not passing any, closing the stage. Last 6 dates, they have not appeared before the trial court. And here on twice or thrice, they have taken adjournment without informing me. And my lords have passed an order saying because the council is not informed, interim order was vacated, then restored. And then they again took time, and then it's happening for the last 1 year, my lords. And based on this, there are multiple other suits.
What is that IA that's pending?
My lords, before the trial court, I have filed a 7 Rule 11 application, and their application IA number 2 and 3 for injunction, all three are pending, where I have concluded my arguments.
Let all three appeals.
First of all, I would like to make some submission regarding this thing, what my friend made a submission that we have taken adjournment and those things, Lord, it is, whatever is the truth, let him state it. Let us not.
No, just leave it there.
Yes.
Now, we'll ask the trial court to decide the application, your injunction application within a week. If you have to cooperate it, if you are not cooperating, the court will pass its orders. After that, that order 7 rule.
Till the trial court takes the decision, let there be a
This order
protection.
will continue.
Yes.
And you have to cooperate, even if you ask a day adjournment, the court will proceed with that. That much I'll make it clear. Because it is a national highway.
One day or
Page
2 day,
number
my lord, your
34.
lordship may exempt us, because the reason
This
is
this is
someday an advocate may have some inconvenience
No,
also.
this is a national highway, and these kind of hoardings, if they are not in the interest of the general public, it is not something your personal thing. So it requires attention and it requires urgent hearing. Please come. The writ petitioner, the writ petition is filed.
Against non-grant of interim order.
No, to quash the order dated 21/1/2025, passed on I number 2 and 3, filed under order 39 rule 1 and 2 CPC, dated in I number 2, invoice number 108 of 2025, by the third Asian Civil Judge Bangalore. The petitioner is the plaintiff in the suit. He has filed the suit restraining the defendant from interfering with the plaintiff's peaceful possession and enjoyment of the suit scheduled properties. And also an injunction restraining the respondent from illegally disposing the plaintiff's peaceful possession and enjoyment of the properties. In that, the petitioner has filed I number 1 and 2, seeking injunction. Where is that order dated?
My lord, that order is at Annexure C, page number starts from 26 and 28 is the operative portion, my lord.
The court has issued the suit summons an emergent notice on I number 2 and 3, not 1 and 2. 2 and 3. 2 and 3.
One was leave.
And the court observed that on perusal of the pleadings and the document filed with the plaintiff, the court is of the opinion that the plaintiff has not made out urgency to grant ex parte temporary injunction at this stage. Hence, before passing any order on I number 2 and 3, it is necessary to hear the other side. Therefore, and accordingly, summons were issued. Agreed thereby, the petition is before this court. A coordinate bench of this court on 23/6/2025 has passed an interim order observing that that a submission is made that if the injunction is not granted, respondent will remove all the holdings belonging to the petitioner, and hence the court has passed an order directing the corporation to maintain status quo and not to damage the holdings in the suit scheduled property. That interim order is continued from time to time. Land counsel, the defendant has filed the vacate petition. Land counsel appearing for the respondent submits that as the, what is that?
State highway.
State highway.
The state highway.
State Highways Authority.
No, it's
Act,
a state
what is that
highway. Act is Karnataka State Highway Act.
The Karnataka State Highways Act does not permit any installation of holdings on the highway, and because of this holdings, there is every likelihood of causing accidents. Further, in the light of this, in the view of this rainy season, the danger is all the more high.
Last year, after I filed my IA for statement of objections, as on that date, I filed photographs, my lords. This is what has happened. It has fallen on a vehicle. The entire one of the holdings.
In fact, during the pendency of this writ petition, in fact,
not erected by them, but another illegal holding.
The holdings which are erected by some other persons
on a state highway
vehicles and created lot of damage. Hence, it is submitted that the stay granted by this court needs to be vacated. Next parallel, counsel appearing for the petitioner submits that the petitioner has no objection for the trial court to hear the matter. However, the interim order that is granted by this court shall continue, or else his applications, if the respondents remove the holdings, the application itself becomes infructuous. Next para, having got the counsels on either side, there is a material non-record. Considering the urgency as expressed by the respondents and also balancing the interest of both the parties, this court deems it appropriate to pass the following order. The writ petition is disposed of, directing the trial court to consider I number 2 and 3.
IA4, my 7 to 11 application is pending.
First of all, let this go.
My lords,
Again,
the
if we-
difficulty
again, if
is
this,
this, civil court doesn't have jurisdiction, my lords, under the act.
No, that now your urgency is for this.
Lords, both the IS may be considered because I have argued and closed.
What will happen is if you mix all that, this will get delayed.
My
If
lords,
this
in-
gets delayed, then their stay will continue.
My lords,
First, on priority, the court shall consider IA number 2 and 3
my lords, may I-
within a period of 1 week from the date of receipt of the copy of the order. If if either of the parties are not cooperating with the same, the court is at liberty to proceed with and pass appropriate orders. Number 2, it is submitted that I number,
my lords, my submission before the trial court is that the 7 to 11
what
application.
I'm saying, what is that I number?
IA number 4, my lord.
I number 4, it is submitted that an IA is filed, I number 4 is filed under order 7 to 11. After this application is disposed of, the other the IA number 4 shall also be shall consider and shall consider expeditiously according, and it is made clear that till the IA number 2 and 3 are decided, the interim order granted by this court shall be in force. Shall
I'm
continue.
sorry, my lords, I'm repeating myself again, I'm sorry. My submission is that my 7 to 11 application to be taken up first because the suit doesn't sustain, then the question of injunction doesn't arise at all. So either let there be a direction to dispose of both together because I've already argued, filed written arguments. They can respond.
Example, court says court has jurisdiction.
Then then consequently, this application can also be disposed of. IA 2 and 3.
Both IA number 2, 3 and 4.
All three may be considered simultaneously, my lords. Within a period of, my lords, a date.
1 week.
My lords, without further notice, a date may have to be fixed because the next
Trial
date is
court
on
will
trial
advance
court-
money, we have to make an application.
The parties can advance the matter. From the date of receipt of the copy of the order, 1 week I said. So it's,
I get
the
it, I
court
get it.
will, so once the copy is
We've had some
received.
challenge
inform
in advancing the matter earlier for vacating as well. So may I request that a date may be fixed when both parties can appear is all I'm requesting.
I said 1 week from the, when will you get the order copy? I don't know. Yes. Mm. No. We need not consider this because the matter is sent to the court. Yes.
Appear for the. I filed an application, my lords. Respondent number 3 is dead, my lords. So to bring the LRs on record, my lords, I filed the application. Suit is one for partition, my lords. The case, my lords, is at the stage of FDP proceedings, my lords.
Have to order notice in this.
Yes, my
Number
lords.
4
No,
of
your
it.
lordship, only one submission in that aspect, your lordship. Before the FDP proceedings also, they are raised the issue, your lordship, but there we are disputed the relation and other respondents also disputed the relationship between, because he is not having any LRs, that is the submission. That's why since from 2023 to till date, there was no LRs were brought on record in the FDP trial before the trial court. Now the first time they are filing this application before this honorable court. When the existence of the legal representative is very
See
disputed.
some other day. This is matter in the month of July. Yes, 65.
Interim order may be extended, my lords.
Your lordship, kindly fix the date because 2000.
Matter on 28th of July. Yes.
I'm grateful.
Number 65, Raju, yes.
But still number 65, Lord. Your lordships had directed that by 30th May, I'll have to deposit 20% of the amount to the bank. Incidentally, it so happened 30th May was a Sunday. So we, because transfers had to be made from another bank. banks were not working on that day. We told the bank that we will be depositing very next day on 1/6. And on 1/6, we made good the entire 20% deposit. What the bank has done in the meantime,
30th May was not Sunday, it was Saturday, it was a working day. They've deposited on 1st, my lord, but then first parallelly we took possession because that was the order, on or before 30th. And on or
yes,
before 30th. So, my lord,
Saturday,
given enough
no
time.
doubt it was a Saturday, but there was some difficulty in the transfer.
1 minute, you have
So
taken
first
possession
we,
on Sunday.
No, we took possession on Monday, my lord.
But they paid it
and
on
Monday the deposit was
My
made
lord,
good.
in the morning we took possession and afternoon they made payment.
So it doesn't matter.
Lord, mom.
Lord, they had enough time to make payment and it was as per the order.
No, the whole difficulty with the banks is when you're getting money, this is what are the submissions.
Yes.
But you will wait years and years together fighting the litigation, from DRT to DRAT to High Court. So you got the money.
We've
So
got the
order,
money.
yes.
We've got 20%, my lord. Also, my lord, one submission. There was in fact a cost of 10 lakhs imposed, my lord, if they don't pay. Let them pay. They had undertaken to pay, my lord. That is as per the order. Let them make the payment of the cost of 10 lakhs.
Entire amount is not
Lord,
paid.
the full money will be paid.
39,
The full money will be paid by the deadline indicated by your lordship's lord. We have
No,
shown the
that is
bona fides. The bank cannot act like a Shylock,
If they don't pay
trying
by
to
30,
squeeze us.
First part of the order itself says 10 lakhs, my lord. Second part, yes, my lord.
that is in case the petition fails to be the first installment to the bank.
Or 30,
And at the
35,
same
yes.
time, the
They had in
petition-
fact undertaken, that was a specific undertaking that they had taken, that they'll pay, even if the first installment is not paid, we are ready to pay costs. That was, my lord, the second installment
Lord,
also 10.
it came on a Saturday. I don't know why my learned friend is. It came on a Saturday. We could not finish the transfers that day. We have written a mail and requested them.
The IA number 2 of this court has disposed of the matter with that order on so and so. If any request is unreasonable, the court will not consider.
No, my lord, this is as per the order, my lord.
No. I'm saying if the request is unreasonable and there is delay, then I would definitely would have
Yes.
considered it. This court
Yes.
by order 25th March 2025 has disposed of the petition, considering the undertaking filed by the petitioner, wherein it is stated that they are ready to pay the 20% amount by 35/2026 and remaining amount by 39/2026. Now it is submitted by the Lencina Council appearing to the petitioner that 35/2026 happens to be a Saturday, and
Yes.
on 1st June they have paid the money. Land Council appearing for the respondent banks, it is submitted that as there is a delay, they are not accepting the amount. You have
No, my lord, it has been appropriated because it is an electronic payment that automatically is
Yes, it is
appropriated by the
submitted
system.
that as such, the file, they have come up with the present IA. Then counsel appearing for the respondent submits that when the court has directed them to pay the amount on 30th, as they have failed to pay the amount, they have taken possession on 1st. It is submitted that as per the order, if there is any, if the petitioner fails to pay the amount as indicated in the order, they have to pay cost of 10,000. It is submitted that now the
10 lakhs.
10 lakhs, that it is submitted that the petitioner has to pay 10 lakhs as cost. Means for as per the order, the petitioner has to pay by 30th and it is paid by 1st, and the 30th is a Saturday. This cannot be considered as a delay, and accordingly, and the position that is taken by you have taken physical possession.
Physical possession.
The physical
Yes.
possession of property shall be delivered back to the petitioner, and it is this order makes it very clear that whatsoever, what is that day will be
30th of September.
30th of September.
September will be is Wednesday.
Wednesday.
Next time, if the petitioner comes up with this kind of application, it is made clear that it will not be entertained even for a day.
Please.
If it fails to pay the same, the bank is at liberty to to take appropriate steps. Yes, next.
Please. Oblige.
That is disposed of.
Cell number 66 urgent, 67 CN Common.
The petitioners are the applicants before the executing court. In 2001, my lord, I had filed a suit for declaration and possession. My suit has been decreed.
My lord, after the decree,
You
my
have an
lord,
interim order. Where is the respondent?
my lord, they have been placed ex parte before this honorable court. Notice has been served. They have not claimed the notice from the honorable court.
We'll see. No urgency for this. Interim order only granted.
My
is
lord, now what
extended.
has happened is on 3/7, the trial court has posted my execution matter, my lord. Your lordship may fix a date next week, my lord. I will.
You have a stay. Why will the execution court do
No,
anything
no,
now?
the execution court says, my lord, that in the trial court, what has happened, my lord, my application under one section 153A has been dismissed.
This is matter on 30th. Interim order only granted is extended. Yes, 68.
Yes.
68. Cell number 68.
I am for the petitioner, my lord. Due to inadvertence, I have filed the above writ petition. Instead of filing public interest litigation, I am permitted to withdraw the writ petition by reserving liberty to.
No, but the other day when the matter came up, we were not ready to accept it.
Yes, my lord. Yes, yes. Reserve the liberty to file a cell before the competent court of law.
A memo is filed seeking to withdraw on the last occasion when the matter came up. Looking at the prayer, this court has pointed out that the relief that is sought is in the nature of a public interest litigation. And how can the petitioner maintain this writ petition? Petitioner has sought adjournment and now filed a memo for withdrawal stating that the petitioner wants to withdraw this writ petition and he'll file and liberty may be granted to avail the appropriate remedy accordingly. The writ petition is dismissed with the liberty to avail the appropriate remedy available to the petitioner.
My lord, sir, writ petition is disposed of in terms of observation of this court.
Yes. Why it becomes an order then? Yes.
Cell number 69. Mahesh Arifin. 69 Mahesh Arifin.
Connection of electricity
I
supply.
appeal for the support number 3 in this case.
For the respondent, warrant, your lordship. Council pays time to, council pays time, your lordship. For short accommodation, your lordship. As senior is.
Have an interim order.
Yes.
Interim order.
Electricity.
Interim order earlier granted
Restored.
is extended.
And in fact, there is a
Month
suit
of
for
August.
partition filed by the petition is pending consultation.
70.
Now it is in the stage of
A
class.
friend is seeking time.
Grateful,
Yes.
your lordship.
Cell number 70.
For the respondent number 3 to
For
7.
the petitioner, my lord.
I'm
I'm
seeking
seeking time to
mandamus.
file my objections, my lord. Because this is, writ petition itself is not mental, because the RR number has already been transferred in my name. They are seeking mandatory directions to,
My lord,
Any interim order in this?
no interim.
there was no
This
interim.
matter in the month of August.
I appear for the respondents 1 and 2. Copy of writ petition has not served.
Huh?
Copy of writ petition has not served.
My lord, the
No,
process has
then
been,
counsel for the petition, serve the copy of the writ
my
petition.
lord, the process has been issued, my lord. After that, they have appeared, my lord.
So you don't serve the papers on that.
Entire paper books are furnished, my lord.
Anyhow,
Once
serve it,
again,
you
once
want
again,
a-
I'll furnish it.
Counsel for the petition, serve the copy of the writ petition on the counsel for the respondent. Yes,
Still
let's in the month of
71.
August. Yes, 71.
Badrinath R for petitioner.
The petitioners, the owners of the land. They are drawing the power, there is a 66 kV power line is there existing in this petitioner's land. Now they want to make it as a double line power line in the year 2015. Where I had filed an appeal before the, as per direction of the National Court before the Deputy Commissioner. Appeal, even the guidelines issued by the Ministry of the Government of it has been not followed by the second respondent. And same has been adopted by the state government also. It has also been not followed by the Deputy Commissioner.
What are the guidelines?
Well,
that are to be
guidelines.
followed?
Regarding fixation of the compensation and to transferring the line.
No, fixation of the compensation is done already.
Right?
Fixation of the compensation is done.
No, it has been not done.
Then
Even the second respondent had not decided it. Only the reasoning given by the second respondent is zigzag lines cannot be drawn. In the paragraph 11 of the second respondent order, may kindly look into.
no, why you do not want it to be laid in your land.
Whereas in respect of the neighboring landowners, zigzag lines has been provided. Same lines to be provided to me also. I'm not interested in compensation.
What is that?
That is not correct. This is the existing line. We are replacing the single circuit line into the double circuit line. Not the where single circuit
File
line
your
was.
objections, we will see.
I'll
This
file
is
it.
not something which we can, the objections shall be filed with the respondents.
It's connected matter also, I served the copies to the other side.
Yes, objection shall be filed by the next date of hearing. list on 16th of July. Yes. Passwords.
230 mood matter. Ankit Jain, for petitioner.
May it please your lordships. My lords, I am an objector who files an application under Order 21, Rule 97. My lords, I have been in the subject property since 1988. Now, my lords, on the date of filing my application, my lords, I come to know about the suit for specific performance when the bailiff comes to visit the premises. And this is when I come to know the judgment debtor has a suit for specific performance against him. My lords, upon coming to know of all this, I file an application.
File the caveat.
Caveat, please. My lords,
Of the papers.
I've served, my lords. My lords, I file an application under Order 21, Rule 97, an obstruction application. My lords, this comes up before the court. The court issues notice on that application. Simultaneously, what the Honorable Court does is, they file an application under Order 21, Rule 35, saying that with police help, I have to be evicted from that premises. Now, my lords, Order 21, Rule 35 specifically contemplates a case.
Come to the order.
Yes, my lord. My lords, the order is at page 24. Before the order, could I only show my application for a moment, my lords, to put it in perspective?
No, let's read that.
Yes, my lords, kindly have page 24. Page 24, AVR advocate filed, my lords, has that? Filed Vakalat for third party objector and filed IA number 1 under Order 21, Rule 97 of CPC. Objector has filed memo with the photos. That is me, my lords. Advocate for decree holder has filed IA number 2 under 21 Rule 35 seeking to break open the lock of the suit scheduled property and deliver possession. IA 3 filed by the advocate for the decree holder under 151. Peruse the report of the bailiff of the court. Now, my lord, just pausing here for a moment, the bailiff's report specifically says I am in possession and I am claiming a right under adverse possessions in 1988. Since the occupants of the premises violently objected for the delivery of possession and sought police help and sought permission to break open the lock, the judgment in OS number 6693 passed on so and so. As per the information of the decree holder, no appeal is pending, and even in the order sheet, office has not mentioned any cross entry. Hence, IA number 2 and 3 are allowed. Now, my lords, IA 2 and 3 allowed while issuing notice on my application.
Did you get the notice?
Here, my lords, issue delivery warrant with the help of police so and so, office to intimate Marathalli. Last line, my lords, call on 18/7 for objection on IA number 1.
How can it be?
My application is rendered infructuous.
Let the trial court be directed to consider that application with that observation.
In such time, we will, then what will happen to this order?
No, that can be kept in abeyance till disposal of the application.
My lord, the only reason
In
why
a time bound manner that can be.
That's the only
Because
reason
the
why-
decree is passed in the year 2021.
Yes.
My lords, may I only say the only reason why, my lords, this can't be kept in abeyance and has to be set aside is this. My lords, if my lords has Order 21 Rule 35, it specifically says it is only for a person who is bound by the decree. My lords, my case is I am an objector not bound by the decree.
The agreed with the order dated 15/6/2026, the petitioner who is the objector and filed I number one under Order 21 Rule 97, filed an IA under Order 21 Rule 97 is before this court. The respondent herein is the plaintiff in the suit. What is the suit for? Suit for specific performance that came to be decreed on 17/9/2021. Thereafter, the execution petition is filed and
In fact, it's the second execution petition, my lords, which is not maintainable.
No, first one was for executing the sale
No, we
deed.
are not going into
Well,
all
well,
that.
well,
Please,
Decree holder has filed I number 2 under Order 21 Rule 35 CPC, seeking to break open the lock of the suit scheduled property and deliver the possession of the property. And I number 3 is filed by the decree holder under section 151 CPC, seeking a direction to Marathalli police station for furnishing necessary police help. The court in the order impugned has observed that since the occupants of the premises violently objected for preliminary possession, the court has observed that peruse the report of the bailiff of the court. Since the occupants of the premises violently objected for delivery of possession and sought for police help and sought permission to break open the locks, the court observes that the judgment and decree is passed on 17/9/2021 and no appeal is filed against that, and accordingly delivery warrant was issued. the issued delivery warrant with the help of police, Marthali police station by break opening the lock. Land counsel appearing for the petitioner objector submits that the bailiff report also says that he is in possession of the property. The petitioner has filed when the petitioner has filed an application under Article 21 Rule 97, court has to, unless the said application is heard and orders are passed, when the bailiff report clearly discloses that the petitioner is in occupation of the property, the court ought not to have passed such an order. And the same is liable to be set aside, and there may be a direction to the court to hear the application of the petitioner filed under Article 21 Rule 97. Next, land counsel appearing for the caveator, respondent decree holder submits that
Let the trial court be disposed of their
submits
application.
that the time frame may be fixed to the trial court to consider the IA that's filed under Article 21 Rule 97. Next paragraph. Having other counsels on either side, peruse the material on record. As per the bailiff's report, when the objector is in possession of the property and he files an objection before the court, before issuing the delivery warrant, court ought to have passed the order on that application. But unfortunately, the delivery warrant was issued. And once the delivery warrant is issued and forcibly, the objector disposes from the property, that is not the purport of Order 21 Rule 97. In that view of the matter, this court is passing the following order. The order dated 15/6/2026 is set aside, and the writ petition is allowed. Number 2, the court shall consider the IA number 1 filed under Order 21 Rule 97 by the objector within a period of 4 weeks from the date of.
4 weeks may be a little difficult for this reason, my lords, because 101 will come into place. Evidence will
Has to be laid.
Shall consider the same as expeditiously as possible.
3 months.
3 months, fair enough.
Within a period of 3 months from
Grateful.
the receipt of the copy of the order, accordingly disposed of.
Grateful.
Pass over matters. List number 1, serial number 13.
Petitioner, my lords, Central Government Standing Council will take notice of both respond number 1 and 2, it seems, my lords.
What is the name?
Lords, M.N. Kumar, my lords.
M.N. Kumar is directed to take notice on behalf of respondent number
1 and
1 and 2. Print the name of Mr. M.N. Kumar. Petition, you have already served.
I have already
It
served.
is submitted that the petition has already served the copy of the writ petition. You shall get specific instructions. Let's this matter on 23rd.
Please.
On 23rd in list number 1.
Great.
Yes, next.
Serial number 44.
40.
4.
This is an order, my lords, where the decrees, judgment and decrees of the year 2005, execution petition is filed in Delhi in the year 2013.
When is the judgment and decree?
2005.
What is the suit for?
Lords, this was a suit for alleged violation of intellectual property rights. There was a compromise petition. Pursuant to the compromise petition, my lords, a compromise decree comes to be passed. In respect of that compromise decree, my lords, an execution petition comes to be filed before the Honorable Delhi High Court in the year 2013. It is then transferred to Karnataka in the year 2015. The execution petition, my lords, itself at annexure F discloses that the demands for money are allegedly for the years 2011 to 2016. They are not past dues. And my lords, ultimately in the order that is passed, there is no sum quantified. The order says, please pay whatever the
No,
dues.
let us see the compromise decree.
Please, my lords. The lordship may kindly turn to my lords. Annexure D, page 164. This is the compromise petition, my lords, that was filed by the parties. Ultimately, this is made part of the decree. The plaintiffs have represented that it is a duly registered copyright society under section 33 of the Copyright Act 1957. These words, your lordship may kindly note, my lords, one of the issues that fell for consideration before the executing court was whether the plaintiff continues to be a duly registered copyright society under section 33. And the defendants hence acknowledge that the plaintiff has the right to license for public performance, communication to the public of musical works under the duly approved tariff scheme as prescribed by the plaintiff from time to time. The defendants hereby acknowledge that the public performance, communication to the public of live music, recorded music by way of radio, CD players, jukeboxes and other mechanical devices, contrivances duly assigned by its author, composer, music publisher, requires the payment of license fee to the plaintiff society.
Paragraph number 7 of that.
Please notes. The defendant number 2 is further willing to pay an additional sum of rupees 1 lakh towards past license fees dues to the plaintiff in order to settle the current litigation. In consideration of the above payment of rupees 1 lakh, the plaintiff agrees that no past due shall be outstanding to the defendants. This is not in dispute. This is not what the execution petition is filed for. Ultimately, my lords, this honorable court will kindly see. Now, your lordship may kindly come to 8. The
Ultimately, what is the compromise?
Ultimately, my lords, the compromise is that going forward, I will obtain a license from them if I wish to play music in my stores. That is the compromise. The past dues are settled. Now, my lords, for the year 2011-12, my case is,
According to you, this compromise deed will speak about what you have to do in future, and it won't determine any of the damages or any of the amounts that are payable by the defendant to the plaintiff.
it is both, my lords. It settled some of the disputes that were present.
Are they?
Please, my lords, as your lordship kindly indicated, my lords, clause 7. For the past dues, a certain payment was prescribed. That payment, my lords, has been made. It is not under dispute today. In respect of future, at clause 8, the parties say that in future, your lordship may kindly see.
Even when you look at this clause 7,
Please,
it speaks about an additional sum of rupees 1 lakh towards past license fee due to the plaintiff. So that is only 1 lakh is due.
Only 1 lakh is due. That 1 lakh is not in dispute today. That 1 lakh has been paid. Clause 8 says, my lords, that going forward, you shall obtain license from me. That is, IPRS, the plaintiff there says, the defendant Coffee Day must obtain license from him. That is clause 8. Then, my lords, your lordship may kindly see para 11. In what circumstances I should obtain a license? So long as the plaintiff is a duly registered copyright society under 33 of the Copyright Act and is validly holding the rights assigned by its author, composer and music publisher members, and defendant undertakes to this honorable court henceforth not to question the validity of the rights held by the plaintiff or as such the rights translating to the plaintiff from the author, composer and music publisher members.
So no, better we go to the application that is filed for execution.
Please, the execution petition is at annexure F at page 172. Lords, it really begins, my lords, at 173. Your lordship may only kindly note the last date of decree 28/1/2005. Whether any appeal, my lords, not relevant. Whether any execution petition has been filed, yes, it was filed before the High Court of Delhi, then it was transferred to Bangalore. Then, my lords, the most startling fact at 174. Amounts due, if any. Your lordship may kindly see the term or the time period for which the amount is claimed. They are from the years 11-12 to 15-16, together with some alleged tax.
Decree was when?
2005. Therefore, my lords, my first submission, and which was, and with utmost respect, has not been considered. Lord, there are two things. One is not considering appropriately, the other is non-consideration. My case, my lords, before the Honorable Executing Court was, for a past debt, execution is a permissible method. But, my lords, for a alleged future liability where rights and obligations have arisen 6 years after the decree, it has to be by way of a suit. It cannot be by way of an execution petition. That, my lords, is not considered. That, my lords, is first. The second substantive issue, my lords, that I said was, this entire case or this entire claim is premised on the fact that I am said to be playing some music of which rights are said to belong to the decree holder. I have taken a written contention that I have not played any music. Now, my lords, any finding could be arrived at. The finding could be you have not. But, my lords, to not consider this issue, can I ever be said to say I must pay under a decree irrespective of whether I utilize their services or no? Question not gone into. Second question, my lords, not considered. The third question was, the compromise is premised on the basis that under section 33, IPRS or the decree holder continues to be a copyright society within the meaning of section 33 of the Copyright Act. My lords, it's a fact. I don't think they will contest it. They obtained re-registration of the copyright in the year 2017. Therefore, my lords, in 2012, the law gets amended. On this, my lords, the Honorable Court has considered, in my respectful submission, quite incorrectly so. That, my lords, is the third point. The fourth point, my lords, was that whether they have rights in respect of musical works or sound recordings. That was the fourth point. Now, my lords, in respect of these points, your lordship may kindly see why, on the first point as to why, respectfully, this is not a matter capable of execution but can only be settled by way of a suit. All the questions that fell for consideration here are not questions that fell for consideration before the High Court of Delhi and were therefore resolved. For instance, my lords, whether they are a registered society in the year 2012 could not have possibly fallen for consideration before the High Court of Delhi in the year 2005. And, my lords, this is, all of this comes because there is an amendment to the statute in the year 2012. Certainly something that could not have been within the contemplation. Your lordship may kindly see, my lord, section 33 of the Copyright Act. There is a 2012 amendment.
Lordship, the hearing it finally, my lord? No. Because if your lordship is hearing it finally, the entire record have to be there because evidence is led in the execution and there are witnesses who have testified. And their witness also has come, who is also admitted to sound recordings being played. All of those material is available to show, my lord, each of the contentions that my lord is urging.
This, what I'm not able to understand
Yes.
is, what is this order? Order impugn, please look at it, page number.
51, my lords, is where it begins. The operative portion, your lordship will please find at 89. Whatever is due shall be paid is the order.
Because that's the invoices that are placed before the court. Entire invoices are placed before the court. It's as simple as that. No, my lord, I'll tell you, lordship.
That's not the way a judicial order will be passed.
No, I understand.
And this is the executable order.
It is
So where from people will, from here and there, where is your invoice, what is happening? That's not the way we
No,
look
it
at
is filed in court.
Huh? No, you're filed, but when.
The invoices are in court and the invoices will not depict the entire amount of money. It's only a question of putting the figures together because the execution is not over.
That has to be quantified.
Execution is not yet over. The entire issue till now was on the question of entitlement. The court not has answered entitlement. Now it's only a question of looking at the invoices and quantifying the amount. The execution is not closed. That's what I'm pointing out. Execution will continue until
Is it, do you submit that this is the way an order will be passed in any case?
Not in any case. Not in any case. In this case, it is a slightly different scenario because of the objections raised. All the objections that
Why can't, if the court has come to the conclusion that he has to pay,
yes,
that also should have been determined.
Should be the next order, my lord. Should have been the next order.
It was fully litigated. It was fully litigated.
The next one, it says for compliance. Now, my lord.
For compliance of what? What should I pay?
So, you can't enforce this order as it is.
No,
That's
now I'm
what
going to
it
give
is.
the details. I'll go give the calculation to the court on the basis of which not the next step of attachment of the property will
That's
go on.
what, as of now.
As of now,
this order
on
is
this-
not an executable order.
No, this is an order in the execution. Respectfully, it's not executable in the sense that I don't have to file anything else. Unlike a decree, my lord, which is executable, this is an order in the execution holding, my lord, that I have an executable decree and therefore they are liable to pay as per the invoices. Now, the next step is I will go back to the court.
Where did the court at least use the word invoice?
My lord, please see, license fee is in terms of the invoices.
No, I'm looking at operative portion at age.
89, please see, judgment debtors are hereby directed to pay the license fee or royalty amount from 2011-12 till the period has remained unpaid to the decree holder with interest at the rate of 8%.
Lordship may see, my lords, how open-ended, till it is unpaid. Sorry.
Yes, sir, one second. Till its realization within a period of 3 months from date of the order, failing which decree holder is at liberty to take suitable action against judgment debtor in accordance with law. Now, my lord, what I have to do is, either they pay me. Now, because I'll tell you, lordship, what the problem is. Your lordship will see section 47 of the CPC. Any question which arises in the course of execution will be answered by the court as if it were a suit. And all issues, my lord, which are pending between the judgment debtor and the decree holder have to be answered under section 47, which is why under section 47 a trial is conducted. Obviously, my lord, only to determine as to how much is the entitlement. Now, your lordship is right that the court does not make a finding this is the exact amount of money, but that is the next step because it has answered all the questions in saying that you are entitled to the money. Now, my lord, the court will now examine as to what is the extent of money that is to be paid to me. Obviously, my lord, I can't ask for an attachment right now, but when they say for compliance, they will not comply, which is quite clear, my lord, they will not comply by making payment of the money. Therefore, the next order of the court will have to be that this is the amount of money that you must pay. And that is the next step in the execution. Because first the legal issue has been answered, that I am entitled to the money. After the legal question is answered, how much is the money, my lord, the executing court will make a determination.
So what was decided with that compromise decree?
My lord, the compromise did two things. One is, my lord, what happened was.
This is execution of that decree.
Yes, yes. We filed a suit in Delhi High Court. The suit in Delhi High Court, my lord, was for an injunction to restrain them from playing any songs without obtaining a license from us. Now, under the Copyright Act, there are copyright societies, and copyright societies have to be registered with the central government. And once they are registered with the central government, my lord, we are entitled to represent a particular class of copyright holders. In this case, we represent lyricists. So, lyricists, my lord, whoever writes a song, all songwriters come and form and become part of a copyright society. Therefore, whatever money I recover, it's like a cooperative. Whatever money I recover is distributed amongst all the lyricists. Therefore, my lord, the R.D. Burmans and all the lyricists, Ilayaraja, all of them have actually become members of this society, have signed an assignment agreement in favor of the society, owing to which the society becomes entitled to represent them. Therefore, my lord, wherever a song is being played, there is a certain amount of money which has to be paid as a license fee. Now, that license fee, my lord, year on year, we are required to put it on our website to indicate to everybody that this is the amount of money that we'll collect. Therefore, every hotel in Bangalore, my lord, which plays music, whether it is on a channel music or in the hotel, in the restaurant, take a license from us on a certain principle. In a 5-star hotel, it is on the number of beds. On the number of beds that they have, there is a license fee of, I think, 3 rupees or 4 rupees per month, which has to be paid. That money, my lord, is collected overall and distributed amongst all the lyricists. Therefore, the objective of this entire society is to ensure that people who have contributed to the making of a song stand to benefit by receiving money from time to time. That's the whole objective, and that is the basis on which, my lord, suits are filed in different places. Therefore, we filed a suit in Delhi because Cafe Coffee Day, my lord, was playing music as, I think my learned friend saying he's not playing is a different thing, but Cafe Coffee Day plays music everywhere. Therefore, we filed a suit. They acknowledged at that point in time that I will come to you, ask for a license, take a license from you, pay you the license fee, and then play. Therefore, it is not as if, my lord, nothing is available.
Where does the compromise?
Yes. Can I now request, my lord, look at the compromise petition? Please see page 164, my lord. Please see para 2 first. What is the statement that they've made? Page 164, para 2. Defendants hereby acknowledge that the public performance or communication to public of live music, recorded music by way of radios, CD players, jukeboxes, and other mechanical devices, whichever way a music is played, contravenes duly or contrivances duly assigned by its author, composer, and music publisher members, requires the payment of license fee to the plaintiff society. So, first acknowledgement is that they must pay me license fee. That's the first acknowledgement they made. Then, my lord, we said we did not want to fight on the past dues. There were a lot of dues that had accumulated. We said we will not fight on it. You give us a token amount of 1 lakh. We'll take that 1 lakh and forget what has happened in the past. We will fix as to what is to be done in the future. Therefore, the entire compromise was only to determine what is to be done in the future. Therefore, my lord, at para 8,
Para 4 may be seen, my lords. Other dues were also paid. It was entirely not for the future. It was really for the past.
all right, okay. 1 lakh and 2 lakhs they paid. Very good. Then, Lord, para 8. The defendant undertakes to this honorable court that in future, defendant shall pay the license fee to the plaintiff as per the plaintiff's tariff. That was the agreement. Therefore, my lord, I have to show two things. What is my tariff and whether I'm applying it to them. Therefore, so long as the tariff is available on a public forum, and that's how it is required to be published, that on the basis of the tariff, I send an invoice to them every year. I've sent an invoice to them every year. They did not make payment. As a matter of fact, from the date of the decree till 2010, they made payment. Every year they made payment for all their stores. Suddenly, my lord, they decided not to make payment. From 2011 onwards, they refused to make payment. Therefore, this is, my lord, what was the agreement between the parties, recorded and acknowledged by the Delhi High Court. And the Delhi High Court made it an order of the court because they gave an undertaking to the court.
The license fee shall be paid on this basis. The plaintiff agrees that on the defendants paying the license fee, they shall issue the license to the defendant.
Correct.
If they don't pay, you don't give the license.
I won't give the license, in which when they can't play. But the problem was, we found out.
That's a different cause of action. How can it be this execution of this decree?
It is, my lord. In every execution petition, if there is an issue which arises as to whether there is a future breach or not, it is a question to be answered by the executing court under section 47. And that is the whole purpose of conducting an inquiry under section 47 between a plaintiff and a defendant. Now, your lordship is not under order 21. There can be objectors, third party objectors who come. That is different.
You're saying that from several years they are not paying.
Yes.
No, if they are not paying, you have not given them, you shouldn't renew the license. You have renewed the license.
No, I have not renewed the license. But they're playing music in violation. That is the whole issue. My lord, the whole issue.
How was it determined by the court?
Well, that we've led evidence, and as a matter of fact, the witness who led evidence on their behalf admitted it. He admits to the fact that they're playing music through jukeboxes. And not only that, they took a position that I don't have to take your license, I can play music in the legal notice that they sent to us. A law firm, which sent a notice to us at that point in time specifically said, we will not take a license from you because according to us, we don't need a license anymore. We'll continue playing music, and they continue playing music. And that is what is determined under section 47. That determination, Lord, is what my learned friend is challenging before your lordships today.
Lord, my respect.
May I just read it? I
don't think that's a part of the evidence.
It is a part of the evidence.
It's a part of the execution.
I don't think it's exhibited, sir.
It is exhibited.
Yeah. Let my learned friend confirm the exhibit number.
He specifically says, this is a statement. Our client plays.
Sir, please give the exhibit number. It's not a part of the evidence.
I don't have it right now. Our client
Not a
plays-
part of the evidence.
Not there.
It's not marked in evidence. This is not right procedure. It's not on evidence. It's not marked. I did not get an opportunity to confront the witness with this document. It's not
mine.
It's not a part of the record.
It's your statement.
It's not a part
It's
of the court record.
It is part of the record.
It's not a part of the exhibited evidence.
Please read it.
Lords, any number of documents can be produced.
Please direct to call for the record. This is matter on 22nd of July.
Great.
Sorry, from which date? Sorry.
22nd.
22nd July.
July.
Lords, 27th is when I have to report compliance. Let them not precipitate matters on 27th of June.
What is there, as you say,
I have to give the
for-
details of
how
how
are
much
they
is the
going
amount.
to, how are
Right.
they
It's
going
a
to
calculate.
come?
The difficulty is they'll file applications for attachment. Both of us will seek adjournment. I am not,
An order needs to be passed on that.
I understand.
Come here.
I understand. Lords, I understand. We'll just seek adjournment on that day jointly. That's all I'm
I'll file
saying.
whatever I have to file. I'll not.
Lords,
attachment
that's not
order
fair.
won't be passed because first.
Your lordship is hearing the matter. Your lordship
What is
has called
unfair
for
about it?
records. I am only saying, my lords, let the matter be adjourned on 22nd to a date after 22nd of July. On 27th of June.
Then, Lord, in all fairness, they must deposit some amount of money.
Where is
It
the
can't be like
question?
this.
Where is the
Because one
question?
minute.
There is no quantification.
There may not be quantification, but the fact remains that you've not made a single payment from 2010 onwards.
Because, my lords, my case is I'm not playing music and there is not
There's
a
complete-
single piece of
No, I'm sorry,
evidence.
there is evidence. Please don't make that statement.
Sir, on 22nd of July till such time, the execution proceedings will not be precipitated.
Great.
But can I only make, at least submit the details of the calculations, my lord? When it says precipitated, it can't mean that they should not proceed at all. Maybe
The whole
order of
problem is-
attachment can't be passed.
Whole problem is the order, the manner in which it is passed. The court is not, it's not convinced. Yes.
Great.
List number 2. Orders matter. Number 1. Petition EA for petitioner.
Two, what is the number? Serial number? 1.
For the petitioner, Lords, you're supposed to take the PF as well for the different account.
WP of 2024, how long this will go on like this?
Lords, we'll take necessary steps.
The first time also, the connected matter, they have not paid PF for the first time.
We'll pay it
also.
here, tomorrow itself.
Interim order.
2 years.
Lords,
You have an interim order.
please, Your Lords.
I'll vacate the
No, Your
interim
Lords,
order, do
fix a
whatever you
date,
want
Your
to
Lords,
do.
fix a date, we will take the necessary steps and then fix
Why
a
have
date.
you not done it till now is the question.
Your Lords, the issue is that we're not able to figure out which address they are currently, we've already taken steps. Your
Why
Lords.
are they not represented before the trial court? Advocate is not there.
I mean, the last time we were supposed to take the
And all
notice.
the
Your Lords.
respondents, whoever are not served,
Please,
the petitioner shall take out hand summons on the counsel appearing to the respondent.
Please.
Shall file a memo, 1 minute, and shall file a memo to that effect by 29th of June.
Please.
Or else the stay granted by this court stands vacated.
Submission, my lordship. This respondent number 9 has come before this honorable court.
Why the parties are coming to the court?
Because, Your Honor, they are not at all serving. There are family members, my lordship. And also the persons who are dead.
They will serve in on the lower court counsel, let all parties do not come to the court like this. Yes.
Only the law enforcement finally declared stayed in proceedings.
Yes.
But in the lower court, on the submission that matter being adjourned, stayed in that David High Court.
The trial court can proceed with the matter, only the interim order is, no, as far as the final, the drawing of the final decree, as far as the executing court is directed to proceed with the other steps. Yes.
Please,
Till number 2.
Interim order earlier granted is extended.
please.
Till number 2.
My
All
lords,
these
praise,
matters, same order.
praise 2 days time, my lords, to take steps for respondent 10, 11, 12, my lords.
Memo for retirement, so we should accept this memo.
I've already filed Vakalat,
Who is
my lords.
Mr. Prasanna VR has filed the memo for retirement. Already, Archana Murthy has already filed the Vakalat. Memo is accepted and the petition and the council is permitted to retire. Then R10, R11, and 12, trial court. The petition shall take out hand summons on the council appearing for the respondent 10, 11, and 12, and shall file a memo to the by 1st of July, or else you have a stay.
Please,
The
my lords,
stay-
now have come on record, my lords. Now.
Look at it, if it is there is stay stands vacated, or else the writ petition stands dismissed
Much.
against those respondents.
Till
Yes.
number 3. Yes, Raj Prabhu.
Appearing for appellant, Your Lords. Respondent had moved the memo for
No memo is moved.
infractious
Three.
some
Furnishing of to so and so to issue notice to R6 to R10.
Yes.
You shall take out same hand summons on the council appearing with respondent 6 to 10. Interim order is there. And shall file a memo to that effect by 1st of July, or else the stay granted by this court stands vacated
Till number 4.
without further reference to the court.
Grateful.
Interim order earlier granted is extended. Yes, 4.
We have already taken process, but it's not sent from there.
No, it's
Your
easy.
lordship, I appear for the respondent number 3. We have received the petition copy today.
R4 and R5, take
Yes,
out hand
we have taken
hand summons.
yet to be sent from the court side.
No, instead of that, you take out hand summons on the council so that it's easy.
No, there is no standing council, my lord. That's why the.
What is this
difficult-
KEB
K-
matter?
No, this is, my lord. Yes,
Yes, I was under the
R4,
impression
my lord.
that CPC matter it is.
No, KB matter. KB, it is, my lord, Solar Power Development
List
Corporation.
after service of notice. Look at it, interim order,
Interim order.
interim order earlier granted is extended. 5,
5. Till number 5, Kiran B.
And for the petitioner, my lord, I've served the copy.
take that.
Instructed me to serve it on WhatsApp and communicated the same.
As per the orders passed for this court, it is submitted that the petitioner has taken out notice on the hand summons on the council appearing to the respondent and a memo is filed in that regard. An affidavit is filed in that regard.
I also seek dispensation of the respondent as the.
On respondent,
1, 2, 3. And the impugned order is only with respect to the documents. Impounding of the documents, Your Honor.
how many respondents are there? Look at
1
it.
to 3. And the
On
contesting,
On 1, 2, 3. You have done it through WhatsApp.
yeah, I telephone called him. He asked me to send it on WhatsApp. Accordingly, I've done it. And I have attached the screenshot as well.
And he has served the same on WhatsApp. When the petitioner has called the council, they are asking to send it through WhatsApp, and the same is petitioner has filed the call logs as well as the WhatsApp messages. Hence notice to so and so is insufficient. Yes. Dispensation to whom?
All the respondents, Your Honor, because the impugned order is only with respect to impounding the documents.
No, then their presence is not required because it is impounding the document.
Your Honors may hear me for 2 minutes, then, because the contesting party is only defendant number 1.
He is necessary or he is also not necessary?
He is also not necessary with respect to the impugned order.
It can't be like that.
2 minutes, my lord.
We'll see.
One, it's already multiple judgments are there with respect to this impugned order.
Some other day, not today.
Your Honor,
This is
trial court it is on Monday for final arguments, last chance. I have no other option. This petition would become infructuous.
What is it? Yes.
Your Honor, it's with respect to defendant number 1 who has filed 3 documents
There is order.
at page 14. Last second para, Your Honor. Last 2 paras, if I may be permitted to read. I filed an IA with respect to annexure E, F, G, and D. The documents are certified copies of lease deed and lease agreement and mutual agreements for 3 and 2 years for a valuation of 12 lakhs, 10 lakhs, and etc. Your Honor, at page 15, Your Honor, page 15, the judgment referred by the learned judge is with respect to Indian Stamp Act, and with respect to Karnataka Stamp Act, section 3 permits impounding certified copies as well as photocopies. So with respect to the same, I am furnishing certain citations.
Cumberland counsel for the petitioner. Submits that report relying on the provisions of the Indian Stamp Act. I said that the photocopy of the document cannot. The original unstamped documents can be impounded, but not a photocopy of the document. You submitted that, take the judgment, it is submitted to the court as way to notice the Karnataka Stamp Act. And he relies on the judgment of.
Kindly see page 40, Your Honor.
In case of Hariom Agarwal's Prakash and Malviya.
Your Honor, page 40.
Huh?
At page 40, the
Quoted in,
judgment referred by the learned judge, it is clearly stated that it is with respect to Indian Stamp Act and does not apply.
There are judgments of this court also. Where are they?
Yes, Your Honor.
Where are they?
From page coordinate bench.
Relying on the very same judgment which the court has relied on.
No, Your Honor, that is for the reference of this court, but with respect to the judgment of this honorable court in support of my application is at page 40,
Yes,
where
that-
it clearly
that's what I'm
states that the judgment referred by the.
The petition has relied on, not the judgment. He has relied on. Yes, Justice Shantan Gowda. I have also passed one order placing on this. He has relied on the order passed in WP number 6157 of 2013, dated 14th June 2015. Considering the same, they shall be stay of all further proceedings. Pursuant to the order dated so and so. Notice to the respondents, petition is permitted to take, already it's done, yes. They shall be stay of all further proceedings.
Your
This
Honor.
Matter on 4th of August.
One submission, Your Honor. I am not sought for stay because if I seek for stay, I am suffering the proceedings before the trial court. They are purposefully.
Heard, reserved. Yes, next.
Cell number 6. Cell number 6, R.P. Somshankar
I may be permitted to appear for the respondent in this case. The decree, judgment and decree passed in OS attains finality and nothing wrong in the order passed by the execution court, my lord. My learned friend, by suppressing all those facts before my lordships got the notice issued.
But in this case, my lord,
What is suppressed?
they not suppressed, the trial court, my lord,
Yes,
Disam
my-
court, my lord, confirmed the order of the trial court, my lord. But there is a direction to the respondent bank to public action the property, and the petitioner is permitted to participate in the public action, my lord. However, I have been continued in the possession of the property since from the year 2023 till date, my lord.
Where is the impugned order? Let us see.
Right,
Page number
include
61, my lord.
61. ಅದು ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಅಲ್ಲ ಇದು ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮೇಲೆ
Impugned order at page number 18, my lord.
1/8.
Yes, my lord. It starts from page number 18.
DHR by Rahul Agarwal, advocate is present, submitted that
Issued
JDR
a
not
warrant
vacated
to
the
hand over
premises.
portion of the EP property to the decree holder through special bailiff. What is wrong with this order?
My lord, I am not finding fault with them. My lord, only thing, I have been continued in possession. I have been continuously paying the rent. Even till date, my lord, no arrears of rent, my lord. Because since the petitioner has undergone heart surgery, my lord, for some period he was not able to pay the amount, my lord. In that view of the matter, my lord, they have filed execution. In the execution, my lord, we have cleared the entire amount, my lord. It is a public educational institution. If any orders are passed, my lord, number of students who are studying and prosecuting will be affected, my lord. Let them public action, my lord, till public actioning of the property, my lord, you may permit it to continue in the premises, my lord. If by chances get, my lord, preference has to be given. That is the order passed by the Sam court, my lord. No hardship will be caused to the respondent. If I continued, my lord, anyway, they are public actioning the property because it is a society, my lord. They have to public action the property for recovery of the amount, my lord. My lord, some enhancing some amount, my lord, if my land fund tax with the society and permit me to continue in the premises till public actioning. If I succeeded in the public action, my lord, I will continue it will be there, my lord. That is the only this thing.
No, my lord. I request my lordships to come to page number 61 for a moment, the decree and the confirmation order passed by this honorable court at page number 75, my lord. Firstly, I will go through page number 61. The suit filed by the plaintiff is hereby partly decreed with cost. The defendant is directed to vacate and hand over the vacant possession of the suitable property to the plaintiff within 90 days from the date of this order. This is the order at page number 61, my lord. Order was passed on 24th August 2022. And this order was challenged by the petitioner before this honorable court. The finding at page number 75, my lord. Para number 10. Shall I, my lord? The trial court has recorded the categorical finding at paragraph number 38 and 39 of the judgment that the respondent society has issued legal notice before filing of the suit for eviction, and it reveals that they have terminated the tenancy of the appellant, calling upon the appellant to vacate and hand over vacant portion of the suitable property. The said finding of the trial court is neither perverse nor contrary to the evidence on record, which does not call for any interference in this appeal. Next, my lord. Insofar as the contention of the learned counsel for the appellant that the appellant may be permitted to participate in the public action which would be conducted by the society, the said contention has already been considered by the learned single judge of this court while disposing of the writ petition in 27697 of 2009, wherein the direction has been issued to the respondent society to sell the property in question by way of public action And in the said action, the petitioner therein, who is the appellant herein, is permitted to participate. So it attains finality because of his possession. No, because of he is not running the college, because of his possession, we are not in a position to conduct the action sale. That is the problem. When it attains finality, in the year 2022, the trial court has said the vacate within 3 months. No, we are in 26 July.
Yes, Mr.
It's a public money in the society.
But since it is a public education institution, at least 2 years time to.
Yes,
Not even a single day, my lord.
Well, because
it
now
attains
it is under the middle of the education, this thing, my lord.
First request itself is too unreasonable.
Well,
Now you have crossed
well,
everything.
at least
The
1
High
year
Court-
time, because my
this
lord.
honorable court has passed an order in on first day of August 2023.
Lord, we have to take alternate accommodation for, even for shifting the education institution, my lord.
From the last 3 years.
My lord, we have been continued, they have allowed me to continue in the premises.
See, this is how
They're not allowing.
Now, my lord, no, my lord, in order to shift the institution, my lord, I have to take permission of the education department.
You
to
should have done it long back.
My lord, at least some breathable time.
What is a breathable time?
Well, at least because my lord, if I apply for education institution, I have to find alternate accommodation, and thereafter I have to submit
My lord,
application to the.
You let him submit.
I'm
Court
sorry.
is not passing any order.
I am sorry.
I have to submit application to the necessary education department. I have to obtain permission. Thereafter, I have to make arrangement to the students and to the staff and also to the infrastructure, my lord. It is a nursing institution, my lord. We have to provide everything, my lord. At least it will take some substantial time, my lord.
What is
There-
the
At least 1 year time, my lord. At least. At least, my lord. Otherwise, my lord, because it is a institution, big institution, my lord.
No. Please come. Agreed with her. Order passed. And where is that order? 18.
Some
huh?
reasonable time.
18 million.
No breathable time. You can't.
Reasonable.
can't.
As
That
your lordship feels,
That
my
is,
lord.
that is unfair, Mr.
My
Kaul.
lord,
We
reasonable time as your lordship feels, my lord.
10 days.
10 days, my lord, it is impossible to shift the institution, my lord.
1 year we
If,
can't
my lord, if
grant
it is
that.
a residential, my lord, it is because it is a education institution, my
that is
lord.
not the
No
problem of
hardship
the
will be
court.
caused to my lord.
Court has
I
given-
may permitted to some, my lord, let them enhance the rent. Enhance the rent and allowed me to shift the institution, my lord. Otherwise, my lord, it is a education institution will be put to.
I can understand.
Please,
if
my
you're-
lord.
If you're coming up before the court first time, then the court would have at least
My
considered
lord,
your
now
request.
there also.
There are so many orders from the year 2023
My
of
lord,
this court.
my lord, since we are paying continuously rent, my lord, they
That's
have
not
also
the-
not
that is
disturbed me, my lord.
Agreed with the order dated 22 4.
My lord, some reasonable, I leave to your lordship, my lord, some reasonable time
To
may
direct
be.
the court has issued the delivery warrant directing the JDR to vacate and hand over the vacant portion of the petition scheduled property. The JDR is before this court. Then counsel appearing for the petition submits that the petition is running what is that, nursing institute, nursing college, and if the petitioner even to shift the premises, the petitioner has to go through several formalities, and hence a reasonable time may be granted. It is submitted that the petition is even ready to pay the enhanced rent, and there is no basis for the respondents to vacate the petitioner from the said premises. Land counsel appearing for the respondent submits that all the proceedings in respect have attained finality, and way back in the year 2023, when the writ petition is filed by him, the same came to be dismissed by a coordinate bench of this court, a division bench of this court. It is submitted that they want to put the property to auction, as petitioner is in occupation of the property. They are not in a position to put the property to auction and enjoy the fruits of the decree. The petitioner is not entitled for any the order impugned do not require any interference at the hands of this court, as the court has passed the order pursuant to the judgment and decree which has attained finality, and there is no illegality with the order. Anytime.
No, my lord. No, my lord. Absolutely not. Because this honorable court itself refused to grant in the year 2023 when the commercial appeal was disposed of or dismissed.
Having heard the counsels on either side, there is a material on record. The judgment and decree has attained finality, and right from the year the earlier he has come before the court in the year 2023, and from 2023 till 2026, still the petition is continuing in possession. In those circumstances, this court cannot consider the request of the petitioner, and this court cannot interfere with the order impugned, as there is no illegality with the said order. And even after the judgment and decree, petitioner has had the breathing time and enjoyed the and has continued to live in the said property from the last several years. In those circumstances, this court do not find any reasons to interfere. Accordingly dismissed.
Some reason, at
Grateful,
least
my
at least 6 months time to vacate, my lord.
Grateful.
Some reasonable time, my lord. Otherwise, my lord, they will immediately take steps to evict me with police help, my lord. It is an education institution.
Reasonable 6 months, 1 year, it will not happen.
My lord, at least 6 months, my lord. I will find a alternate way, my lord. Because to shift the institution, my lord, it is not not even a residence, my lord. Therefore, my lord. Otherwise, it will affect the institution, my lord. Moreover, the students, my lord, particularly who are prosecuting their studies, my lord.
If you're really interested in their welfare, you would have done it long back.
But since they have not disturbed, they have allowed me to continue in possession, my lord.
Yes, next. What is that? KMs. Yes.
Serial number 7 and 8 again. Serial number 9.
Your Lordship, serial number 8.
My lord,
Adjourned.
Your Lordship,
matter was moved
we
yes-
have moved the matter and we had not consented for the adjournment, Your Lordship.
That it is listed along with that in list number 1, serial number 57, ma'am.
My lords, may I make a submission?
Because
And for
all
the
are
regulatory
connected.
authority in list 2 CL number 8, the challenge in this matter is with respect to the 2014 regulations, 2022 regulations that I have framed. In list 1 CL number 59, it is with respect to the 2024 regulations. They're not connected at all. They're completely separate
That
regulations.
submission made in the morning.
Please.
Anyhow, that day when it is listed, we will hear it.
Your
My
Lordship,
learned friend
there
has
is-
also moved a vacating application. So there is.
Your Lordship, there
When is
is
it coming?
24th month.
You filed a vacate petition.
Please, Your
Petition has
Lordship.
been filed by learned
List
friend.
it on 3rd of August.
3rd of August.
Please.
Completely.
All the matters, all the.
Please, my lords.
Serial number 9.
And for the petition,
For the
yes, yes,
respondent,
Madam.
Madam
Unless the matter has been moved yesterday, no information was given to us. We have engaged in senior counsel, my lord. There's some inconvenience.
Require,
No,
the
my lord.
list will, the matter will come in the list.
Please, I agree, my lord. There is some inconvenience with the senior counsel, my lord. We have engaged in senior counsel. Any date in the next week, my lord, we are ready to argue, my lord.
That's why stop engaging senior counsels and argue the matter. Because they have the urgency, you should
Yes.
argue the matter.
No, we are the
And now
plaintiffs in the
once-
matter.
Once I adjourn this matter will not come in the list, and every day he'll come and make a mention.
No, my
You
lord,
have to understand the difficulty of the court also.
my apologies.
24 matter, you're enjoying the stay.
There's a stay which is
In a
operating.
writ petition,
My lord, in this,
pending.
Notice of
my lord,
2012,
we
my
have
lords.
challenged the application.
Notice of 2012, my lords.
This matter on the top of the list on Monday? Yes,
Interim order may be extended.
interim order. And that day I have not even grant passover.
Please.
Serial number 10. Serial number 10.
Then I except for the respondent number 1 to 4.
But appear for the
Lord, I filed
Petitioners.
application, my lord, to release the, my lord, rent amount deposited with the, my lord, garnishee before, my lord, trial court. In fact, my lord, there is a decree from the, my lord, commercial court in my favor, directing the, my lord, petitioner herein to deposit 65
What
lakh.
is this writ petition about?
My lord, in the commercial,
May I make submission? Lord, the writ petition is, my lord, by a garnishee, my lords, challenging the order, Lord, of directing, an order of the trial, executing court, directing him to pay the amount, deposit the amount of rupees 75,000 per month, and also, my lord, on failure, my lord, issuing arrest warrant. And an application for recall the said order came to be filed, which came to be rejected on the ground that the agreement of rent is unregistered. But once the rent agreement is unregistered, my lords, the court cannot rely upon the said agreement.
Fine.
And I am no way liable to pay the amount.
Lord, as a matter of fact, Lord, the respondent number, Lord, the predecessor of the respondent number 1 to 4, Lord, secured a decree against respondent number 5. Lord, there is an agreement of, Lord, lease in my favor from the respondent number 5. Under the said agreement, Lords, there is a specific clause number 4 and 5. Lords, may kindly.
We'll go to the impugned order first.
Please.
Then we will hear the matter.
Please. May I read, my lords?
Page 31.
32, my lords, your lords may kindly see para number 5.
Yes.
May I read, my lords? At the time of hearing, both the councils have contended to substantiate their positions. Accordingly, applicant claims to be third party to the proceedings and contended that alleged garnishee is not a garnishee in strict sense of the term, because garnishee is a person who is under obligation to pay the amount to judgment debtor. But as per the agreement held by the applicant, the amount payable is not to the judgment debtor, but to third party. As such, applicant IA number 2 and 8 cannot be garnishee with the meaning of said term. For the said purpose, applicant relies upon the lease agreement dated 15/3/2021. This agreement, my lord, was executed prior to institution of the suit. Said copy of the rent agreement is produced with the list of documents dated 23/3/2023. Said rent
We'll hear
agreement
this
is.
on Monday. This is matter on Monday.
Please.
All the matters, you can ask the court officer, dates will be given as per the board.
Serial number
Plus
20.
one submission. The matter before the trial court, my lords, has posted on 23rd.
That also you can tell the court officer a day before it will be given.
Lordship,
As
my
per the board, you just adjust the
serial
matter.
number 20, Lordship, 230, Lordship, seniors.
Serial number 10 ಏನಪ್ಪ ಪ್ರಸನ್ನ VR Monday
Monday.
Serial number 11
Madam, Monday, my lord. Monday. Now filed application for vacating is there.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಮಂಡೆ ಆಲ್ರೆಡಿ 40 ಮ್ಯಾಟ್ರ್ ಇದೆ. ನಾವು ಕೊಡ್ತೀವಿ ಸರ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ನಿಮ್ಗೆ.
ಯಾವತ್ತು?
ಬಟ್ ಮಂಡೆಗೆ ಆಲ್ರೆಡಿ 40 ಮ್ಯಾಟ್ರ್ ಡೇಟ್ ಗಿವನ್ ಇದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಹೇಳಿ.
11 ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ? 11 ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ?
11 ಗೆ 25th ತಗೊಂಡ್ಬಿಡಿ ಸರ್.
ಅಷ್ಟು ಲಾಂಗ್ ಡೇಟ್ ಬೇಡ.
ಅಲ್ಲ 20 ಅದೇ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಏನಾಯ್ತು ಮೇಡಮ್?
25 ಓಕೆ.
ಎಲ್ಲ ನಂಬರ್ ಕರೀತಾರೆ.
ಬರ್ಕೊಳ್ಳಿ 11 ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 12.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 29.
ಸೀರಿಯಲ್ ನಂಬರ್ 12.
ಮೇಡಮ್ 25th ಕೊಡಿ ಮೇಡಮ್. 25th.
ವೆಂಕಟ ಪುರುಷೋತ್ತಮ್.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಡೇಟ್ ಫುಲ್ ಬೋರ್ಡ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನಿಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಅದು ನೋಡಿ ಅಪ್ ಟು
29. ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಮೇಡಮ್ ಹೇಳಿ ಮೇಡಮ್.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 12 25th ಕೊಡಿ ಮೇಡಮ್.
ಕೇಸ್ ಕರೀತಾವ್ರೆ.
ಆಲ್ರೆಡಿ
ಕೇಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಪ್ರಕಾರ ಕರೀತಾರೆ ಅವಾಗ ಹೇಳಿ ಸರ್.
13 ಹೇಳಿ. ಯಾವತ್ತು? ಜುಲೈಯಲ್ಲಿ ಕೊಡೋದಾ?
30th ಕೊಡಿ. 30th.
ಜುಲೈಯಲ್ಲಿ 6th of July ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 12 25th ಕೊಡಿ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 14.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಸೀರಿಯಲ್ ವೈಸ್ ಕರೀತಾ ಇದ್ದೀನಿ ತಾನೇ. ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲಾ ಡೇಟ್ಸ್ ವೇರಿಯೇಷನ್ ಆಗುತ್ತೆ. ಸ್ವಲ್ಪ ಪೇಷಂಟ್ ಆಗಿ ಇಯರ್ ಮಾಡಿ. ನಿಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಬಂದಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಆಗ್ಲಿ 25 ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 14.
14 ಮೇಡಮ್. ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ?
14 ಸರ್ ಅದನ್ನು 6 7 ಸ್ಟಾರ್ಟ್ ಡೇಟ್ ಎಲ್ಲ ಇಲ್ಲ ಸರ್. ನೀವು ತಗೊಂಡ್ರೆ ಕಾಯ್ಬೇಕು ಅಷ್ಟೇ. ನಿಮ್ ರಿಸ್ಕ್ ಬೇಕಾದ್ರೆ ಕೊಡಿ ಅಂದ್ರೆ ಕೊಡ್ತೀನಿ, ನನ್ಗೇನಿಲ್ಲ. 6th ಆದ್ರೆ ಅವತ್ತು ಕಡಿಮೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಅವಾಗ ಬೋರ್ಡ್ಗೆ ಯು ಕ್ಯಾನ್ ಟೇಕ್ ಎ ಚಾನ್ಸ್ ಅಷ್ಟೇ. ಅದೇ ಗೊತ್ತಾಯ್ತು. ಯಾವತ್ತಿಗಿದೆ? ಎಲ್ಲಿಗೆ?
ಏನು ಕೇಳಿಸ್ತಾನೆ ಇಲ್ಲ ಅವನು.
Serial number 29. ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೀರಾ ಅನ್ಸುತ್ತೆ ಮೇಡಮ್.
ಅವ್ರು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದಾರ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ ಇವ್ರೆ ಎಲ್ಲ 40-50 ಮ್ಯಾಟ್ರ್. 6 ಡೇ ತಗೋಬೇಕು ನೀವು. 6, 7, 19. ಅದು 6
ಕಟ್ಬೇಕು ಅಂತ ದುಡ್ಡು ಹೇಳಿದ್ದೆ.
ಸರ್ ಅದಿಲ್ಲ ಅಂತಂದ್ರೆ 13 ಕೊಡ್ತೀನಿ. 16 20
ನಮ್ದು ಮೇಡಮ್ ಇದು 2013 ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಅಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ ಇಲ್ಲಿ. 30 36 21 ಇಲ್ಲ ಇಲ್ವಾ ಸರ್? 13 7 22nd party in person ವಸಂತ್ 30th ರೀಚ್ ಆಗಲ್ಲ ಸರ್. 6 7 ತಗೊಳ್ಳಿ. 6 7 23 6ನೇ ತಾರೀಕು 6 7 ಸೇಲ್ ನಂಬರ್ 23. 23rd 4th ಡೇಟ್ ಇಲ್ಲ ಸರ್. ಎಲ್ಲ ನೋಡಿ ಎಲ್ಲ ಡೇಟ್ ಇಲ್ಲ ನೋಡಿದ್ಯಪ್ಪ. 40 ಮ್ಯಾಟ್ರ್ ಆಲ್ರೆಡಿ ಇದೆ. ರೀಚ್ ಆಗಲ್ಲ ನಿಮ್ಗೆ. 6 7 ತಗೊಳ್ಳಿ. 6 7 ಅಲ್ಲಿ ಕಡಿಮೆ ಇದೆ. ಅವತ್ತು ವಿತಿನ್ 40 ಒಳಗಡೆ ಬರುತ್ತೆ. 23rd 6 7 24 8 ಆಗಲ್ಲ ಸರ್. 9 7 25 ಯಾರು ಇಲ್ವಾ? ಅದು 13 7 ಸಾಕು. 26 ನೀವೇನಾ? 13 7 27
ಶಾರ್ಟ್ ಡೇಟ್
9 7 6 7 ಸೇಲ್ ನಂಬರ್ 28.
ಪೆಟಿಷನರ್ ಮೇಡಮ್. ಪೆಟಿಷನರ್
ಪ್ರದೀಪ್ ಕುಮಾರ್.
ಹೌದು.
9 7 29
ಪೆಟಿಷನರ್ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ ಇದೆ.
Shorter date ಮೇಲೆ
6th July. ಸೇಲ್ ನಂಬರ್ 30 14 7 ಸರ್. 31 14 7 ಫೈನಲ್ ಇಯರಿಂಗ್ ಎಲ್ಲ 14 7 14 7 ಇವ್ರೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ಲಿ ಇದೆ. ಅದು ರೀಚ್ ಆಗೋದಿಲ್ಲ. ಆಲ್ರೆಡಿ 40-50 ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಆನ್ ಬೋರ್ಡ್. ಮತ್ತೆ ಹೋಗುತ್ತೀನಿ. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ ನಾವು. ಅದೇ ಕರೆಕ್ಟ್. ಅದು 14 7 ಇವ್ರೆ. ನೀವು ಹೇಳೋವರೆಗೂ ನೋಡಿ ಇವ್ರೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಬೋರ್ಡ್ ಯು ಅಕಾಮಡೇಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಓನ್ಲಿ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಅವ್ರಿಗೆ ಏನಾದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಇದೆ ಅಂದ್ರೆ ಅಷ್ಟೇನೆ ನಾವು 6 ಇಲ್ಲ ನನ್ ಇಲ್ಲ ಇವ್ರೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ನಾವು ಆಪ್ಷನ್ಸ್ ಕೊಡೋದಿಲ್ಲ ಇವ್ರೆ. ಪೆಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ಇರ್ಬೇಕು. ನೀವು ಯಾವಾಗ ಬೇಕು ಅವಾಗ ತಗೊಂಡ್ ಹೋಗ್ಬಿಟ್ಟದಲ್ಲ. 14 7 ನಮ್ಗೆ ಅಷ್ಟೆಲ್ಲ ಲಾಂಗ್ ಡೇಟ್ಸ್ ಎಲ್ಲ ಕೊಡೋದು ಅರ್ಥ ಕೊಡಕ್ಕಾಗಲ್ಲ. 32 ಸರ್ 32 ಸರ್ ಬುಧವಾರ ಇದೆಯಾ ನಿಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? 23 6 33 ಇಮ್ರಾನ್ ಪಾಷಾ 6 7 34 ರಾಜಾದಿತ್ಯ ಲೇಟ್ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ. ಅವ್ನಿಗಂದ್ರೆ 15 7 ತಗೊಳ್ಳಿ ಸರ್. 15 7 ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಬೇಕಾ? August 3rd. ಅಲ್ಲ 4/8 3/8 ಡೇಟ್ ನಮ್ಮ ಮೇಡಮ್ 4/8 ಇದು ಬರ ಡೇಟ್ ಹೇಳ ಸ್ಟಾಪ್ ಆಯ್ತಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ ನಂಬರ್ 2 9 ಆರ್ಡರ್ ಆಗಿದೆ 10 ಆರ್ಡರ್ ಆಗಿದೆ 11ರಿಂದ ಹೇಳಿ 11
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಮೇಡಮ್
13 ಸರ್
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 12
6 7 ಆಮೇಲೆ
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಮೇಡಮ್ ಡೇಟು? ಹೌದು ಸರ್
25/6
ಥ್ಯಾಂಕ್ ಯು ಸರ್
17/6/7 18/6/7
6/7 ಇದೆ ಆಮೇಲೆ
16/7
ಯಾವುದು ಅವರು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೆಮೊ ಮೂವ್ ಮಾಡಿರೋದು ಯಾರು ಅದಕ್ಕೆ CH ಮೂಡ್ ಅದೆಲ್ಲ ನಾವು ನೋಡ್ಕೊಂಡು ಕೊಡ್ಬೇಕು ನೀವ್ ಹೇಳ್ದಂಗೆ ಕೊಡಕ್ಕಾಗಲ್ಲ ಸೇಲ್ ನಂಬರ್ 19
16/7 20 36 21 13/7 22/6/7 23/6/7 24/9/7 25/13/7 26/13/7 25/13/7 26/13/7 27/6/7 6/7 28/9/7 29/6/7 30/14/7 31/14/7 32 23/6 33/6/7 34/4/8 ಆಗಿದೆ
ಇದನ್ನ ತಗೊಳಕ್ಕೆ ಏನು
ಸರ್ ಫೈಲ್
ಕೆಳಗಡೆ ಬರ್ತಿದ್ದೀನಿ ನೋಡ್ಕೊಂಡು
ಅಲ್ಲ ಅವರು ಮೇಡಮ್ ಕೇಳಿ ಅದೃಷ್ಟ